Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
This is the next search on February 28, 2020, 7:44 p.m. How, does the FBI find people, and people's misspelled P-E-O-O-P-L-E? Did the defendant find out how the FBI finds people in this case? Oh, she found out.
Good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. Thank you very much for joining us this morning. This is the morning to join us. Of all mornings, it's going to be absolutely crazy today. From the get-go, we have a little bit of an extra time for a head start, just so everyone can come in, find their way here, and not miss a moment.
Are we going to address subject matter jurisdiction?
We should probably address subject matter jurisdiction. Let me turn the music down just a little bit so we can hear each other. Oh my goodness. Lots of things happened early this morning, and I missed them, and I apologize. But let me try to get as much as I can. Colorado Mountain Girl, welcome to the gallery. Look at that green courthouse. Thank you so much for your support. Huntley Hashigan, welcome to the gallery. Brand new member there. Thank you very much for joining us, Huntley. Appreciate you supporting us as well. Love Disney Magic. Janine says, thank you, Recovery Addict, for following this trial from the beginning. Your coverage of this trial has been truly amazing. Also, I love Jules. You are not alone. Jules is absolutely incredible. Thank you very much, Janine, for the super chat and kicking things off this morning. Regina Crawford says, one of my favorite places to be, 3 months. 3 months, Regina. It's been wonderful. Thank you so much. It would not be the same without you as well. Appreciate you being here. We also have one big thing we cannot miss. We can't miss it all. Oh, it would help if I put this stuff on the screen. Hold on just 1 second.
I was taking it easy.
Let's try that again. I missed the first one. It's gone already. Huntley, I got you there. Thank you very much. Love Disney Magic. I put it up on my screen, but it wasn't on your screen. Sorry about that. Thank you for the super chat. We have a Regina Crawford, one of the favorite places to be. Now the messages are flooding in. Sandy Raskin, love this group of people. Thank you, Sandy. Thank you. Terry Wright, welcome to the gallery. Brand new member there as well as...
Because he's the guy.
Greeners, amazing supporter and document hound extraordinaire, I might add. Greeners gifted a membership first thing this morning as well. Thank you very much for that. Brianne Malcolm, 7 months, most spicy Monday ever. Yes, if you have to call in sick, do it. Today's the day to not miss this live stream. The Maya case is incredible. And now if we go back, almost, hang on. Mary Weipert gifted one membership. Thank you. Oh, look at this. 6-volt bus with a huge 10 months of support. I say that's huge because that's as long as we have been able to take support. 6-volt bus has been here from the get-go. 10 is Zen, 11 will be heaven. After that, I'll just delve into 12. Thank you, 6-volt bus, for that. And another one of our fantastic mods. Thank you, my friend, for all you do for the channel. Okay, let me properly properly worship and recognize Kim R, who this morning was first in chat, came in right off the bat and had good things to say. She said hi, and that's all it took, being first in chat. The first person in chat every day is awarded the internet or penalized, depending on how you view it. Kim, you have won before. You are a repeat offender. We call you a habitual offender when it comes to this offense. As always, this one as well will go on your permanent record. Thank you, though, Kim, for being first in chat. As a punishment, we are awarding you the internet and assigning you with the light duty, the small workload of maintaining everything IP-related worldwide. So just prepare for that. Remember, today's an important day. No mess ups, but I know you're capable. So thank you very much, Kim. Good to have you here. Mandy B, welcome to the gallery, new member as well. Kidda Smith says, hi, Recovery. It's always good to see you. You're my favorite. Thank you for the kind words, Kidda. And Princess Buttercup's here, gifted a membership this morning. Good morning, Princess Buttercup. Good to have you as well. Let me say, before we get carried away in what's going to happen today, which is going to be amazing, I just want to say a huge shout out and thank you to all those of our community who I saw over on Ian Ruckles' stream over the weekend. Rob, Ian, Kurt, Pixie, let's see who else was there. Nick, Hoglaw was there. We've got Joe. We had a whole bunch of amazing people from YouTube that were contributing time and effort. I just got to go along for a free ride for a little bit and see some of the amazingness. And a lot of you who have been following YouTube for a long time know that this community that is sort of I think Rob's their leader.
Is that correct?
It is absolutely phenomenal. The amount of good they do when they recognize a need somewhere and are able to marshal the forces and bring about good is incredible. I just checked this morning. I think Ian's total is up to like $107,000 they've raised. All part of that Children's Miracle Network program. That it is just really cool. So thank you to all those who contributed. We have birthdays this morning, I'm sure. But let's see, what is it? Buffer. Lavender daughter's Selena's 15th birthday. Selena, happy birthday. We do. I realize there's like 3,000 people in here, and I apologize to those who came here waiting for trial. It hasn't started yet. We're waiting as well for trial. We celebrate birthdays every day, and I would say I sing to them, but we sing together. It's actually a group thing. You are expected, and it's actually required to sing along. I won't make you mic up and call in on the phone and everything that way, but we do want you to sing along as we celebrate birthdays. But before we sing, is there anyone else other than Selena, who was a big 15th birthday? That is awesome. Other than Selena, that we need to celebrate as their special day today. Let's see. With about 3,000 people, I think we might have a few other birthdays. Mods, if you can help me. Rhapsody in Blue, we missed you last week. Oh, no. Rhapsody, hope you had a fantastic birthday. Denise Feldman Ersland, it's going to be spicy today. Happy Monday. RA, and these mods are absolutely best. Here's to many more months and years to come. Thank you, Denise. Pauline as well. I'm happy to be a member of the group. And Scott is the best. The community is the best, and I get a free ride and a lift from you guys. Thank you so much. Suzanne says, good morning, everyone. Buckle up because today's going to be very spicy, gentle to all. Suzanne, thanks for bringing this up. If you're here for the first time, we like to do things a little bit differently here. First of all, just know that everyone here is friends.
I'm not a cat.
We're all here for the same reason, and that's because we love the law, we love true crime, we love following court cases, and we love watching it with other people. That's what brings us together, and understand that's our basis. And there are a million ways you could divide us into groups and separate us by beliefs, by unbeliefs, you name it. Political ideations. There are a million ways to draw us apart. We try not to focus on those here. We try to focus on the fact that we're all friends, and we can disagree. We can agree to disagree. If you came looking for a place to fight, to really get down and throw some punches and land some good ones, you found the wrong room. That's not what we do here. We'd encourage everyone that if you do have an opinion that differs, even from the majority, please do share it. Just do it in a respectful way. And that way we can all listen. And even if we don't agree, we can say, hey, thanks for sharing. I feel differently because of this. If you find somebody that you just get, loggerheads with, that you just don't agree with, we'd ask that you take that maybe to another format to discuss it. It gets really,
that was terrible. I apologize.
Especially when we're busy today, it gets really hard for everyone else to enjoy the stream if somebody's having a little argument with one other person. So please don't make my mods work overtime trying to support everything and keep it clean. Suzanne, thank you very much for that. Recover Out Loud. I'm the former Selena K. Oh, all right. I recognize the picture, but the name has changed. Recover Out Loud. Thank you very much.
Don't miss the forest for the trees.
And Nancy says, I love you all. Thank you. I love all of you. Okay, so we're going to do birthday really quickly because we have to be ready for court.
That is not relevant.
So as far as the birthdays, mods, if you can watch Hippo Lover, I so love being here. You rock. And Jules too. Over 100,000 on Ian fundraiser. Yeah, I think it's 107 this morning. It was wonderful. Rob sent me a little note. He said, hey, do you want me to ask Ian if he can come on? I said, I don't want to impose, but I would love to be part of this. I've seen what happened last year. And it was amazing to spend a few minutes with just some of the best people on YouTube, really. All right. Do we have any other birthdays? Yes. Jujubee is a birthday. I need like one comment that has all the birthdays in it because chat's going really, really fast. I don't know why.
Squirrel.
Don't know why it's going fast. I'm looking for birthdays. We might just have to sing happy birthday to everybody. The longer I wait, the more birthdays there are going to be. Lady Bird, congrats on the yellow courthouse. That is awesome. I'm so excited for court today. I'm so excited. It's going to be great. It's supposed to start at 8:30, so we have about 18 minutes or so before it starts. We have plenty of time. Okay, this is what we're gonna sing to Jujubee and Selena, and I realize that we're probably going to miss a couple others. Just know that in our hearts, and Paul as well. Can we do that? For Kirian's brother, Paul. Here we go. Everyone, warm up. La 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 la. Sounds great. Here we go. Happy birthday to you. Happy birthday to you. Happy birthday, Jujubee, Selena, and Paul. Happy birthday to you. All right, to everyone who's celebrating, even if you're not Jujubee, Selena, and Paul, happy birthday. I hope you have a wonderful day. This is your special day, and the fact that you are here with us celebrating on this special occasion is our privilege, honor, and pleasure. Thank you very much. Hopefully we can make this day a little bit better. I realize there are a million places you could be. There are a million places that will recognize you for making another trip around the sun. I got it right this time. I didn't say Earth. And some of them even give me free pancakes like Denny's. But here you are with us. Thank you so much. I hope we can make your day just a little bit better. All right. Let's talk as we have all the festivities out of the way. Let's talk a little bit about what is coming up in the trial. First of all, I need to get a couple things set up with our objections. We have been running an objection counter. We had a guess, and I realize a lot of you may have missed the opportunity to enter this, but we are tracking the number of objections that we can hear through the court process. There are some that we haven't heard and we haven't been able to track, so we realize this number is low. But we are tracking that today, and let me just see, box 2 will be 4. Let's go here. So our objections count is right here. We're at 1,728. We're going to keep counting those up till the end of closing statements today. So I imagine we're going to get a few more here today. There are a lot of people who guessed a significant number in the U.S. history. They're saying it started at 8:15. Starting at 8:15. Let's see. There's a lot of you that. There we go. It's no feed from courtroom yet, so we have audio turned on. As soon as audio comes in, we'll get it. Anyway, there's a significant number in U.S. history, and that is 1776, and a lot of people guessed that, and that's looking like it might be in the range today. It might be in the range. We pick up another 50 or so objections, and then basically the person who's closest or the group of people that are closest get entered into a random drawing, and one of them is going to win a hoodie. So that we're going to be giving away a hoodie today for to celebrate whoever got the closest. I think I have to word it that it's not actually a contest and a prize, but I'm not taking calls on the burner phone right now just because there's a lot to go over this morning, and I get distracted really easy by squirrels and things like that. We'll turn the sound effects down that you guys are triggering as soon as court starts. But that's it. Here's where we are. Let me tell you what's going to happen today that we are expecting. First off, as court begins today, the jury is not going to start. The jury won't be there to begin with, right? The jury is going to be out for a little bit. They're not going to come in, I think, till 9 o'clock. But first thing, the lawyers are going to be there. The judge is going to be there, and he's going to say, look, we've got one issue we need to resolve first, and that is this IJ matter. What is the IJ matter? The IJ matter is an immediate jeopardy finding, or an alleged immediate jeopardy finding that was brought up in, and they've pursued this. The plaintiffs have pursued this information for years. For years. This isn't just explode in court and suddenly there's this new information. But there's a joint commission. Let's see. Watching from mom's hospital bedside, overheard in the nurse meeting that the joint commission may be here today. Now that's relevant, says Jen. Yes. Basically, hospitals have to get accreditation, and I believe what I've heard over the weekend, because I talked to a lot of you that sent me information just from your perspectives of working in Florida, working in the hospital system. this accreditation is sort of mandatory to be able to be eligible to receive funding through Medicaid and things like that. So it's a big deal for hospitals. It's like a health inspection for a restaurant, but obviously it's in the medical field. So these inspections can happen a couple different ways. They can be triggered by a complaint. They can be triggered by a self-report. They can be random and just appear. But there's how this started is going to be sort of relevant, but how it ended up, I think, will be more relevant. And if this inspection ends up showing a systemic, widespread problem, there's a good chance the jury's going to hear something about this. So the judge is going to find out what happened over the weekend. And what happened, do we know of? Well, on Friday, there was a deposition where a hospital executive was required to be present. It started at like 4 p.m. on Friday. It probably went till late in the evening. And to answer questions from the plaintiff about this finding. And they were required, the judge gave a broad, sweeping order saying anything, and his words were, that had a scintilla of odor to do with this IJ finding or any investigation or a governing body or agency needs to be turned over to the plaintiff. And so all these documents are supposed to be turned over to the plaintiff. Then this deposition is supposed to happen. And realize this deposition is basically the same. It's a repeat of a deposition that happened a week or two ago where the plaintiff tried to depot a hospital employee, and Mr. Shapiro shut it down. He issued a protective order in the middle of the deposition and said, stop, no more questions. And it was when we were approaching this subject. And so now it's exploded. It's been huge. This has the potential, obviously, for appeal written all over it because it is extremely prejudicial. But the judge basically ruled that last week in court, or I think it was last week, at the very end of the defense case, they brought in a witness named Mr. Anderson. Mr. Anderson is like a hospital policies, procedures expert, and he testified using a summary report provided by the defense team. That's all he reviewed. He testified that basically the hospital was smelling like roses and everything was beautiful. And 5 gold stars, poster child for success. And I think presented this image to the jury that the judge now says that may be materially false information that the jury is now left with in their head, when in actuality there's a possibility that the exact opposite was true.
Bring the jury.
So this is going to be a huge decision. On top of that, the defense last week filed a motion to exclude a juror. They want to remove a juror from the jury, and they think he's biased. They think he has preformed opinions and that he's sharing them in the form of his questions. So they listed out a list of grievances for everything they said that he did wrong. I think it was like a 10-page document, and said, we'd like him removed for these reasons. And initially I said, I think the judge will remove him out of abundance of caution. Pretty much all of LawTube said, no, that's not going to happen. I don't know where it's going to end up. I would trust the lawyers better than me. But that's where it's at. The plaintiff did file a response. And one thing to think about is basically every objection that the defense raised in this case, where they said, hey, he did this, he said this and this word, he used these, he called the witness a noob, all that bit, everything. All that has been raised previously to the judge, and the judge ruled on it already. So there's nothing in here that's like a smoking gun, new information. We've discovered a social media profile where this witness is, this juror is like, I'm going to stick it to the hospital during this trial. No, there's nothing out there like that. This is all the same information, again, just grouped together and saying we are reiterating our objections. The judge is going to rule on that as well. So 2 big issues. If a juror does get tossed off, not a huge deal. They have alternates. They only need 6 to deliberate. They have like a dozen. And it's going to be good. Lego My Briefs says it's my late husband's heavenly birthday. Oh, Lego My Briefs. Congratulations at the same time, and I am so sorry. Walter, forever my hero. Together since we were teenagers. Lego My Briefs. Thank you for sharing that with us.
I'm not a camel.
This is obviously going to be an emotional day for you that way. Cancer is a monster. I think almost everyone here knows someone or has someone close to them that was taken too young, too soon from cancer. But my heart goes out to you and to the memory of Walter as well. Thank you, Lego My Briefs. I appreciate that. Deborah Silter, welcome. Good to have you as a brand new member as well as Happy Annie. It's a good day to have new people join us. Let me get a couple other things set up. Oh, I know what I forgot. Well, first let me check the buffer sound because the mods are trying to get my attention. Buffer Zoom has started. I will pull up the Zoom. Thank you very much. Okay. I do get on the Zoom feed, and that way I can see some things and hear some things that the TV chooses not to show, but we are allowed to show. What I cannot do is show you the Zoom feed itself. Sometimes Court can provide that, and we're allowed to show it then. But let's see. Let me go back. Where are we at? But I can't let you hear the audio directly, and I can't let you see the Zoom feed. Let's see. I think it's this one. Nope, that's not it. Amber, where did my Zoom feed go? Amber, can you send me the link one more time? I've stuck it in another spot and I can't see where I put it. It's been
Squirrel.
Oh, I think I just didn't go far enough back. Sorry. There it is. Got it. I'm good. And now you sent it as well. All right, we'll get this pulled up right now. Copy link.
Bring the jury.
Open in Zoom. Agree to the terms. Okay, so hang on. Okay, we've got audio from Mr. Whitney. As a result of the immediate jeopardy findings, she looked back 5 years, and then the health system risk management executive conducted executive looked back for 3 years. Judge says health system meaning Johns Hopkins parent organization. Whitney says correct. And the issue that was taken up as a result of immediate jeopardy is risk management failed in several ways. And before I go there, Whitney says we made a footnote in our notion as well.
With 30.
Risk management was central to what went on there to Maya Kowalski. I don't need to rehash that. Judge says no. So there's two distinct failures I can talk about with risk management. One being internally, that when CMS and the Joint Commission, ACA, and by the way, there were 3 reports, self-reports, Ms. Green and her team made a site visit directly to Atlanta to the regional office to self-report these issues, and because of the media exposure. In December of 2018, they drove to Atlanta. Mr. Whitney says, I still do not have correspondence related to what their rationale was for that visit. Ms. Green claimed not to have it, but they also drove to Tallahassee. They reported to ACA, and separately, they issued a written report, self-report, to the Joint Commission. So it's not just a Joint Commission issue. They had to report to at least 3 regulatory and accreditation bodies. Internally, risk management was discovered to not have the proper channels to communicate with any of the divisions, any of the division levels. 17 of them, I think it was the number, says Whitney. They were effectively siloed off. Ms. Crane, who served as senior counsel and executive over the risk management, and that's what it says in the corrective action report that I've had a chance to review, was removed as a result of this. At the system level, Judge says, Ms. Crane, the one that's on all of the emails about Ms. Kowalski? Yes, Your Honor, says Whitney. Senior counsel who was notified of this issue. At the system level, says Whitney, they discovered that Hopkins, and this is the words of Kevin Sowers, interim CEO, Hopkins had let this hospital down. And why is that? this was the only hospital in the Johns Hopkins health system that did not have a separate reporting channel to risk management at the system level. All of the other hospitals in the Baltimore area, anywhere else in the nation, they might have a hospital, had a channel to risk management at the system level. So this allowed the risk management department, maybe alloud's not the right word. As a result, risk management did not report adverse events. If they were notified, I don't know what happened. They went in a file cabinet. They were siloed off. They weren't discussed further until they did this 5-year or 3-year look back, taking us back now for January 2019 with immediate jeopardy. It goes back to either January of 2014 or January 2016. They discovered 13 patient deaths that had not been reported appropriately to these agencies, state, federal, and the Joint Commission. What else did they learn? Judge says, were all those deaths, were they part of heart patients? Whitney says 13 deaths were out of the Heart Institute. Yes, that's where the fire manifested, but it was a system-wide failure. Whitney continues, nurse practitioners brought this to all children's attention as early as 2015. And when the interim CEO was brought down from Baltimore, Kevin Sowers, he discovered with these whistleblowers, there was a culture of retaliation and retribution if he raised issues. Miss Green spoke to this in her deposition. She spoke about, and it's in her internal emails as well, they had to conduct a massive, this is their word, massive re-education campaign within the hospital, hospital-wide. It's not as if they just re-educated the surgeons and the folks in the Heart Institute. Hospital-wide, the campus-wide, they posted posters in all of the staff areas and break rooms with the slogan, "Speak up, speak out," because these folks who had spoken up about the issues with risk management and the Heart Institute were retaliated against. So what does that leave Maya Kowalski, reporting her issues, and anyone who's going to speak up against what's going on with her is going to be retaliated against during the relevant time frame. 8 key executives were forced out, including Miss Crane, Miss Johnson Ellen, the CEO, and a number of others. The CEO was found to have been wearing 4 hats at the time. So the hospital and the system and the board felt that because he was wearing 4 hats, they needed to divide those up and bring in a separate executive because he had the power effectively to shield these issues from the board. And one of the consistent problems was that the board was unaware of this issue. They were not elevated to either the hospital board or the system board. Guys, we don't have a video feed yet. I can just tell you what I hear. Lastly, says Whitley, Miss Green, at the end of the conclusion of her deposition, I asked her some questions about the facts that we know to be true from the testimony and the risk management notes here, that if you have a 10-year-old child in your hospital complaining that she's being lied about the mental health of her mother and the status of her parents, should those issues have been raised above risk management? And she has said, absolutely, they should have. She also agreed that where the parents are communicating directly with the treating psychologist, Dr. Kastenstein, hang on, that Miss Beatty is improperly interacting with counseling, advising their daughter, that issue should have been raised to senior leadership, including the CEO of the hospital. So those are broad sweep of...
She also agreed that where
now you can hear now.
The parents are communicating directly with the treating psychologist, Dr. Jennifer Katzenstein, that they have real concerns by mid-November.
They just started the stream.
Ms. Beatty is improperly interacting with, counseling, advising their daughter. That issue should have been raised to senior leadership, including the CEO of the hospital. So those are the broad sweep of the failures that resulted in immediate jeopardy. It was cultural, it was systemic, it was improperly structured in terms of risk management. There was a culture of retaliation and retribution if you spoke up, and it all culminated in how Maya Kowalski was treated.
Now, I appreciate that. Where does that leave us with respect to proceeding? It sounds like you've got a lot of information already, and we need to address what the door that was opened by the defense and their case in chief.
Yes.
But
Yes.
it's we're not trying all these other collateral issues. It's just to meet what
Yes.
the defense presented to the jury, a fair shake of it, and then moving on. So can't we just do that with what you got this morning?
Well,
I mean, it sounds like you got a deposition of a senior individual at the hospital. You've got, perhaps you've got it late, but you've got the documents. I'm assuming that your experts now seen them.
Mm-hmm. Can we just, is that a ruling or is that a?
No, I'm just asking a question.
Sure.
Can't we just, do you have enough so we can just go and finish this trial?
If forced to, yes, but we don't think that's adequate. And the reason is this case has had risk management central to it since before the court came on as a presiding judge. It's been up to the Second District Court of Appeal on this issue as to whether risk managers are sufficiently managerial to have the authority to bind the hospital and a punitive damages award be appropriate or upheld. So for us to attempt to unring the bell, unwind the clock over the course of 72 hours over the weekend, we think is severely prejudicial. So we have laid out a menu of options for the court in our request for relief. We believe that this was manipulated, intentional, contumacious by a clear and convincing standard because, as the court noted on Wednesday afternoon, defense counsel in this courtroom serves as primary outside counsel for Johns Hopkins Children's Hospital. Under questioning of the court, defense counsel admitted that he had an entire set of closed files on his computer. In essence, there's no way that as we were proceeding through this case, defense counsel was unaware or forgot about all of these systemic, cultural, and retaliation issues that were at the forefront in 2018 and 2019. We believe that conduct is severe enough to warrant the striking of defendant's answer and proceeding this morning on damages. If the court thinks that's too severe, we think that given the history of this case, having been up to the Second District Court of Appeal, that the court should direct a verdict on punitive damages if the jury, after deliberation, believes that we have proven battery or false imprisonment, the counts that are subject to punitive damages. We have been unable to develop the evidence on that over the course of the past 5 years, given the withholding of information. Third, if the court believes that is not appropriate, we have suggested, and it sounds like the court may have weighed into these, so I heard something about potentially a directed verdict on negligent training. We think that could be an appropriate sanction. Third, and in combination with others, striking the testimony of Mark Anderson and giving the jury an instruction to that effect that his testimony was unreliable and misleading because even from him, material and relevant evidence was apparently withheld. Fourth is what the court suggested a moment ago, that we proceed this morning, we cobble together, and we have prepared an exhibit list, so that's how we do this today, with some of the more critical documents that we received on Friday evening. And we put Dr. Corcoran back on the stand, and he has the ability to talk about these issues and how they affected the hospital in 2016 and 2017, the time of my admission. And fifth, regardless of what the court finds appropriate from what we've presented here, sanctions against the hospital, attorney's fees for all these efforts, taking the deposition. I don't know how far back that we need to talk about that, but those are our suggestions to the court.
Okay, thank you.
Defense.
Mr. Hunter.
Please, court. I'd like to address first Your Honor's question regarding how we proceed this morning and what's necessary to proceed this morning. And in order to do that, I need to make clear to the court most of the information that was set forth in our filing on Friday of Angela Green's affidavit, as well as the disclosure that we filed. If you go back and you look at Dr. Corcoran's testimony.
Okay, can I ask a question, though?
Yes, sir.
So you file Ms. Green's affidavit and you file a motion for clarification, and in none of those did you attach the immediate jeopardy finding of what brought us here. Why did we omit the actual immediate jeopardy finding from your affidavit and from the motion?
Well, the point of the affidavit, well, first of all, the immediate jeopardy finding was in a letter dated 1/31/19, and that has been provided. But
it was not sent to the court as part of the affidavit. It wasn't part of your motion for clarification.
It was not.
I mean, you attached a whole bunch of other things saying how wonderful everything is. But you didn't attach that.
Yes, sir, because the point of the filing was that the immediate jeopardy finding was immaterial and did not relate to the period of time that Maya was in the hospital.
So when I said to turn it over, you didn't immediately turn it over to the plaintiffs. You didn't even attach it and send it to the court. I mean, what am I missing here?
I think you're missing, Judge, what we're trying to get across in terms of what brings us here and what the real point of Your Honor's order was and what the real point of the testimony at issue here is.
So when I say to turn over the immediate jeopardy finding, you're going to interpret that not to turn over the immediate jeopardy finding?
No, sir. Your Honor, we turned over the immediate jeopardy finding. By Friday morning, I have a list here of about 30 or 40 different documents that we had turned over to the plaintiff in less than 48 hours after this all occurred. I've also got, since then, a list of about 170 others. We've provided nearly 1,500 pages of documents that include the immediate jeopardy finding. Counsel interrogated Ms. Green in her deposition regarding the immediate jeopardy finding. And the immediate jeopardy finding, as she explained, was based on a site visit that the CMS did in January of 2019. If you read the report of that, which she testified about, you will find that all of the information that they gathered and all of the conditions that they addressed were set forth in that letter and related to that time frame. There was
when I went to look to actually read the immediate jeopardy finding, you didn't attach it. So how am I supposed to read it if you didn't attach it?
Judge, my apologies for not attaching it, but again, the point of the affidavit and the point of our filing was to attempt to clarify the basis on which there was any suggestion that the immediate jeopardy finding was relevant to the hospitalization here at issue. What I was trying to get across to Your Honor, obviously unsuccessfully, is the fact that the premise of Dr. Corcoran's testimony is based on two things. One is that the immediate jeopardy survey took place in September of 2018 and was a, quote, look back, unquote. First of all, there was no survey in September 2018. And secondly, the surveys don't look back, they look forward. And that's the second point of the filing. It was to establish the fact that at the time of Maya Kowalski's hospitalization, what Dr. Anderson, or Mr. Anderson testified to, witness Anderson testified to, was that we were in good standing with JACO and CMS. The point of the filing was that we documented that that was in fact the case, that certificates had been issued in 2015, and in August of 2018, indicating that we had been reaccredited and that accreditation, barring any other activity and barring any other violation, was good for 3 years. The period of time that was covered by Mr. Anderson's testimony, Ms. Kowalski's hospitalization, was in the fall of 2016. During that period of time, we had been accredited by the Joint Commission, and we've got copies of the certificates we've provided. They're attached to the motion. The point is that the entire premise of this, that the immediate jeopardy finding was somehow related to the status of the hospital at the time of Maya Kowalski's hospitalization, is simply not true. There was not, the immediate jeopardy did not relate to any of that. The immediate jeopardy did not base its findings on anything that took place during Maya Kowalski's hospitalization or that was even reviewed at that time. The point we were trying to make, simply put, is that Mr. Anderson's testimony, however brief and however summary, was simply correct to the extent that we were, in fact, accredited at that time, and that there was nothing untruthful or misleading presented otherwise to this jury. That was the point we were trying to make.
Was there a culture? Did any governmental agency or the Joint Commission talk about a systemic failure of the culture at the hospital?
There was a discussion of that finding. There was a discussion of failings of plans that took place in January of 2019 that did not relate to anything that was occurring in the fall of 2016, 2.5 years earlier.
How do you say that? I mean, am I just to take your word for it? I mean, how do I know that when the plaintiffs just told me they got evidence of systemic problems, which apparently Ms. Green talked about in her deposition?
Your Honor, with respect, Ms. Green talked about in her deposition findings that were made at the IJ in January of 2019. If you look at the report that resulted in the IJ, it's a report from CMS that has been provided that actually indicates what the basis of the IJ was. And it talks about interviews and it talks about evidence that was gathered in January of 2019 during a site visit between January 7th and January 11th of that year. And then it relates some of those failings to its interpretation of policies that were adopted in September of 2018. None of that reaches back the preceding 2 years to when Maya Kowalski was a patient. The whole point of this is, the whole premise of Dr. Corcoran's assumptions, and it was an assumption. He looked at that report. He saw the date of September 20th, 2018, and he assumed from that there was a Joint Commission survey at that time that resulted in an IJ. That's been proven to be incorrect. And also it's been proven that that was not a look-back situation. So the whole premise of this, the whole point of this, is not what was going on at the time of the IJ and the findings that were made regarding the IJ in January of 2019. The point of this case and the things we're trying to litigate here took place in the fall of 2016, 2.5 years before. And there is not anything that has been produced that I'm aware of that relates the IJ or its findings or its basis to what was actually happening on 7 South or 7 North, where Maya Kowalski was a patient in 2016. The proof that we put forward in Angela Green's deposition, and she's here to testify if need be today, Judge, the proof that we put forward, simply put, was that the IJ related to the self-report of the Heart Institute and the Heart Institute alone. If you look at the report, if you read the report itself, you see talk of governance, you see talk of infection control, you see talk about contractual duties, but when you look at when the interviews were, in each item of that report, it talks about interviews that were conducted in January of 2019. and the findings that were made in looking at documents at that period of time or over the preceding 4 to 6 months. It says nothing about looking back 3 years or 2.5 years to this period of time, because it simply didn't.
Did Ms. Crane lose her job because of this issue?
Ms. Crane lost her job because of the Heart Institute issue and the failure to report deaths and the failure of oversight regarding those issues. If you look at this, Judge, I apologize, Judge, but I didn't mean to cut you off, and I want your questions. I really do.
Maya is watching the defense team burn right now.
The point of this is, however, that if you look at the sequence of events here,
and I think
there was in fact a self-report to the Joint Commission. It was oral, and then it was supplemented with a written report. The other two reports.
The self-report occurred because there was a media report out there already. Is that correct?
That is true, but there had been reports and there had been discussions beforehand.
Well,
wait
a second. Did the hospital report to whether it's the Joint Commission or any governmental agency prior to the media outing the hospital on the issue?
There was a report and a review that took place in the spring of 2018.
A report. Who's reporting what to whom?
There was a media report then regarding a heart case that was reported by the hospital to the Joint Commission. I believe, I don't have it right in front of me, I believe there was also a report to ACA and or CMS. There was a site survey that took place at that time. There was a review done, and there was a follow-up, and the deficiencies were cleared. There was, in addition to that, the entire triennial survey, which took place in August of 2018. Those documents were attached to the motion. There was none of these deficiencies found or identified at that time. So what happened here was there was concern regarding the heart program. There was an effort to address that. The regulatory authorities came in. They did a survey. They found the deficiencies addressed. There was a subsequent triennial review in August of 2018 that resulted in a reaccreditation that renewed the accreditation that was in effect at the time Ms. Kowalski was in the hospital in from September of 2015. So at the time of her hospitalization, the hospital was in fact accredited by the Joint Commission. It was in fact accredited and in good standing with CMS. There was no indication otherwise. Those facts were reaffirmed in August when there was another triennial review. When this hit the fan, so to speak, with the media report, that was self-reported. That was self-reported that day, and 2 weeks, 3 weeks,
that day,
nearly a month later, CMS came in with an unannounced survey and made their report. They left. They did not find an IJ at that time. They issued the IJ on January 31st, 2019. We had 10 calendar days in which to respond. We responded. There's all this correspondence has been provided. That the issues that were raised in the IJ, according to what we sent to them at the time, correspondence from one of our senior officials, said basically, here's the plan we had already put in place by the time of the report. Changes were already underway. Here's the plan we had already implemented. Then, in addition to that, there was a proposed plan of action to address the IJ and address the deficiencies. That document was provided. Then there was another on-site visit that took place in February 20th and 23rd, I believe, of 2019. That resulted in the IJ being lifted with a plan in place that we had to abide by. We abided by it. There were subsequent follow-ups, and it was cleared. But the IJ was lifted, Judge, in February of 2019 by CMS. And obscured in all this is the fact that at or about the same time that CMS was conducting its follow-up survey regarding the IJ, the Joint Commission was also in to do a follow-up review, and that was cleared. There were no deficiencies found. And so what I'm trying to get to is this, and the point where we can show you what happened with the IJ, we can demonstrate all that, but what I don't want to get lost in all of this is this central bottom line fact. The issue that brings us together into this conversation today is the question of whether Mr. Anderson's testimony about the standing of the hospital regarding JACO or CMS, whether his testimony was incorrect or misleading. And the answer to that question is that it was not. And there's no basis, there's no indication in the record otherwise. All you've got to suggest otherwise is testimony that is based admittedly on supposition. Okay? When Dr. Corcoran testified, he indicated that he had never seen a Joint Commission document regarding an IJ. He had never seen any indication that there was in fact some survey in September of 2018, and that's for good reason. There wasn't one. And the point that I'm trying to get across to Your Honor is that at the time of this hospitalization, there was in fact a certificate issued that had been issued that had never been revoked and never been abrogated, that Johns Hopkins All Children's Hospital was accredited by the Joint Commission, and there was no indication from CMS otherwise.
Either Mr. Hunter did a lot of homework over the weekend, or his memory got much better.
Your game plan for today?
My suggestion, Your Honor, that if this issue is that problematic, that the jury be instructed to disregard Mr. Anderson's testimony with reference to JACO and CMS, and that we proceed. We would like to go ahead and proceed with the case. If at the most, if we believe that putting this entire issue before the jury, first of all, is going to result in more misleading and more confusion than anything we could possibly do otherwise. We've been trying over all this weekend to conduct discovery and conduct what amounts to a reopening of discovery with reference to matters that are fundamentally immaterial and that are fundamentally prejudicial in the sense that any prejudice far outweighs the probative value. We've been litigating and investigating a purely collateral matter. And Judge, I think we're at a point where the best and most conservative management of this situation is to proceed. And if there is some clarification, limited clarification that counsel feels the need to address and rebuttal, then let's do that. But I would implore the court to look at the circumstances and look back de novo at what Mr. Anderson actually said and what Dr. Corcoran actually said, and see that there isn't any indication that this jury was misled. There is a brief reference to this entire matter, and we're going off into a collateral matter that is going to be fundamentally confusing and highly prejudicial. And if we go down this road, we're going to have more problems than we could possibly imagine.
So when witness Mr. Anderson is asked the following question, let me talk to you about your overall view based on what you've reviewed. Did it appear to you, based on the materials you reviewed, the records, the policies, that All Children's Hospital had an appropriate safety plan in place for patient care? Answer: yes, they did. So,
Your Honor?
So I mean, that is something that the hospital adduced in front of this jury.
Yes, sir. And
now you're telling me the door was not open. I mean, that's what you're telling me?
What I'm telling you, Judge, is two things. Number one, if he were to be called back, if we can get him back, if he were to be called back, the proof would be that at the time that he referenced that statement, as of the fall of 2016 and 2017, the Joint Commission on the Accreditation of Hospitals had reviewed the safety plan in effect in 2015 and issued an accreditation based on that. And there's
let me ask you
prove
this.
it. And then
let me cut you off. Did you even provide witness Mr. Anderson with any of this information that we've been discussing since Wednesday afternoon? Was he provided any of it?
yes, sir. We sent.
He was provided the information? Because we had an issue with what was produced to Mr. Anderson, witness Mr. Anderson. So I want you to be very clear as to what was specifically produced to witness Mr. Anderson. Very, very specifically.
Since Wednesday, he was sent the certificates.
I don't care what happened since Wednesday. At the time he testified to this jury, had the defense even provided any of the information that we've been discussing since Wednesday?
May I ask Mr. Shapiro to address that, Your Honor?
Mr. Shapiro, do you want to step into the breach here?
Does not want to.
Only to the extent that he was provided hospital policies and procedures, yes.
That doesn't answer my question.
Yeah. I did not provide him Joint Commission surveys, no. So I don't know if he looked at anything online, but to my knowledge, no. My understanding of his just to explain, my understanding of his testimony, Your Honor, is that the fact that the hospital was able to operate at that time meant that they had gone through joint accreditation surveys. That was the simple basis of his statement that he volunteered.
Didn't even provide the information. Okay. What's next, Mr. Hunter?
I just point out to the court that we have been scrambling very hard to try to provide as much information as quickly as we can. And I believe that this issue can be addressed either with an instruction, a curative instruction, or some summary disposition. I think if we go full scale into it, we're opening a whole nother trial.
Well, plaintiffs are telling me that if I don't go into it, I'm getting another entire trial anyway.
Maya's loving this. She's got a smirk on her face.
Okay. We are where we're at. Anything else, Mr. Hunter, that you would like to say before I let Mr. Whitney have a very brief rebuttal, and then we'll talk about what we're going to do?
I don't believe so, Your Honor.
Mr. Whitney, very brief, please.
It's the icing on the cake right here. Whitney is incredible at this. He can read the room so well.
I need to dispel a couple of notions. First, that these issues were limited to 2019. In what was produced to us Friday evening during the deposition, we have an ACA statement of deficiencies dated February 23rd, 2017, specifically for risk management deficiencies. The specific violations relate directly to patient rights, coordination of care, and patient family education. That was less than 1 month after Maya Kowalski was discharged. We provided that the first time from ACA on Friday afternoon. The statement of deficiencies and the corrective action that we were provided. Mr. Hunter just represented this court that surveys don't look back, they look forward. That's absurd. They have to look back, and in the corrective action plan at page, I don't know what page, I can pull it for the court if we need to. The Patient Safety Committee reported 12 retrospective Code 15s and additional Code 15 reported during the required time frame. They're not talking about the future, they're talking about the past. Ms. Green confirmed that in her deposition. In the corrective action plan provided Friday afternoon, the risk management department was not included on the organizational chart included in the quality and safety plan. There was a failure to have them report to the medical executive committee, the president, the board, or the integration of risk management into the hospital organization structure and quality assurance program. there was found to be, retrospectively, no evidence of risk management reports or data collection in the past 15 months and no historical data related to objective indicators of quality, all retrospective. The failure in the plan of correction, the governing body failed to ensure management of the organization. That's how that begins. The interim president accepted the resignations effective immediately from the president, vice dean, the VP chief of staff functioning as lead executive of risk management, the chief patient safety officer, and the VP of marketing and communications and culture. The director of risk management was replaced by someone in the role of vice president of medical affairs.
At least 5 heads rolled.
Mr. Anderson's testimony, you know what, the court already spotted the issue, that exchange about patient care. This goes directly to patient care. The last thing I'll say, Your Honor, is that we've been at this for just under an hour, and we admit that this is a lot to put before the jury on the final day of what's supposed to be the final day of this case. For that reason, we think directed verdicts are the most appropriate way to deal with this. Rather than bringing in Dr. Corcoran, introducing 15 documents, bringing in Mr. Anderson back, they want to bring in Angela Green now and have a mini trial on this issue. We think directed verdicts are the appropriate remedy.
You can't unring this bell.
I can't unring this bell, says Mr. Anderson.
The court has before it the question of sanctions filed by the plaintiffs against the defense. Ultimately, I'm going to be reserving on the question of sanctions. That's a bigger issue than what we have time to address today. And there's a lot of concerning issues that we'll ultimately have to work through. I need to address where we are right now, what we should do and what we should not do. I've got a situation where the defense knowingly and intentionally presented evidence to this jury that everything was fine about at the hospital at the time of Ms. Kowalski's admission. There is evidence out there that can be viewed that there is a systemic culture of problems, especially centered in the risk management department. Now, absolutely, without a doubt, it does seem that the driving force was this Heart Institute issue, but there is a view of the evidence that plainly and without interpretation could be seen as being more pervasive than just isolated to the Heart Institute. There's a view of this evidence that it is systemic, and systemic means systemic. And when we talk about culture, and I hear what the defense, they want to view, well, look, this happened in 2018/2019, so you can't look back. Culture, however, is not something that you just turn on and turn off. It's not like a light switch or buttons on this wall that I can't figure out how to turn on and turn off lights. But it goes to the essence of what an organization is. And that takes time. And a 3-year look back from a time that we know that it was spotted by regulators, both governmental regulators and otherwise, suggest, or at least there's a view of the evidence that a jury could find that this pervasive culture existed at the time of Maya Kowalski's stay at Johns Hopkins All Children's Hospital. You know, this culture might even go all the way back to the time of Johns Hopkins' purchase and acquiring of the hospital, which was, I think, 2011 or 2012. So I now have a situation where the defense presented everything is fine. And I think it's appropriate and required for the plaintiffs to rebut the evidence that the defense presented to this jury.
The door's opened.
Now, that being said, this is not a deep dive into what happened in the Heart Institute, what happened everywhere, but it goes more broadly and more high level as to what the culture was and the problems that existed, what appears to be admitted by Johns Hopkins Children's Hospital. And I think if the jury hears that at the high level, that is an appropriate response for the plaintiffs to rebut what the defendants presented. And then we'll let the jury make the decision as to whether it's relevant or not relevant. I don't think we need to get into a situation where we have, 14 days of testimony as to what happened in the lead up to, okay, you can call them self-reports, but if they happen because the media outed you, I'm not sure it's a self-report, but be that as it may, we'll call it a self-report. So I do think that there is a way we can proceed. So this is what I would suggest. Apparently there's 2 more boxes of materials. I see the plaintiff has his expert here that you spend this morning going through the documents and let the expert come on the stand and testify at about 1:30 today. Hopefully we can finish the evidence. And then I can give jury instructions this afternoon and the parties can do closing arguments first thing tomorrow morning. So, Mr. Whitney,
I was only going
thoughts?
to say, I think there's a lot of those boxes, but we're not going to be able to have time to explore all of that. And I think we have an hour and 20 minutes left in our rebuttal. I think our preference would be to, with what we have here, there's enough to put in front of him to discuss this at a high level now.
Strike his testimony, though,
as
counsel said.
And the other remedy, of course, striking Mr. Aaron's testimony. But in terms of timing, that's what I'm speaking to right now, is we prepared an exhibit list with 5 or 6 of these critical documents. We can get the issue in front of the jury for rebuttal this morning and hopefully wrap this thing up.
May I be heard for just one moment, since I'm the one delivering the closing? Judge, we can't unring that bell unless we strike the testimony of Mark Anderson. If the court recalls, juror number 1 asked a question which reaffirmed their point about whether the government had passed judgment or had accepted, or whatever you want to call it, approved of the actions of Johns Hopkins, that there were no problems there. You can't unring that bell unless we do something to let the jury know that that was highly questionable testimony. Because even if we come back here with some rebuttal, it's still in the jury's mind that the other guy said, well, but the government overall, they found that they were okay. And I know juror 1 at least, who's asked the most questions, has been, it was a concern to him. So we move the court to strike all or the significant portion of expert Anderson's testimony, or else we have an incredibly uphill battle to get around that.
Well, I hear Mr. Hunter, he's making a full-throated argument that what happened in 2018 has no bearing going back. And, if that's the argument he wants to make to the jury, then why should I preclude him from making that argument and presenting evidence to that effect?
I don't say that he can't make some sort of argument. I'm saying that the particular phrase that there was the government passed, approved, and I forget the exact quote, it's in our memo. Johns Hopkins during this period be stricken. And then, however he wants to argue the rest of the testimony from there, fine. But the key point is, for those jurors, that the federal government had passed on the conduct and the management of Johns Hopkins. And that is at the core of our case, particularly punitive damages. So if we cannot get that out of the jury's mind, because let's face it, it was procured through lack of production to us and some highly questionable representations. If at the time we had had that stuff, we could have attacked it and we could have done something about it. We did not have that option. The testimony needs to be stricken for us to have a level playing field. I don't know any other way around it.
If I strike the testimony, then why would I allow you to present any information to the jury?
Well, that's an interesting question, whether we even need to go that far. If we strike his testimony, the jury is to disregard it.
Well, you want to know what's even more interesting in my mind is how does this impact your punitive damage claim if the risk management department wasn't reporting up? But, I mean, that's another question, but regardless.
That one.
I don't know.
The judge
nothing
just
else going on
dangled
this
the
week here, I
carrots.
think. So.
This is just awful to have this at the last minute. We spent the weekend, instead of me spending 100% of my time on the closing, dealing with this issue because we were so worried about the impact it would make over all.
I hear what you've said. I'd let you speak when it really was Mr. Whitney. So, Mr. Whitney, was there anything else you wanted to say before I let Mr. Hunter have an opportunity to comment on my game plan?
I don't believe so. Judge, you made the point I was going to make. If you're going to permit rebuttal, then an instruction would make that pointless. Obviously, we've made the record. You know how we feel, but Your Honor's game plan, I would suggest that if you issue an instruction, there's nothing for them to rebut. So I think that the two things there are mutually exclusive.
But how can I strike his testimony, the witness's testimony at this point, when you've just made a full-throated argument as to why it doesn't matter and why the information you presented to the jury was legally correct? I mean, I feel like I'm in between a rock and a hard place here.
I can identify with that feeling, Judge. But my point simply is, I think going further, my point was and is going further with this is ultimately going to do more harm than good, and it's going to create more confusion and prejudice than otherwise would be the case potentially to both sides. Now, if he puts on a rebuttal, you've heard what I've said. I don't have any choice but to approach it that way. But I would just suggest to the court and to all concerned that if Your Honor feels between Scylla and Charybdis on this, that the simplest and most direct approach may be an instruction. And I'll just leave it at that.
They never.
Plans with the court for 5 minutes to discuss the matter with appellate counsel. This is a big deal, and the court presents a very cogent argument about which one and how. Well,
I'll give you the 5 minutes, and then I've got a jury on ice right this second, and I've got to do something with the jury. But unless I hear something fundamentally different when you come back after having discussions with your various appellate counsels, it seems like the options that exist at this moment are, one, me striking the testimony of witness Mr. Anderson with some type of instruction to the jury that they're to disregard it, and then no rebuttal on this issue. Or two, you get some ability to present rebuttal today, hopefully maybe right after lunch, and then we will do closing arguments tomorrow morning. I'll try to instruct the jury this afternoon so that we can do closings in the morning and then they can start deliberating at lunchtime. So, or maybe a little bit after lunch. So that seems to me to be the two paths that I can walk at this moment without. I think those are probably the two best options I've got in the situation we find ourselves in. So
the court speaks wisely on it.
Take 5 minutes, and I'll be back. Let the jury know it's still going to be a few more minutes before I can get to them. Thank you.
All rise. Closing recess.
Okay, as they go on a break, let me say this: the negative inference instruction. I think now, Rob, you can correct me if I'm wrong on this. I think where that could come in is the judge has ordered that this document, this IJ, be released, to be turned over, and that wasn't. Can the judge issue a negative inference instruction that says you can, as a jury, because this evidence was not turned over, was not submitted, you can infer that it contains damning testimony, that it contains it was not turned over because of how bad it is for the defense. And you can just assume your worst. Isn't that what he's doing here? If it's not regarding that document, how does that negative inference play in? Okay, so what we've seen so far, first of all, Mr. Anderson, I think, was making a poor choice there towards the end when he stepped up, and Mr. Whitney did a great job when he said, "Hey, we need you to strike that testimony." If they strike the testimony, this is the testimony of witness Mr. Anderson. If they strike that, the court pretends it didn't happen. And if they strike it and they pretend it didn't happen, yes, the jury's going to be like, whoa, so something was wrong there. They told us that everything was fine. They said, no, ignore that. Yeah, that helps a little bit. But then all the measures that are taken, that the opening of the door, the extra information that can come in from all this other information, from the deposition they've had, from the documents that were turned over, none of that comes before the jury. Nothing at all. So I think the judge in doing this was trying to give Mr. Anderson a little tip. He's like, don't ask for, because first of all, if Mr. Anderson says, I want you to strike the testimony, and the defense says, yeah, you're right, strike the testimony, that could be a win for the defense. Could it say it saves a nuclear explosion in front of the jury where the defense looks bad? So the judge in his little recommendation, he's like, okay, I'm fine with you talking to each other. Just know that here's the problem. If you strike this, then all these other remedies go away. Everything else you're asking for, all the other documents, the extra cross, basically getting the hospital, getting someone to admit the hospital lied and that this was not true. That never comes before the jury. And he's like, wouldn't that be a little more helpful? And even goes to the point where he says, I think a couple of moves down the road, you've got this whole the risk management. They weren't reporting up the chain. Don't you have like a punitive claim that might benefit from this coming in? Right? Isn't there some damages that might be greatly inflated if this testimony comes in? So the judge was very, very wise in doing that, and basically convincing, I think, Mr. Anderson to not strike that testimony, to say don't ask for that. That's the go-to we go to. But you've got a different situation. You can ride this horse farther than we have ridden it. Right? There's more mileage here you can get out of this than simply striking the testimony, which is damaging to the defense. So, yeah, this is going to be good. So Whitney, surprisingly, okay. First of all, this surprises me. I was talking to someone over the weekend who was telling me that there's a rule that when you turn over evidence, it has to be turned over in the form that it's normally stored in, and things like that. And we're hearing that the defense turned over boxes of documents. Okay, I'm guessing they didn't pull boxes of files. I would have thought that they would have turned over digital files that could be searched a lot faster using high-end software that can search the documents, search for keywords, look for that IJ finding, look for those keywords that will make documents in a mess of documents and records for years be pertinent and be able to draw out the things you need and get right to the facts without having to sort through pages of fluff, right? But the defense turned over boxes of documents. The judge is saying, hey, you want to go through them? And when Whitney does, they would love to go through them. But at the same time, they want this case to go to the jury. if this gets dragged out and the jury has to leave and they can't, they're like, oh, we're not available anymore. This causes problems. They don't want to lose the jury and like, hey, we need an extra 2 weeks of your time, right? So Mr. Whitney is trying to dance this line saying, we're okay. We're okay even with only having an hour and 20 minutes left on cross. We're okay with just changing what we were going to do and bring this witness in. We'll bring in some rebuttal. We'll bring in the rebuttal and bring this in an hour and 20 minutes. We've got enough information here. We don't have to do a deep dive. We'll present this to the jury, and then we can move forward and be on schedule, even closing today. The judge says, well, clearly closings are going to be till tomorrow. He's like, no, we don't have to, Judge. We'll stick to the schedule, which is huge. I mean, this is like a huge concession. They have all the rope they want right now to do with whatever they would like. The judge basically says, my hands are tied. You're right. You're in the right. The defense was wrong, and now the ball is in your court, and you get to decide how this next inning is played. And Whitney has just been on point. I love it. And he brings out those pertinent points, especially when there were some factual matters that he felt needed to be challenged about the relevance of the findings and the different things. The fact that the judge literally hassled Mr. Hunter directly. Mr. Hunter starts giving his little speech. He's like, wait, let's back up just a little bit. Didn't I say quite clearly last week that we wanted the IJ and everything else? And I looked at all the documents and I can't see the IJ. And they didn't provide it. They didn't. Instead, they provided reasons why the IJ is not relevant. Reasons why we shouldn't go there. This is why we should not talk about the elephant in the room. We're going to switch to, I just switched the feed to a more richly saturated color. So when people's faces are on screen, they're going to appear red. It's not that they're angry. It's not that they suddenly got mad and flushed. Just so you know it, everyone's going to look just a little more colorful today. A little less pasty and pale. But Kyla McDonald gifted 5 memberships. Thank you very much, Kyla. That's awfully generous of you. Thank you for that. The judge is mad. And I think he went as far as he possibly could without saying, I've already made my mind up. Okay. You guys can talk amongst yourselves for 5 minutes, but let me just tell you, I've thought about this all weekend long. I've done nothing but think about this, and we have a solution. The jury issue is next. We haven't even started with that. And did you see how Mr. Anderson carefully inserted a question from juror number 1 into this discussion and tied the two together? To say, this insightful juror number 1 asking a question, does that mean that the government, so we're gonna transition over to that soon, I guess. I don't know. Are we gonna? Is the judge gonna just let the day go on and address the jury issue later, maybe on a lunch break or later today? I'm not sure, but the jury question still has to be addressed, to my knowledge. So yes, there's a motion there and a response from the plaintiff regarding the dismissal of juror number 1. What does it mean to sanction the defense? Well, this is the judge putting in a rule that limits or hamstrings or puts them in a disfavorable position from which they have to operate. Imagine if you're in a wrestling match and you have to, and the referee says, because you poke the other guy in the eye, now you have to start on your back and it's going to be a scramble to get back on your stomach. It's something like that. It's a sanction, and we could have a lawyer come in and explain a little bit more. I want to talk a little bit about the DV because Mr. Whitney did ask for a DV. A DV, a directed verdict, is when the judge says, this doesn't need to go to the jury. We've seen enough. I can rule here and enter I'm directing the verdict to be this. Right? I'm going to say we are finding for the plaintiff on this count. And then he said, and Mr. Whitney says, and then we can go straight to punitive and say, let's start talking about damages. Because we've won on that count, let's talk about the damages. How much is this worth? The judge did not go that route. He didn't say DV. Instead, he said, I think you should bring this on cross and be limited. He didn't say, I don't want 14 days of testimony, but be limited. AJ McCleary, welcome. Good to see the courthouse change color by your name. Thanks for your continued support. Oh, man. This is all the fireworks we expected this morning. This is incredible. I wish the feed started a little sooner than it did. I'm glad I could bring you what I could on Zoom. That started very quickly, and so we got what we could on that one. Fluffy says, as I said when I called in on Friday, if it was what they say it was, they'd have turned it over. I can only imagine how bad the actual JC report is. They're fighting so hard. Yes, and this is the second time that when the judge has said turn it over, they have not turned it over. That's where I think the negative inference instruction should come relevant to that. And I hope that doesn't get lost in the weeds of just allowing in a rebuttal or allowing in some testimony that it's obviously harmful to defense. But I think the fact that you have a situation, the judge used some strong language when he called this out, right? He said, you've got intentional misleading information that was provided by the defense. Okay, this is not by the hospital. It's provided by the lawyers here sitting in the room. Mr. Shapiro, he's like, specifically, intentionally misleading information. You meant to do this. You knew it was wrong. You did it anyway. It hides the fact that there's, in the judge's words, systemic issues at the hospital that are relevant to this. I hope that does not just fade away by the wayside in light of the big issue of rebuttal coming in before the jury. Seriously, Annie Marie, welcome to the gallery. Good to have you here. Thank you so much for being here. I appreciate that. We just have a couple minutes. Let's see. Rob says, my opinion, I'd let Anderson's testimony stand, ask for the negative inference on limited docs, given that what that should have been, put on Corcoran in a rebuttal and introduce as much as I can, then argue DVs. Okay, so I don't know if the DVs are going to come up or if the judge is sort of ruling that just the rebuttal is enough of a fix. I guess they still have the option for DVs before closings. So all we need is that negative inference. I have not heard those words offered. Even when Mr. Whitney went through the menu of options that they provided for the judge, and the judge likes that. The judge loves if you bring the judge a problem and emotion.
Please get everybody.
Sorry, the judge's announcer voice there. I didn't hear that presented to the judge, but hopefully that gets brought up here.
Starting with the plaintiffs, what are our thoughts at this point?
Our thoughts, Your Honor, are if it's an either or, we would, between an instruction to the jury striking Mr. Anderson's testimony or putting in some limited evidence and rebuttal testimony of Joseph Corcoran, we would take the latter. We would like to proceed in rebuttal. We would prefer, even then, a brief instruction, but if it's either or, that's our preference.
And what's your view of doing it, let's say, like at 1 o'clock today, give your folks time to
Whitney doesn't want that.
Get prepared, your expert, if they need to look at the other documents, and then doing closing arguments tomorrow. Because remember, I still have to deal with jury instruction issues.
I understand. We prefer, Dr. Corcoran was here on hot standby this morning for a reason. He has a doctor's appointment this afternoon. We would prefer to proceed immediately into that. He has seen the documents we were provided. He was at the deposition. So he's, well, not fully prepared, he's adequately prepared, and we'd like to do it sooner rather than later.
We'll have some exhibits to add, I think.
And we have, I've narrowed down the exhibits that we would put in ahead of this.
Let's say the plaintiff, or the defense.
Judge, we would, if that's our choice and the Hobson's choice at that, we would suggest that it is simpler and more straightforward to do an instruction with reference to Dr. Anderson's testimony regarding JACO and CMS. We have one drafted that we can, hurriedly drafted, that we can show you. The other question that I would have, I don't know, we haven't discussed parameters of the rebuttal testimony proposed, and I would like to hear that, and I'd also like to hear whether or not we would be accorded serve rebuttal on a very brief basis regarding this.
Why would I give serve rebuttal when it was the defense that opened this door?
I don't know what the rebuttal is going to be, Judge.
Well, ultimately, like I said, I've reserved on the question of sanctions. I think the question of striking pleadings is probably not something that I ultimately would physically do, given the nature of this case. But I do want to give the plaintiffs an opportunity to cure or present evidence in rebuttal to the evidence that the defense presented. So, I'm willing to do that this morning. I do think Mr. Hunter has a point. We need to talk a little bit about the parameters. So what if we do the following? Over the next 30 minutes, we can discuss the parameters. We tell the jury to come back or to stand down and be ready to go at 10:15 this morning. We'll do the rebuttal case. I'll send them to lunch. We can work on jury instructions, issues, hopefully instruct the jury this afternoon on court instructions, and then closing arguments tomorrow morning. Does that...
Acceptable. The time is acceptable, plaintiffs. As far as sanctions, we would ask the court to reserve on DVs.
Okay, so that'll be coming back.
On directed verdicts. Reserve on directed verdicts. Okay. Mr. Hunter, anything further on that game plan?
No, sir.
Okay. What I'm going to do is I'm going to bring the jury in. I'm going to tell them we're going to take a recess until 10:15, so maybe they can go outside and stretch their legs or whatever, so they're not sitting cramped in their room. So let's bring them in.
All rise. Jurors entering.
Okay, please be seated, everybody. Hey, members of the jury, I want to confirm while you're away over the weekend, you did not discuss this case amongst yourselves. You did no investigation and received no information. Is that all correct?
Correct.
And that no one approached you about this case. Is that correct?
Correct.
Now, have any of you seen any media accounts about this case?
No.
Including any media accounts over the weekend or since you last were with us? Okay. Don't pull out everything right this second. I'm going to need a few more minutes to get us to the position where we can have the rest of our case presented to you. So it's going to take me, probably another 45 minutes or so. I didn't want you to have to sit there in that room for another 45 minutes. So I'm going to let you kind of go out, maybe go outside and walk around, whatever you all want to do. I am going to ask that you be back at 10:15, and so we can proceed. It's all on me. I'm the one that is slow and not getting us to where you want to be this morning, but it's all on me. So don't blame any of the lawyers. It's all on me. So do not discuss this case amongst yourselves. Do not do any investigation and receive no information. And I'll see you back in about 45 minutes.
All rise. Jurors exited.
Okay, so as the jurors are leaving here, judge, as always, wants all the blame for anything that goes bad that might affect the jury to be on him, and that's to protect the image of the lawyers, so that the jury doesn't take it out on one side or the other because of delays. That's
the jury's out of our presence. Everyone, please be seated. Now let's talk about parameters. Mr. Whitney, do you have an outline, a plan, a thought process on this issue?
Your Honor, we have
That's not
7
Mr.
exhibits that we would intend to use.
Okay, and what numbers are they so weird?
2811, 2815, 2817, 2818, 2819, 2821, and 2822. And so the rebuttal would consist of me asking some contextual questions of Dr. Corcoran and then proceeding to further contextualize that by showing him these series of exhibits. When we talk about parameters, I heard the court earlier that this is not going to be a deep dive into the Heart Institute, and I'm willing to abide by that. I think the challenge that the court faces is I would expect that the cross-examination of Dr. Corcoran would center around this was all the Heart Institute, wasn't it? So I don't know how we deal with that issue.
Well, I mean, I think, well,
Judge, looking quickly at the exhibits they've listed, the Agency for Healthcare Administration complaint investigation, 2811. I'm at a loss to understand the relevancy of that to what Mr. Anderson said or how it relates to this. I should say witness Anderson. The emails from 2817 was actually a forwarding of an email to me. It was an email that was sent to Ms. Green in real time that she then forwarded to me, and that was what was produced to the plaintiff. In other words, her email forwarded to me. So I'd like for counsel to come off of that.
Just forwarded. Just forwarded.
I mean, redacting out your name or reference to you.
Right.
I mean, I think that's what we've been doing with others that went to you.
Right, and then otherwise, that's an after the fact matter that we would respectfully object to.
Well, I'm going to need to see these documents if you're objecting to them. So tell me which ones you're objecting to, so I can make a ruling on them.
Keep me honest on the objection count, guys. Let me know if I miss one.
We object to 2811.
Let's pull that up, please.
While they're looking at that, if I could have some help on the Colorado Judicial Branch, we're waiting for a verdict in the People v. Woodyard case.
Your Honor, 2811 is
I need
what
to
I
know when it
referenced
goes
in my
live.
response to Mr. Hunter's argument. This is an ACA deficiency report dated February 23rd, 2017, approximately 1 month after Maya was discharged. The two specific citations, well, first of all, it's specifically a risk management survey. If you look at the third paragraph in the left column. And the two specific deficiencies are patient rights and care, coordination of care. And the other is on page 8 of 14 at 2811-008. It's patient rights and care, patient and family education, both relevant issues.
Well, is there anything in this document that references out the Heart Institute or did you say 13 or 18 deaths that occurred in the Heart Institute?
Nothing in this document deals with the Heart Institute.
Okay, so can you go to just the next page just quickly and then...
It's been redacted for patient identification information.
Next page, please. Next page.
Judge, while you're looking at that, I'd like to call attention to the fact that it's concerns itself with discharge arrangements and discharge planning.
Next page. Next page. Next.
The judge reads really fast.
Next. Now, what on page 8 did you want to highlight?
I was just pointing the court to, if you see the far left column, at the bottom of the page is H023, and then it cites the specific Florida Administrative Code section for patient rights and care, patient family education. So there's two kind of overarching administrative code deficiencies in this document.
And this is a February 2017 document?
Yes, Your Honor.
Okay, next page.
Objections are allowed in closing. They're sort of considered bad form, but sometimes they happen.
Next page.
We haven't heard anything about the jury yet, the juror number 1. Don't know anything about that decision.
Next page. Next. 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 Okay. Besides relevance, Mr. Hunter, any other objections?
No, sir.
Court's going to overrule the relevance objection and receive into evidence 2811. What's the next document? That Mr. Hunter, that you have an objection to.
Uh, 2817, Your Honor.
Okay, so there's no objection to 2815, is that correct?
No, sir. That's the immediate jeopardy notice.
Okay, so the court will receive into evidence 2815. Is there anything that needs to be redacted on 2815, or has it already been appropriately redacted?
2815, Your Honor, is the CMS letter that was sent to the hospital on January 31st, 2019. Mr. Anderson gave you a copy last Wednesday. It's a matter of public record. I don't think anything needs to be redacted.
I don't know of anything that needs redaction on that, Judge. It is public record, and that is the IJ notice.
So we're at 2817.
That's the report that came after
This is
the original IJ.
Forwarding to Mr. Hunter. So can we pull that up?
That's what the defense would like the judge to think is the original IJ, but it is not.
So we would redact the top block, everything above halfway down the page where it begins with Angela Green to Susan Frey.
Sorry, we're going to keep that off for just a
Howard
second.
Hunter all the way through external email, exercise caution.
Yes, Your Honor. That was just forwarded to him on Friday evening during the deposition.
We don't want
Is there anything besides removing your reference in your name, Mr. Hunter? Is there anything else?
The only
There's emails
just relevance, Judge. I mean, these are talking points for a board presentation, and I don't see the relevance of them.
Can I see the next page, please?
So if I could orient the court.
Sure.
The email you see there, Kim, addressed to Kim, CMS 2567 is the form number for a CMS statement of deficiencies, or what we're calling the immediate jeopardy notice. This is internal emails between the patient safety risk management teams at the hospital. If we go to the next page, they're developing talking points. Kevin, referenced here, is Kevin Sowers. This is the interim CEO brought in, and it discusses in a high level what they need to address based on different citations that were noted in that January 31st letter. Can we go to the next page, please? Next page. Here, governing body, this is an organizational level issue. And so it talks about the leadership transition, the resignations of 8 leaders, It talks about restructuring risk management, and it talks about the very bottom bullet point there is the massive education campaign, which talks to the fear of retribution present in the hospital during the time. Ms. Green testified that of these bullet points here, 5 of them were related to risk management issues. I'll stop there.
And is there anything on this document specifically referencing the Heart Institute or those 13 or was it 13 or 18 patient deaths?
There may be. In fact, maybe the previous section there, I see at the top it says something about institute. Can you go back up a page for me? Yeah, I mean, so number 1 here, halfway down the page, says halted all congenital open heart surgeries, meeting with families of children. This is the 13 deaths they discovered. Some of these are more general. I suppose we could print this out and suggest some revisions to eliminate Heart Institute issues.
This, to me, the rebuttal is not going to go into the question of the Heart Institute and those specific patient deaths. I don't want to talk about patient deaths.
Okay, understood.
In rebuttal.
Understood.
So that type of information has got to be redacted. So anything else about this document, Mr. Hunter? I know we're going to take out your name from it.
Right. The only other thing I would point out to the court is that beyond the relevance of it, this is essentially a recitation of subsequent remedial changes, and we object to it on that basis.
So 2 objections, 1 relevance and 1 is self-serving, he said? I've never heard that objection before. He's literally, they're redacting his name out of these documents that make the hospital look really bad. He was up to his eyeballs in
I
this.
see the court's brain working, mine as well.
Very slowly.
Me too. Can you go to back to the advance the page to risk management again, please? Page number 5 or 6, I'm not sure. There we go.
Judge, my point is the entire document is basically talking points on a report to the board about a response to these entire matters. So that's what this is.
So I suppose it's baked in here that these are measures that they are taking in response to the immediate jeopardy notice. However, they're also acknowledgments of the conditions that existed. For example, without fear of retribution is not a remedial measure. It's an acknowledgement of the culture of the hospital.
I agree with Mr. Whitney that this identifies the problems that existed and goes to rebut the evidence that the defense presented to the jury. So anything else, Mr. Hunter? Okay, so we're going to remove the Mr. Hunter information. We're going to remove the Heart Institute information. Otherwise, the court will receive, as redacted, 2817. Do I need to make that an A?
Probably.
Okay, so let's call it 2817A, and I'll need the plaintiffs to print out and give the clerk the redacted version.
We could have a copy just to compare, because I think I saw another Hart reference earlier in the document.
That, please do, yes.
We will work with counsel on that. The next is 2818. I don't know if there's an objection.
Can you pull it up? Obviously, we need to take out Mr. Hunter's name there at the top.
Understood.
And was this sent to Mr. Hunter?
On Friday. Wait.
No, but did any of these emails?
This one, Mr. Hunter was the one printing out these emails on Friday evening.
Right, I get it. But within this email chain was in 2019. Was he on?
I have not seen his name. You can correct me if I'm wrong.
Okay.
I apologize, this is hard to read.
So we're taking his name off. Anything
Self-serving in
else?
legal context refers to a statement or answer to a question that serves no purpose and provides no evidence, but only argues or reinforces the legal position of
Next
a
page.
particular party in a lawsuit. Thank you, Magical Mary, for that definition. It only reinforces or the legal position or of a particular party, provides no evidence.
What are we using this document for, Mr. Whitney?
One moment. We're using this document because, Your Honor, this is attaching the draft corrective action plan, which, if you advance to page... Not right? You advance to page 7. So what you have here, Your Honor, in the left column, the large left column, you have the statement of deficiencies from CMS, and in the right column, you have the negotiation between CMS and Johns Hopkins All Children's Hospital as to what will need to be done to correct the issues and acknowledgement of the issues throughout. And this is what I was referencing in my argument earlier with respect to certain pages that speak to 8 key executives leaving and risk management not being properly integrated, etc. So I would reference certain pages here.
Well, is there, again, going back to the Heart Institute / deaths, anything like that will have to come out if this document comes in?
I understand it's a long document.
How many pages is this?
121 pages. And that's the survey and corrective action. It's 128 if you include the email. Excuse me.
The way these things are set up, Your Honor, is you're sent this form 2567, whatever it is, and then the suggested plan to address it, the subsequent changes to address it, are put in a column that relates or correlates to the alleged deficiencies. So that's why the length is because of the format, if you will. But we point out to the court again that this is the statement of deficiencies, and then it's a plan that is outlined in the right-hand column to address alleged deficiencies that are the subject of this witness's testimony. So this is a document that outlines proposed subsequent remedial changes.
Well, let me just ask this. Is this a document that you actually need, or is it duplicative of the talking points? I mean, isn't your expert going to talk about it, and then does this document physically need to come into evidence if there's a lot of Heart Institute related things that would have to be redacted?
I don't think it's duplicative, Your Honor. I think the jury, given the impression they were given, needs to understand what the actual situation with the federal regulators was, and this is the best document to do that. And I can simplify this process by A309 is if you look back, it references failures at the governing body level. So those discussions begin at page 57 of this document and continue through page 79. And we could relatively quickly review those 22 pages plus the email to redact out Heart Institute issues.
And then just redact the other pages that
and just leave out the other pages.
Judge, it is a chronicle of subsequent remedial changes. B, it is going considerably beyond the testimony that counsel is intending to rebut. This is going deep into details of multiple matters that have nothing to do with the very simple, straightforward statement that we're rebutting. And I'm looking at page, what is it? This is page 57. There's a discussion of a plethora of details of Heart Institute issues and indications starting with ventricular shunts and hand hygiene and working its way down.
I suspect this is actually page 51 of the report, and it just happens because of the email is identified as page 57.
Oh,
so
yes, I'm sorry. Yeah, we need to move forward 6 pages. Next, there. That begins, you see in the middle column, A309. That's the governing body failure.
Can you make that a little larger, please?
Keep going, please.
A little larger. Thank you.
Well, again, this goes into, the top of it goes into the heart and diaphragmatic hernia program. Yeah, I think Your Honor may have hit the nail on the head as far as this thing being duplicative and unnecessarily detailed if you've got the other exhibits in.
This is what we're going to do with this document. The 20 or so pages that are, is it code A309 having to do, is that the one with the risk management component?
Yes, Your Honor.
Fine, okay. So you're going to just either redact out everything else or not include the pages. I don't care, but you know, it might seem better to leave the pages in and just redact it because the jury has been very curious about documents, but I don't care. And then for those 20 or so pages, we need to redact out references to the Heart Institute or those specific patient deaths.
By 10:15.
The art of the possible at this time. Miss Lawrence is working in overtime right now.
Understood.
What's the next? But once we do that, I will overrule the relevance objection and subsequent remedial measure objection and admit it.
And that, I'm sorry, Your Honor, just for clarification, court is letting in starting on exhibit number 63, page 63.
Whatever the first page is with respect to when it starts talking about the risk management department issues. What's next? And that probably needs to be an A.
Understood. 2819 is next. This is internal. We will redact the top block with Howard Hunter receiving it on Friday evening. And then what follows is the management presentation. Next, please. There, we would just need this slide here. It talks about governance and culture. And then the fifth page, 1005, talks about failure to document adverse events, including disclosing our errors.
This is why Whitney says we've got enough.
And then you're planning on redacting the balance?
We can redact the balance.
This is using the hospital's own words against
Same
them.
objections, Judge.
Same ruling as redacted. I will allow that 2819 into evidence.
2821, please.
Is this going to be just the letter or the letter and the attachments?
Right. The attachment, again, is the statement of deficiencies, so we can forego that. However, the letter addresses, beginning on page 3, risk management issues. There would need to be some redactions here because the first one is the deaths from the Heart Institute.
Well, Mr. Hunter.
Same objections, Judge.
Okay, so obviously that B1A needs to be redacted out. Yes. And then the previous couple of pages that talked about the Heart Institute needs to come out.
Yes.
Is there anything past this
And then
in the letter, not the attachment, but in the letter itself?
Yes, Your Honor. If you go to Section D, we get to governance leadership, and it discusses the Ethics Committee, which has been subject of some testimony here.
Clearly outlines what is happening now in the organization.
This is a chronicle of remedial change.
I overruled a subsequent remedial measure issue. This goes to the actual problems and goes to rebut the evidence that the defense adduced in its case in chief. So as redacted, the court will receive 2821.
There's one more page I want to show, Your Honor, on that, which is page 6. And there, number 4 picks up a governing body. And again, these are related to governing body issues. And then closing with 7, which would be the signature page.
Right, but number 3, let me see what number 3 was. Infection control, that's out, right?
All that above that would be, above 4 would be out.
Yeah, we would add the objection, Judge Cumulative, with the others.
Overruled that. Anything else on this document, Mr. Whitney?
No, Your Honor.
Okay, as redacted, the court will receive it.
All right, and that takes us to 2822. And it's an internal email involving the interim CEO. We would redact the top portion here with Mr. Hunter's name. And what's really critical is beginning at page 4. And we only need the top box on page 4, which again goes to governing body issues and talks about, at the bottom of that box, speaking up for safety and long-term just culture.
And then you're going to redact out that second bullet, managing heart surgery programs?
Yes, Your Honor.
And then everything else is being redacted?
And we'll redact the balance beginning at 1B in those bottom 2 boxes.
Anything in addition, Mr. Hunter?
No, Your Honor, same objections.
Okay, as redacted, the court will receive 2822.
The only thing we need to do exhibit-wise, Your Honor, is admit the mortality tables, which are the first exhibit listed. We've provided opposing counsel. And so, for the record, those are 2060-002, and then continuing at 47 to 50.
Any objection from?
No.
Court receives 2060 pages 2, and then pages 47 through 50. Did I read that properly?
Yes, sir.
Anything else as far as exhibits?
Go ahead. 1 second, Your Honor.
Jules is in the courtroom. We're hoping to hear from her so we can hear what happened first thing this morning before we got the Zoom feed going.
Because we have a couple of exhibit issues, but not related to their rebuttal.
And is it something that we can all agree to just do after we send the jury home today? Is it possible, or do we have to?
Yeah, it's just the only, well, we need to, after the jury goes home, you're saying, Jerry? Yeah, we just want to, we're asking to admit an exhibit we forgot. It has nothing to do with these issues.
So long as we can do it after I send the jury home?
Yes,
Okay.
I don't see why we could not.
We are done.
Okay.
Thank you, Jim.
Let's shift gears for a moment. We have the question of juror disqualification.
Here we go.
Do you want, because we've got time issues with the expert, do we want to postpone that discussion until, a little bit later on today?
That's fine with the defense, Jim.
Yes, from my perspective.
Okay, and then before we take our lunch, we need to have a final discussion and nail down the jury instructions. So what I would propose is we do this testimony, and then I guess you're going to rest after you present your evidence. I'll send the jury to lunch, and then we'll work on jury instructions, deal with the DQ issue, and then take our lunch, and then come back, and the court will read the instructions so that first thing tomorrow morning you can do closing arguments. Does that game plan work for everybody?
Yes, sir.
It does, Judge. I just don't know when they're going to be able to get us the redacted documents.
Well, my hope, should I just give you 10 or 15 minutes right now to work on that, and then come back, let's say, at 10:20, and hopefully we're large way there?
We'll be most of the way through it, and if there's one that we can't get redacted in that time, we won't present it at this time. We'll just move it into evidence once that gets worked out.
So should I come back at 10:20 or 10:30?
10:30 would be appreciated.
Does that give your... Okay. He's got enough time, so I will be back at 10:30. Let the jury know that we'll be starting just about 10:30.
All rise. Let's close our recess.
Okay, so this is spicy. This is really good. Let me go right over to. Well, I think this feed's going to stay active. A couple things we want to talk about. First of all, let me first go a little side note. I do have another channel where we've been following the Colorado. It's called People v. Woodyard. It's a trial in Adams County, Colorado. It's involving Elijah McClain. He was an individual that died subsequent to an arrest in Colorado, where I believe 5 officers are charged in his death. The third officer to be tried is currently in trial. The jury is deliberating right now. I am on the approved media list for that, so I have written permission from the court to record the WebEx feed, which is the only cameras in the courtroom. I've been recording that, and per the judge's instructions, I posted at the end of the day. I'm not allowed to live stream it, so I have to delay the posting. The court will not work with us at all in telling us when the jury comes back if they have a verdict. So I literally have to be sitting here clicking the refresh button so that because the WebEx is going to open and they're going to read the verdict right then. So I would appreciate if somebody can go to the Colorado Judicial Branch page and watch for it. It's Adams County Division L. We don't need everybody to do it. We're not going to try to flood their website, but just a couple of you that are in a position where you could do some quick refreshing. I'm going to be doing it here as well. I just don't want to miss the verdict after I followed the court for weeks of trial. I'd like to have the bookend on that video for the Top Mark Media channel over there where that is. Because the funny thing, everybody else who was approved, Law and Crime, Court TV, CNN, everybody else, no one else is posting the full video. So this is the only place people can find it, and I'd like that to be there. So if you can help me in that, it's Adams County, it's Adams Division L will be on the list, and I posted the link earlier. Anyway, so that's that. Now, Don brings up a very important question. Do you know the total earned for Runkle? This morning, I believe the total is still open, so he can still receive donations, and it still may go up. But as of this morning, he was at 107,000, which I think put him in like third place on the fundraiser list. $107,000 going to a hospital for a very, very good cause. And it was amazing to be just a small part of that. Being there and listening to Rob be an auctioneer was wonderful. Rob's got a skill there. But big shout out to Ian Runkle from Runkle of the Bailey for doing just an amazing job yet again to help out people who desperately need the help. Just a stellar guy, and it was wonderful to be able to be a small piece of that. Thanks to you, all of you, for being so generous. That was just amazing to watch those donations pour in. All right, the link stays open until the end of the year. Thank you, Jess. That's right. So there's still time if you missed the live stream or it didn't match up financially, or if you're in a position now that you weren't in before and you would like to make a donation, that link will still be available. You can go back to the live stream, click on the link, and get you right there. So question that I don't know the answer to, and we might need some document hounds to sort this out. When Mr. Hunter was talking to the judge, they filed a motion to the judge about this clarification of testimony or deposition, I think. So they think, what I got from that is that Mr. Hunter thinks their witness in deposition said too much, that agreed to too much. It looks really bad. And so they tried to clarify some stuff. and they're trying to clarify that this really isn't relevant, even though the answers, it makes it look bad. That's what I got, just my layman's understanding. In that motion he filed to the judge, they did not include the IJ. And now it's not clear to me if that original IJ, the original, not the January report. Everyone's seen the January report, and that's bouncing around all over the place. But the original finding, not the one that was cited in January later, if that was ever given to the defense or to the plaintiff. I don't know if that's out there. It definitely wasn't included to the judge with all the other documents that made the hospital look really good. But so I'm not sure if they actually got away with never producing the document, the one document that the judge was asking for. Let's see. I would like the Colorado case also. Alice, it's out there. I'll say this is a WebEx. And also, I'll say this about the WebEx for this court, the Mayak trial. WebExes have limited numbers of people that watch, and so I don't want to just share the WebEx information for how to watch the Zoom, even though it's available. The restrictions are very tight, and they do not kid around. If you take a screenshot from it, if you take an audio recording from it, you will find yourself in the judge's wrath, and you don't want to be Mr. Hunter regarding that. So just be careful and realize there are some people like us that we depend on that to be able to provide it for a lot of different people as far as our recounting the events that occur there. And if too many people flood that, it may block out people that desperately need access to it. For that reason, also on the Colorado court, we don't need everybody there refreshing. Just if you are a document hound that likes to watch for that moment something gets posted, and be willing to let me know in that Colorado case as soon as that courtroom goes live. That way I can record it following my judge's order. I'm listed in the decorum order. It's all good. I have an EMC coverage from the court where I'm specifically listed and granted permission. Even though there are all the warnings on the screen, I have that written writing. So I'll record it and then we'll be able to provide it for everybody. Let's see. If they provided it to the judge, it would be public. They don't want it there. Well, if they provided it to the plaintiff, wouldn't they introduce it now in this stack of documents? Let's see. I think if they didn't turn in the September 18th IJ doc over, Whitney would have said it and the judge would have exploded. It wasn't filed with the court. We'll have to wait for, I'm not sure if Jules is going to be able to call right now, but we'll have to wait to hear from Jules because we missed the very beginning of court because they just start. The Zoom starts and they're going. And as soon as the Zoom was open, I connected to it and gave you the audio at that point. I'm not sure if he said at the very beginning that they never got the document. He probably would have told the judge. Regarding original document, I believe Shapiro said it was archived and could not be accessed. Wasn't that the, I think, Colleen, I remember that statement from Mr. Shapiro, but I think that was in relation to Kathy Beatty or Sally Smith. It was like a performance review that the previous ones were in an archive system that no longer had access to. I thought that had to do with the performance review information. Let's see. I think Hunter said it was a verbal self-report or something like that. Yeah, he did say that, Misty, and the judge caught this because Hunter's like, I just want you to know, yeah, there was something that happened in the spring and the newspaper did a report. We reported it that same day. It's like, yeah, the newspaper report came out and then you self-reported, and the judge caught that. He caught on. He's like, I don't count that as a self-report. That's like, oh, you caught us. Yep, we did it. Before the authorities actually show up on scene. That's not a self-report in the judge's eyes. Verbal self-report after media. Done. That's exactly how it went down. Mama Smith says, I can't believe the deception of the hospital. Dracula's skeleton is falling out of the closet, Mr. Hunter. Yeah, that Dracula comment. He thought he buried this Dracula years ago. Julie, W87 says, Recovery Addict, what do you think they're going to discuss dismissal of juror number 1? Julie, we did hear right before this break, the judge addressed this and said, we have this issue still out there. Do you want to wait till lunch or later in the day? I took that as lunch. So it sounds like that's going to be brought up either on lunch or after the jury breaks for today. Hospital has access to J-Hatch documents. The hospital is J-Hatch. I'm not sure what you were saying there. Spell check might have got you a little bit. Okay, it's going fast. He said the media outed you. The media outed you. Is not producing documents to judge contempt of court. Dave, this is what I was saying before. If they did not produce it at all, if the document that let's go right here for a minute because we're just staring at an exit sign. If the document was not produced at all, then the judge he took 10 minutes telling Miss Crowells that that this is what he wants. He wants everything related to this finding, related to the investigation, related to initial reports, related to self-reports, related to accusations, tips, summary reports, government agency investigations, everything related to that turned over to the plaintiff. And it took 10 minutes. And he even said, I want to make sure that you understand how broad this is and just how wide sweeping I'm making this order. And she's like, okay, I'm taking notes, Your Honor. Are you sure? So you just want this? And he says, no, I want you to know that if I don't use the right code word, the right vernacular, the right key word or phrase, catchphrase to say, oh, he wants that one? No, it's included. Everything, anything related to is included in my order. It needs to be turned over to the plaintiff. It was so broad. It was so broad that it sounds like there would have been a lot more evidence than just 2 boxes to be turned over. Okay? And the fact that they turned it over in boxes, that to me is very, very telling. It takes time to go through boxes. It takes human time. It takes eyeballs and fingers, flipping pages and scanning and reading to go through that. And 2 bankers' boxes full of evidence, full of or related or unrelated. They might have stuffed who knows what's in there. Okay, it all has to be scanned through and looking for a little catchphrase, looking for a little piece. Why it wasn't turned over digitally, I don't know. How they were able to get all that information and say, yeah, this is relevant. This is relevant. Print it and send it to them in paper form. Why was it not sent over digitally? Maybe they got it in both formats. I just heard that it was there in banker boxes. Lynn says, is it possible the Joint Commission report mentions Maya or issues that were raised pertinent to the case? Lynn, I think the report, as far as the individuals who, I think it focused on the cardiac patients. I think there were 12 or 13 cardiac patients that passed away. And that was a big focus of the report. I don't think it mentioned Maya at all. I don't think you'd find her name in that. Realize that the part of the problem was that problems seemed to not be reported up. That things like that, like Maya's situation that would have, and the testimony from, was it Miss Green? They said that it was who they deposed. That sort of situation should have been passed up to upper management. But the problem was it was not, apparently. Waldorf KP says, Recovery Addict, yes, was challenging that Mr. Shapiro didn't provide it to witness Anderson. It was funny how fast Mr. Hunter threw the hot potato to Mr. Shapiro. He's like, yeah, I'm going to defer this this nuclear explosion to Mr. Shapiro, and he gets to throw himself under the bus and be the sacrificial lamb in this case. Okay, I'm seeing Adams Division 2, Division E, and Division L, but Division G, but no L yet. So we'll keep an eye out for this. I've got a snooze alarm going, reminding me to keep checking. How can the rest of us watch the Colorado case? Alice, the only way you can watch it is either live on the WebEx, which is done through the live.coloradojudicial.gov, or I believe on my second channel, the Top Mark Media channel. And it's just a straight dump of a WebEx feed. No commentary, nothing. Because it's been going live during this trial, so I haven't been able to focus any other. I don't even know what's happened there. I just know they're in jury deliberation. I think you should be the cameraman for the court. I have ordered some equipment. We're getting there. We're getting there. We're going to start small, but we've started ordering some cameras that will allow us to do it. The pan tilt zoom cameras, the switchers and everything, to be able to live stream from court. Let's see. I'm in Colorado. I spent most of my paramedic career in Aurora. I know how they work inside and out and can give you a lot of info for future trials and medical info. Can also go to court. Sharon, that's awesome. That is really cool. I wish the court was a little more forthcoming with information about what's happening. I was talking to a court clerk on Friday about this, and she says, sorry, you just have to wait till the news comes out and hear how the trial ended. I'm like, you don't understand. when the judge issued an expanded media coverage order, he gave me permission to record this and provide it. I am the media that is providing the report. I just need to know when they're back from deliberation. They wouldn't help. They wouldn't help at all. I've got a few contacts out there that I'm watching as well, some newspapers and things that are following it, so we'll see if we can get it. I'm invested. I love this. I really do. This for me is so not just entertaining, but informative on a soul deep level. I like to think and learn about the situations that are, and unfortunately, it would be perfect if it weren't the fact that real people are involved and real people get hurt, and a lot of these, that's what brings it about. But I don't like the suffering involved in trial, but everything else that's involved in these trials is just absolutely intriguing. Can reports be subpoenaed from Joint Commission? That's pretty much what the judge did. And he didn't issue a written order, unfortunately. I think that would have been the next step, and the judge can't really do his own work. Judge can't do his own investigations. This is as close as I think he could get to that. All right. Did you watch Alan urgently, appellate lawyer on defense? His reactions during Hunter's talking, his face was palming. He was face palming, covering his face, rubbing his face, was telling. Missy Didi Moo, sorry, I can't pronounce your name today. Yeah, there have been several times when the judge has really been cracking down on the defense that everybody else has somewhere else to look other than the judge at that moment. When your team is getting raked over the coals, they suddenly, everything on the desk and everything in your bag and everything in your pockets is more interesting than what's going on in court. And we've seen that a couple times when the judge has really cracked down on them. Let's see. Let chat know the children's hospital that Ian Runkle is raising money for is Stollery in Canada, not JH. Yes, Sinbad. It is Stollery, and I believe it's part of the Children's Medical Network. It's a great cause. It's wonderful. Stollery in Canada. Kathy, Mr. Whitney knows he's got enough right here. He's got enough information, right? He knew beforehand. I mean, before the defense turned over a single document, they had enough to know what had happened and know that they had defense over a barrel. They just needed to follow the steps with the deposition, with some documents turned over from the defense to basically say, and here's now what they're saying, and we're going to see that now. They have enough. They don't have to go deep dive. That isn't the dog fight that they want to pursue. Okay, they've got enough that they can bring it in this one, and they can counter this very incorrect testimony, this materially false testimony, as the judge calls it, with this other information. They have it in the hospital's own words. And I realize Mr. Hunter was saying these are subsequent remedial measures. You can't admit this to for the truth of the initial problem. Judge is saying it's coming in. It's coming in because you opened the door. So. But they're going to use the hospital's own words, their own PowerPoint slides to talk about just how bad their situation was in the hospital, and that's all they need. And they may even get a DV in here on top of it. That would be incredible. Taminator gifted a membership. Thank you very much, Barbara Hayden. That went to you. Congratulations. Appreciate your generosity, Taminator. Mr. Opertorso says, I'm clutching my pearls, worried you'll miss my super chat. I'm still accumulating to an 8K chat. Oh my goodness. Let's see, Mr. Opertorso, thank you, first of all, a very generous super chat. I wish I could make these appear a little better. I'm still trying to find a good solution for that. Super Chat Monday, I wonder if it's worth it to defense lawyers to take sanctions if it means keeping bombshell docs sealed, falling on the sword for a client to the extreme. The judge has said he's reserved on sanctions, meaning that doesn't mean he's not going to make a decision. He means I'm going to make the decision at a later point if we're going to do it. So we're going to reserve on sanctions. We're going to reserve on DVs. He's pushing that can down the road a little bit, saying that those are still things we have to address, and I will, just not right now. So and what that means is we're going to have the evidence come in first, And we're going to see where that leads. And it may be explosive. It may be fireworks. The way it words this, the jury's jaws might be on the floor. And so we're having the evidence come in first that counters what the defense had presented. And then down the road, we're still going to have the talks about sanctions and DVs and going straight to punitive damages. Let's see. Matthias Grease says, decided to become a member today. Plus, yesterday was my aunt's birthday. Happy birthday, Aunt. Plus, I celebrated my and my brother's birthday. Also, my nephew is so cute. Love you, chat. Thank you, Mathis. Mathis, I called you Matthias. Mathis Grease, thank you very much. Appreciate your generous donation. As well as MD says, happy November and CRPS Awareness Month. Today is Color the World Orange Day for CRPS Awareness. Thanks for your sensitive coverage of this case. And we have an orange heart right here. We can float around the screen a little bit. Thank you, MD. Appreciate that. And I was not aware, but I am now. I would have worn orange. I have an orange hoodie. It's smoking hot, but I could put it on. I'd be sweating to death. All right. West Coast morning catch up. Oh my goodness. You've missed a little bit. Okay, we're getting close. We've got Adams Division M is up now. We're just waiting for Division L. Let's see. Christy says, sorry, I've not really been on YouTube until this case. Where's the like button? Christy, depends on the device you're watching. If you're watching on TV, it could be a little more challenging. On a phone, if you're not in full screen, it would be just underneath the video. It's a little thumbs up button. But you just being here is enough. We can find the like button later. Please fill me in brief, the Runkle story, new here. Nana, Ian Runkle from Runkle of the Bailey. He is a lawyer in Canada. That's just a great guy. He has amazing white. He looks, if Pete Tragos and Gandalf somehow had some sort of, I've already gone somewhere I can't back out of. Let me back up. He's got great hair and it's white and it's just brilliant. Silver flowing locks. But he's also just a really kind and a really fun lawyer. That every year he does a fundraiser for Stollery's Hospital in Canada. And last year he raised over $50,000. This year he's raised over $107,000, all during a 24-hour live stream, which was incredible. And a lot of friends from YouTube connect with him during that time because it's extremely difficult to live stream for 24 hours, even if it's for a good cause. And so that was really neat to see. It was really neat to see everyone come together and support him during that and support the cause, and whether it's through donations or Rob being the auctioneer, auctioning off items, and just all of the viewers, the whole community coming together with incredible generosity, knowing that it was going to a good cause. So that's where it was. I believe Ian is sleeping like all weekend. He's trying to recover. That is it's a huge undertaking. So I've done 12 hours, and that was a brutal day. I can't imagine double that. Division L is on. Thank you very much. That's what I needed. Okay, so give me just 1 minute to get this recording done. Let's close that. Close this. Sorry, I'm a bit distracted here. We'll get it squared away. Make sure we have no other audio sources. We're good. All right. Pardon the interruption. New screen recording. Double check audio. You only get one shot at this, so you got to get it right. Okay, record. All right, we're recording. Thank you. So now you don't need to watch Division L anymore unless they drop off and then come back again. But thank you for all those who watched for me. That is super helpful.
Hey, please be seated, everyone.
And perfect timing. Here we go.
Where's Mr. Whitney and Miss Lawrence? There's Mr. Whitney. How are we coming on those exhibits?
Well, Judge, I'm finishing reviewing 2817, and there were multiple things that Mr. Whitney agreed had to come out that hadn't been taken out yet.
Whoa. Magical Mary, 327 pages of sections.
Be honest.
Well, what's the game plan?
We'll take up something. Should we take up something else?
Well, I thought the issue was your expert couldn't be here this afternoon.
Correct. I was just thinking while they're trying to get all the exhibits together. I don't know what else we can do in that time, but
Talk about the jury.
I can't deal with anything else right now.
I need that sound bite. I need that sound bite. Without my voice over it.
I don't know how long it's going to take, Judge.
I only need 2 or 3 of them to do the rebuttal. I don't have my arms around right now what 2 or 3 are ready. We've got 4 people scrambling, working on it, printing in the hallway, giving them missed crawls. We're doing our best.
Tomorrow's Tuesday.
Let me ask our expert one question.
This expert has a doctor's appointment later in the day. They have to put him on today, basically. They're sort
We're
of
just trying to
tight.
figure out how late he can depart to make this afternoon in case this needs to be shifted to maybe even take an early lunch. I'm just throwing out options here and bring him back. After an early lunch at 12:30 or something. He's confirming.
Dr. Cochran, what time do you need to leave?
Your Honor, I think I need to leave around 2 o'clock. I'm going to call the office and see if maybe I can be a little bit late. I have a procedure.
I don't really want to start later than that because
start later than
because you're going to have questions, and then I'm sure Mr. Hunter's going to have questions.
Yes, and so if
I don't know, somebody from the defense side.
Sure. If we started at 12:30, I would not have more than 45 minutes of questions. That gets us to 1:15. If they have an equal amount of cross-examination, that takes us to 2 o'clock. Just an option.
I mean, I'm reluctant to ask this question, but what if we call him, let's say, at 8 a.m. tomorrow morning, ask the jury to be here super early, and we do the rebuttal tomorrow morning. We then instruct the jury closing arguments, and then maybe even let them start deliberating. I mean, I don't know. They might have to start deliberating on Wednesday.
I'll just ask him the question if he's available tomorrow. I'm going to ask that question.
Judge, are you concerned if we start at 12:30 that we won't be...
I want to give this jury as much time as we possibly can to deliberate. Right. I would love for them to start deliberating tomorrow, as opposed to Wednesday.
Right. So, what's the court's reluctance, I guess, to start the witness at 12:30 so we can get all the exhibits situated, or 12 even?
My preference is to get him on and off today.
Right.
Strong preference.
Right.
That being said, we are so far down this road, I don't want to do, because of rushing, I don't want to do something that is problematic.
Dr. Corcoran can leave here as late as 2:30, so if we start at 1 o'clock.
Got to be in my car, sir.
And he's not available tomorrow.
Judge.
If we started at 12, will you be ready with your exhibits?
I can confidently say yes, we'll be ready by 12 o'clock.
I believe so, Your Honor.
I'm sorry?
I said, I believe so, Your Honor.
Okay. But I also have to deal with the jury instruction issue because I really want to try to instruct the jury this afternoon unless you all say that's just, we're doing too much.
I think we would prefer that as well. Have it instructed this afternoon and get through as much as we can.
We would as well, Judge.
Now let me hear from Mr. Altenburg since this...
I don't think that disagreements and things that we have left on jury instructions are that time consuming. So,
okay. So I'm going to bring the jury back in. I will tell them to get out of here until noon.
Sorry for the trouble.
No, it's the art of the possible. Let's bring in the jury.
Okay, you're going to hear the judge talk to the jury one more time and explain that everything is his fault. And we all know that the judge is lying. Okay, but really what he's doing is he's doing everything he can to make sure that this is a fair trial for both sides. And so he says, take any anger out on me. Don't put this against any of the sides. You're going to hear him say, hey, things have come up. We need to make everything. It's going to take a while to get ready. You get an early lunch.
Okay, please be seated, members of the jury. I want to confirm while you're away, you did not discuss this case amongst yourselves. You did no investigation and received no information. Is that all correct? No one approached you about this case. Is that correct? And you've not seen any media about this case. Is that correct? Okay. Let me tell you where we're at. And this is, again, that 5-minute issue my wife so much loves. I'm going to send you away to be back, go to lunch, and be back at noon. We're going to finish the evidence this afternoon, and I am going to do everything I can to also give you the jury instructions this afternoon, which means that the closing arguments will not be today, but will be first thing tomorrow morning. When you come back, I'm going to see if you might be able to come in a little bit earlier tomorrow. But I intend on getting the jury the case tomorrow, deliberations to begin tomorrow. So what I'm asking is, when you come back from lunch, are you going to be able to be here at such a time so I can basically start having discussions at 8:30 with the jury? Okay. So basically seeing if you can be here 30 minutes. I don't know. Just let me know if that's going to be a problem. If it's a problem, then we'll do it at 9 o'clock. So just let me know when you come back. Other than that, we are going to keep working today, and we're going to have information to you at noon. So I'm going to send you out, let you go to lunch now, and be back ready to go at noon. Do not discuss this case amongst yourselves. Do not do any investigation, and receive no information.
All rise. Jurors exit.
So jury now gets, they've just had breakfast. They've come into the courtroom twice. Nothing's been presented to them other than that there have been delays. Now they're going to lunch. Once they get back from lunch, they're going to get some spicy testimony and cross with Dr. Corcoran.
Okay, the jury's out of our presence. Everyone, please be seated. Is there anything else about the exhibits, or can we pivot at this point to
jury question?
Mrs. Cross.
There's just one, on that one exhibit that I went through, there's just one phrase that Mr. Whitney and I do not agree on, the redaction. The rest, I believe, we're agreeing. I don't have my highlighted copy.
Can you just put it up?
Well, I need my highlighted copy. Do you have that?
Can someone send me a link to the timestamp on one of the bigger feeds?
So 2817.
I just can't deal with anything else. Crowell's.
Page 9, please. And the phrase is in here on several pages, but I think whatever ruling you make will apply. At the top there, Judge, it says, the second paragraph, there are 4 major areas we're actively working to improve. My issue was the second line, having had knowledge of complaints that allege a lack of oversight and accountability. I just thought that was probably referencing the Hart Institute. It's vague, I get it in general, but that was the one issue.
I am fine, since there's not a specific reference to the Heart Institute. I would leave in oversight and a lack of oversight and accountability.
Okay, that was the only, I think, disagreement on that document. Okay. That's the only one we've been through, Judge, so I have no other comments on the exhibits.
Mr. Altenburn and Mr. Elliott, can I have you both come forward and let me spotlight you there, Mr. Elliott. I'm pulling up the...
So this is jury instructions, not the juror dismissal issue. It's jury instructions.
I don't know who wants to start talking first.
The biggest concern I think that I have at this point in time is the confusion over count 14 and the motion that I filed this morning about whether or not
the negligent training
count.
And
yes.
You have now seen my...
I've seen, if it were to be removed, what you did appears to me to be the way to do that, yes. But I was I put that in there purposefully, but I also knew that you'd ruled against me on the motion to dismiss on those issues, and so I wasn't 100% sure whether you left it in on purpose or whether this was just an oversight, and I didn't want to get carried away on this. But I continue to believe, as I always have, that this tort requires, that the person be outside the course and scope of employment, or that there be something exceptional. And all the cases that I showed you under the 766-110 statute were in that nature. The federal cases, because the federal government is not liable under a respondeat superior, always have to have something additional by the government, and frequently that's negligent training, which doesn't come into play here. And so, all that line of cases struck me as meaning that, in fact, if the person is in the course and scope and we are vicariously liable for them, that this does not play in. And, when we get then to the damages, I think we all agree that the negligent training in and of itself doesn't cause impact or damage. What it does is it integrates with an employee who does something that causes injury to Maya Kowalski, which is the false imprisonment, the battery, or the medical negligence. And for the life of me, I think at that point the damages are 100% overlapped. I was concerned that the jury might not fully understand that, so I took the unusual step of actually asking for a nominal damages instruction on this so that they could give $1 or something if they couldn't figure out what else to do. But I just continue to believe that this count from its inception has been something poorly pled and not legally recognized in Florida. So I still believe that I should be entitled to a directed verdict on this count. But if not, then I'm not quite sure what we do with the instructions. If they insist on having an in, then it gets complicated with scope of employment, or, as I've said at the end, push to shove, I'll just have to withdraw this because everybody wants this case to go to conclusion. And I would rather have it resolved first so that it doesn't create reversible error.
Okay, before I forget, let me, Madam Clerk, on the question of directed verdict on the claim of negligent infliction of emotional distress. This is the one that I dealt with on Saturday.
Correct.
The transcript and the court minutes need to reflect that based on the court's rulings with respect to the physical impact requirement.
Can you send that to me, Magic Mary?
Ruled that death by suicide cannot qualify as a physical impact for the negligent infliction of emotional distress. Based on that ruling, that means the court's going to have to grant a directed verdict on the negligent infliction of emotional distress, and I do so at this time. And
so
the lawyers know that I've done that, and we've already oriented our jury instructions in verdict form. I just needed to do that here in open court so that the court minutes and the transcript will reflect that. Okay, going Mr. Elliott, or actually Mr. Altman, was there anything else you wanted me to say as relates to the negligent infliction of emotional distress?
No, Your Honor. I guess I would point out that I had made these arguments in DIN 3396 was the last time I made them, which kind of ironically was entitled "A Motion to Resolve Critical Jury Instruction Issues Prior to Opening Statements."
I'm just pretty slow, Mr. Altman. Mr. Elliott, on the negligent infliction of emotional distress, anything else you need to say about the plaintiff's position before we move on to negligent training? You're on mute, Mr. Elliott.
Your Honor, I think you summarized it. We exchanged some emails over the weekend that are, I think, Mr. Alderman and I have discussed filing a set of the various instructions with the comments in it at some point so that they're there. But I think, as you accurately recited, given the rulings, we understand the DP.
Now let's shift gears and talk about the claim of negligent training.
Yes, Your Honor. I think I heard Mr. Altman say that it integrates in with the other claims. It's not just medical malpractice, it's some of the others as well, and we don't dispute that. And it may be that there are not additional damages, it will be nominal damages. But we have briefed previously that we don't think this is limited to somebody being outside the scope. If, again, and we've had this discussion before, if the defense either agrees or the court rules that we can still talk about training in the closing, then I think we're probably don't need it as a separate count. But if we're going to face opposition on that, we think it should stay in. If the court decides later on as a matter of law in terms of reviewing it after the fact, assuming the jury even does anything with it, you can always direct it out at that point, but at least we'll have gotten a ruling on it. So those are sort of two alternatives that we would suggest.
Mr. Altenberg.
I mean, the only thing I would suggest about their proposal on can they talk about it, then the question becomes, well, I don't disagree they can talk about evidence that's relevant to something that's left. From listening to the discussions this morning, there may be some element of this that relates to a punitive damages claim. I'm not exactly sure how that ties in, but it doesn't really have anything to do with whether someone commits one of the other torts that we're vicariously liable for, because they're intentional torts. That if Miss Beatty made a contact that was offensive and not such under intentional tort law, then it doesn't really make much difference about whether she was perfectly trained or not perfectly trained. And the same is true for the false imprisonment. And the medical negligence stuff is a whole different can of worms, because that's supposed to be a professional standard of care. And we're going right now to the jury on negligent training on an ordinary standard of care for a medical facility that is itself deemed to be a healthcare provider is now under an ordinary standard of care to provide training to another healthcare provider. I don't think that's the law, and I think we're better off getting that count out of there. And again, if there are things that are relevant that are left from this testimony that can be used for the rest of it, I can't object to relevant testimony.
How does this ruling impact, if at all, what we're talking about rebuttal?
You know, Your Honor, I was not in the courtroom when this happened, so it gives me a slight disadvantage, but my impression is we were talking about this in significant part related to negligent training and trying to show that we had accreditation. What I don't honestly know myself is whether that carried over to something that relates to the punitive claim. But the punitive claim really is whether or not the people at the high level, the officers, directors, or true managers, were so involved in something that they become liable, or whether they were in a posture where they fit into one of those other two categories. And as you point out, it's kind of a two-edged sword for them, because it has to go up to management to be ratified, or go up to management for them to make a decision on it. And their whole line of theory here is that nothing went up the chain. So I've always kind of listened to this with the same interest that you had, that I'm not sure how it ties into punitive as compared to training, but I'm not going to tell you that I'm 100% convinced that there's not, as you use the word scintilla of evidence of this that somehow relates to punitive damages.
What about, hold on one second, Mr. Elliott. What about Mr. Elliott's, or maybe it was your initial idea of just putting a nominal?
I only did that truthfully as a last resort, because nominal damages are supposed to be for a tort for which damage is not an essential element, and damage is an essential element for the tort of negligence of any variety. So here, there's at least nothing new in the way of damages for this tort compared to the two intentional torts and the medical negligence claims that are the predicates for this. So I'm doing that only because it seemed to me to be the best way to protect the verdict from getting some, now that I know that how much money they want to be seeking, some large number for something that doesn't really have any damages.
Mr. Elliott, anything further?
Yes, Your Honor, a couple brief things. Not correcting something, not training, not correcting, is condoning. It is ratifying. So it is relevant to the punitive damages. And I heard a reference just saying, well, I think this is relevant here. Something about it, not being reported up. Well, wait a minute. Not reporting to the national headquarters is not the issue. They fired the CEO of this hospital for what was going on there. That's high enough up. That's punitive damage liability of the hospital. That's who we're talking about here. The fact that they're owned by somebody else or overseen at some level by somebody higher up, we don't have to get there. Firing the CEO because of how bad this was kind of makes it's relevant to the punitive damage case.
I've been warming up to Mr. Altenburn's position on this. I wish I felt as confident as you seem to feel about this claim. And is there any way I can leave the claim in with shifting a question or two, so that if I felt like after the fact I need to DV it or JNOV it, I can. I want to make sure that the law is correct and the instruction's correct.
My concern, and it's kind of for both sides here, is that at the beginning of this trial, the understanding was that we weren't going to shift to somebody outside the scope and course of employment. So they didn't put on any evidence of that. And frankly, I didn't raise that anyone was outside the scope and course of their employment, because in good faith I didn't see any evidence that I could use as the defendant to try to prove my employees were outside the scope and course of employment. So a shift to that has the questions that I put in the motion this morning, where we have to individually say, well, somebody outside scope and course. I don't think we need or should do that, because I don't really think there's any evidence of that in this case. If in fact there's no evidence of damage beyond the underlying torts, I don't see how it can possibly be harmful error to omit this, because the damages are going to be the same one way or the other. There's not going to be any harm to the plaintiff done by omission of that. And Mr. Ellicott's made a good point that some of this may still be relevant for punitive. I'm not saying that that's outside the zone here.
Your Honor, if we could... Oh, sorry.
Go ahead, Mr. Elliott.
I would say if we can have an understanding or an agreement or a ruling that training can be discussed in closing, I think we're there. And having heard a preview of the closing, it's not a feature. If there's a reference or two, I actually missed it. And Ms. Ferrier heard it. I think she heard it. So it's not going to be a feature.
I haven't heard it. I didn't have a chance to hear the feature. I guess my inquiry would be, is it relating to punitive damages, or is it relating to something else?
I couldn't tell you the context. I mean, it was...
Okay.
Thank you, Mary.
What
That's
about
been super
Mr. Elligott's, if there's some sort of understanding? I made so many calls in this case, and I think this is pretty much my last call.
I'm essentially conceding to you that I think there's a level of this that could be talked about for punitive damages, and whether Mr. Anderson will go farther than that line, I don't know, but there certainly is a line there that he can go to. So.
I think I need to ask Mr. Anderson to make sure I'm not giving away something, if he's comfortable with what we've talked about.
This much I know for certain. There is a plan behind everything the defense does. And because of that, I would like for it to go to the jury and for the court to then consider these matters on JNOV. If we have to ask an additional question, we're not opposed to that. But as to the cause of action, we would prefer for it to go to the jury, and the court hasn't heard the conclusion yet of one of our witnesses.
My evil plan is simply not to have one more claim on the verdict form and to have to deal with it in closing arguments, Your Honor.
Mr. Anderson, I hear you want it to go, but like I said, I'm starting to really warm to Mr. Altenberg's position that it might be legally incorrect to let it go to the jury, that the negligent training has to be outside the scope.
Isn't that an issue for the jury?
Well, we don't have a jury finding currently itemized on the verdict form, and based on how this has been developing over the last 9 weeks, it's not something that really we've been focused on.
I would remind Mr. Anderson that if they're outside the scope for count 14C, then they're outside the scope for false imprisonment and battery, and that impacts his punitive claim itself.
My concern is I do not want to hear from the defense after the court rules some argument that somehow our punitive damage claim is inadequate or we failed to preserve some issue. And sure as sure, we're going to get that from them. And so that's why unless simply submitting it is reversible error, in other words, if the court afterwards determines on JNOV to take it out, I don't see the problem with submitting it and getting their view.
Except it allows for a chunk of argument on things that probably should never have come in. I mean, the problem with if there is, as he says, a strategy, but I've been worried about trying to sort out the negligent things that the jury has heard about compared to the things that were extreme and outrageous conduct with intent. And
I guess, and this is going to sound pretty callous, I don't really care what your all's arguments are.
Good.
It's a question of what I legally have to do.
Right.
And that's... I just wish I was over the finish line on this issue where you seem to be, Mr. Altenberg. I'm just not quite there yet. I'm pretty close. I've warmed to the idea that you might be correct on it, but I'm just not over the finish line on it, and so that's my hesitation.
But your hesitation is on it as a legal issue as compared to the evidence that's going to the jury. So, I mean, it's not like the directed verdict is dependent upon whether there's evidence on this or not. It's whether this claim can be made by someone when there's absolutely no dispute that it's going to be 100% covered by the employer because the employer is vicariously liable. And that's the cases that they've cited to us just don't fit that. And the little case law under 766110 doesn't seem to fit that.
And I guess my concern is, let's say there's a finding of no liability on false imprisonment, battery, medical negligence, and then there's a finding of liability on negligent training.
So how could that be? Your current instruction says that cannot be.
And that's... If your argument and your position is legally correct, then how can that be? I think that's the appropriate question.
And that's how you have it currently on the verdict form that you submitted to us last night. They can't answer the questions on negligent training unless they answered yes to one of those questions at least.
Mr. Elliott, I'll give you one last chance. I am, like I said, I'm more in Mr. Altenberg's camp on this issue than I am in your camp. So,
Your Honor, you've heard Mr. Anderson's concerns, and I don't know that I have anything to add. I mean, again, I think part of the problem could be addressed as long as he's not going to be interrupted when he starts talking about training, because it is relevant.
If it is wrapped at some point into the med-mal, which is what I thought we were going to do about 2 months ago with this. But as long as it's wrapped in so that my concern is not fulfilled, then I understand the need to streamline. And, of course, the law.
I'm not quite sure how it's wrapped in at this point in the med-mal. We've got those instructions are kind of what they are.
is there any question, Mr. Altenberg, that we could ask that lets me basically punt on this issue?
Judge, it's a question of law. It's not a question we can ask the jury. I'm sorry. I wish it were.
Mr. Elliott, any other question?
The law's on the defense side.
Issue?
No, I think if the concern, one of the concerns I heard earlier was, well, you'd have to have med-mal to answer this question on the medical malpractice part. I think you could add a line that says that. You could say, well, let's put it this way. Yes, I think you could answer a question. You could add a question that says, if you find to find that the training was inadequate for a healthcare provider, you would need to answer do the analysis you did above for the medical malpractice claim.
I mean, they're already going to be able to argue that whoever breaches the standard of care on diagnosis and treatment did so because they weren't adequately trained or because they fell below the standard of care. That all fits together in that package. I mean, but it's the standard question in this situation about these doctors and whether or not they deviated from the medical standard of care in treatment or diagnosis. And it doesn't create another spare question.
I think I just heard what we've been asking about, which is that we can talk about this may have happened because of a lack of training. If I was wrong, I apologize. If I heard that, I think that may satisfy Mr. Anderson.
And can we hear the end of Dr. Corcoran's testimony before we make any finals?
Well, I guess the answer is yes, but all this has to get printed. It's going to take a while to make that happen. And so I'll be having the jury sitting, cooling their jets even more.
Talking about this afternoon with jury instructions.
Right, because, I mean, I got to print them out. And it's, I've got 11 or 12 jurors, depending on how we deal with the juror disqualification issue, plus all of y'all, the court reporter and me. And we're talking about close to 75, 80 pages per. All right.
It's wild.
Mr. Elliott, I guess I've always kind of, I don't say that this has been a throwaway count, but it just kind of seems duplicative of the other counts. And I think at this point, even though I'm not fully on board with Mr. Altenburn, I'm more on his side on this one, and it just seems like it's cleaner to not have the negligent training questions in there. I think from a percentage odds standpoint of me being wrong, I've got less of a chance of being wrong on that than if I leave the questions in.
I understand, Your Honor, and I think, again, our concern, including Mr. Anderson's, and I think we heard it would be okay, as long as you can talk about training, and again, it won't be a feature of the closing, but as long as you talk about training in the closing, and it is relevant to several issues, then I think,
I don't want to be foreclosed about arguments over management practice.
Now, Mr. Shapiro, was that shrug meaningful to this discussion, or?
Not particularly, Your Honor, honestly. It's, just to be honest, it's not a feature of my closing either.
Are they going to object, though, when it's brought up by the plaintiff?
Okay, well, this is where I'm at. I think I'm going to remove the negligent training questions. I've heard some discussions, and I do agree that the question of training does go to the other tort counts that are existing. So I think we're really talking a lot about something that's not going to become an issue or should be an issue. Certainly, it also goes to the punitive damages. So I think I've got a greater chance of being correct by not asking the negligent training questions and removing that from the verdict form. So I'm going to say let's go with the version of the instructions and verdict form that I circulated this morning. And now, knowing that that's the version I'm going with, have you all had any chance to see if I've messed up the cross-references any?
Well, I'll confess that I've read this document so many times in the last 3 months that it's hard to proofread, but I didn't see anything that was a mess up on it. The only other thing that I'm still a little concerned about, especially after I saw the calculations, which seem to be mathematically correct, is that they're lump sum for all non-economic damages, which when we get to non-duplication with the concept the pain and suffering must be for this tort, it's going to make it even harder for the jury. And so I know that you think your non-duplication instruction is adequate, but I think it's going to be tested by the closing argument, and I wish it were a little stronger. I proposed something, but you didn't get it. So.
There's so much that's been tested in this case, Mr. Altenburn.
It's a veritable fertile field, isn't it?
Okay. What I would ask is and I don't know if it's Ms. Ferrier and somebody else in your office, Mr. Altenburn, to go back and fly spec
this,
especially the cross-references. I'm going to start having printing of the verdict form and the jury instructions, and if we have to throw those away and change them, I've wasted some paper. But from a timing perspective, if I can not have the jury continue to wait on me, then...
And on that verdict form, well, I guess all of the negligent training's out, so the one question we were uncertain about is gone. Okay, yes.
And I mean, I'm not saying that you and Mr. Elliott shouldn't look at it, but...
no, fresh eyes would be a good idea.
Eyes.
By talking about wasting some paper, he's talking about 1,600 pages.
Same boat that you are. That, I mean, if I had 4 days to put this aside and come back to it,
right,
I would do that. But since we don't even have 4 hours, I'm not sure I'm in that position.
Okay.
So. Okay. Anything else that we can do before noon, or I should let y'all take your time, finish out these exhibits, and be ready to go at noon?
Your Honor, what time did you want to talk about the juror issue?
Can we just do that after we send the jury home today? Is that
yes.
problematic for anybody?
No.
So defense, you're okay with just waiting until?
That's fine, Judge.
Okay, let's do that after. Let's take that one off the table until we get this rebuttal case nailed down.
Can we come back at 10 till, just in case Ms. Crawls has any further requests for minor redactions?
That's fine. 10 till. Now, one other thing, and it probably doesn't matter since you have a lot of technology, but I was going to give the lawyers a copy. Sometimes the lawyers want them stapled, not stapled. Sometimes they want it two-sided. Sometimes they want one-sided. Is there any specific request on how you want your paper copy of the jury instructions and verdict form?
We like the stapler. One-sided or two-sided is up to the court.
I don't care about the stapler. It's just the TV, doing it right in front of the microphone.
I know. We'd appreciate a staple. Stapled, and if we could, just one side.
One side.
It's a thick document, one-sided, but it can be done.
Staple 2 for me.
Do you want yours both sides?
I'm a big pine tree saver, Judge.
Okay. So does that go for your entire team or just you?
I think Ms. Crowell is partial to one side.
Okay. And Madam Court Reporter, I'm going to get you a copy. Do you want yours one-sided or two-sided?
One-sided is fine.
One? Okay. And Mr. Elegant, your team there in Tampa?
Your Honor, we'll just pick it up from when they come out off the, we'll print one here. Thank you.
Okay. With that, let's be back here at 11:50, and then we're going to rock and roll.
Okay, so now we have some talking to do here. Give me just 1 second. We're going to switch to this feed here. Coloration changes just a tiny bit. All right, we have a little bit of talking to do. They're going to take a little bit of break. Really, this is a lunch break. Okay, this technically is a lunch break, but we don't have very much time, so we're going to talk through it and work through it. So I hope you guys brought your little bag of lunch, some treats, some snacks, something that'll tide you over, because we've got a lot to cover here. This the discussion that we just had here with Mr. Altenburn, who's on the defense side. He's the gentleman who comes up and talks about this, and that he's the individual that the judge has a lot of respect for and shows a lot of deference to. Mr. Altenburn used to be Judge Carroll's boss, basically. He was the appellate judge that heard cases that Judge Carroll had decided or had been heard in his court, and then they went to appeal. They went to Mr. Altenburn. So he used to be in that position over Judge Carroll. They have a long connection relationship. I told you about a case way back in what was it, 1992, when Judge Carroll was a teenage boy, 16-year-old, and was in court in a family matter where he as a child did not want to go and be forced to visit his dad, the family had a divorce, and the court ruled he didn't have to, and Judge Carroll took up that appeal or sided with that decision. So that's how far back the two of them go in this, and that was way back. So they have a lot of respect for each other, and they know each other very well. But that is not what is informing the judge as far as his decisions here in this court. His decisions are based on the law, and Judge Carroll is Mr. Altenburn is very, very smart. He understands the law very well, and fortunately for the defense and unfortunately for the plaintiff, the law as it relates to medical malpractice claims in Florida tends to be friendly to the hospital, tends to be friendly to the doctor side of things. And so they bring up these issues, and the plaintiff has raised this complaint that really there's no legal groundwork backing it. And the judge is trying to leave it in there because it it makes sense from in your head, but he doesn't make decisions based on just how it feels in his head. He has to follow the law, and the law just doesn't support that this allegation of the hospital can be held liable in this specific way. And this is just one of the, I believe, 22 different ways that the plaintiff was alleging that the hospital was wrong and that they should be held liable. So he's cited today for the defense in a specific way when it has to do with negligence harm that resulted in Beata taking her life. The negligence side he's taken out. Now there's an intentional side that I believe is still in, and that's where I believe the big liability lies. So anyway, that's going to be that's what we heard here today. We've talked a couple times over today. We've talked a couple times about this juror issue, juror number 1. The judge even mentioned, he said, when he was talking about printing all these jury instructions, he's doing the math. He's like, well, I've got 12 or maybe 11 jurors, okay, knowing that sometime today he's going to make a decision and he may be down to 11 jurors. So that at least is an option in his head, as he has to weigh this motion and the counter motion that came in, the reply from the plaintiff. He's going to determine if that juror gets dismissed or not. And I've said that I think the juror is going. I think that the juror will be dismissed out of an abundance of caution. He's going to be told to go back to the jury room, get his dozen eggs or whatever it is he's got back there, and thanked for his time. This is not that the juror broke the law and is in trouble and is going to be held in contempt. That's not it at all. The judge will be most gracious. He may or may not talk to the juror and ask some questions just to see if there is a problem or if something comes out in that way. He may just dismiss that juror and just change who's going to be deliberating. But I do believe that's going to be the case. I think the juror stays, says Adam. Jules, please call into RA. Thank you, Maggie, for that. I'm not sure what Jules' schedule is. I know she's been sitting next to Dr. Corcoran. I don't know. I don't think anything happens there, but she's sitting right in the middle of everything. The guy who's about to testify today, the first witness we're going to hear from on this rebuttal testimony about the IJ issue, about the Joint Commission finding. She's been sitting right next to him. He's waiting in court. Now he has to testify right away. He's going to testify very quickly. They're going to do some cross-examination, and then he's got to split. He's got like a doctor's, I think he said he had a procedure that makes him unavailable the rest of today and tomorrow. So no fun there. YouTube lawyers think the juror is staying. I've been wrong before, Elizabeth, and I would not be surprised in a tiniest bit if I'm wrong again. But there's a chance I'm right. And just out of being true to the position I took with you guys, I'm going to stick with that one. And I believe the judge, and I do this because in several other occasions, the judge has made decisions, especially when citing on information, whether it comes in or not. He's been very, very cautious to make sure he draws the line. When we're talking about the child dependency case, that the dependency hearing stuff, he wants to make sure we don't get anywhere near that. And so he's ruled on that. I think he wants to make sure that there is not even a hint or a scent or a scintilla of odor of this was improper, and we move forward anyway. So that's my basis, and that's all I have to base it on. But I think the juror is going to go for that reason, which is sad because we've really enjoyed that juror's questions, and he's put in a lot of time and effort. Okay. New device just joined my network. I'm trying to figure out who it is. All right. Motion for sanctions is long because they have all the depot's transcripts attached. The actual motion is around 30 pages. Desiree, I think it's Desiree. Thank you. I do have several people send that to me, and I've been sort of perusing it. It is 300 and something pages long, and it has depots in there as well. So I'm just I don't have time to go into it quite yet. I think tonight, if you go over on to LawTube, one of the many, I'm sure Rob's going to be possibly doing this. Do we have Jules? I think we do. We have Jules. Hang on one second.
Call from Jules.
Jules, this is Recovery Addict. How are you doing this morning?
Fine. How are you?
I am doing absolutely wonderfully. I will tell you that this morning, the live stream did not start until halfway through the argument. We had the Zoom feed but it was Mr. Whitney was already talking. We did not hear what happened at the very beginning of court today. Did you catch that?
I did. I was sitting in between my two favorite. Dr. Richards is laughing at me. I know. Dr. Richards just heard me say I was sitting in between my two favorite doctors, Dr. Corcoran and Dr. Richards. Yes, I'm going to be perfectly straight up. It was not as intense as I thought. Mr. Hunter was not his arrogant self. He was, I'm going to use the word humble. He was more humble than he has been in the past. He did not provide documents that Mr. Whitney had requested. However, the what do you call it? The depot.
Yes.
I left my notes upstairs, so I apologize. It's just been very hectic. Grant, I believe her name is Grant. He did the depot on Friday, and in the presence.
Jules, are you there? Hang on.
Obviously, Hunter, and even at the depot, Hunter did not supply the documents and correspondence.
How?
The judge was annoyed.
How is the judge not? I mean, how is Mr. Whitney not asking for a negative inference? Did he ask for a negative inference ruling?
No. I mean, he didn't. That wasn't the term that he used. He said he wanted sanctions against the defense, and he wanted attorney fees and the cost of doing the depot and all of that applied against the defense. And Judge Carroll said he will decide that later.
That seems like small potatoes. I mean, the negative inference would be basically the judge telling the jury, look, we've asked for this. The document is out there. They won't provide it. They're basically, shame on them, naughty them. You as a jury can infer that the documents contain that damning information that is being sought.
Yeah.
That would be the huge ruling.
It would be, but I judging by what the judge has been saying all morning, I think he's like walking an extremely fine line as to, not cause an issue.
Adverse inference. I keep saying negative.
Yeah.
Adverse inference. That's the.
Yeah. No.
Thanks, Greg,
No.
for
That term did not come up. No, it didn't come up.
What are the chances?
The judge was.
Mr. Whitney is like, hey, we're good. We're good going forward. He's told the judge, we've got an hour 20 minutes. We're good working in the same parameters. Let's be on schedule. Let's go forward. Just let us rebut this. Right? Does he have something that's just going to blow up in front of the jury?
Well, this is what's happening behind the scenes. Okay, all the documents that Nick wanted to put in, he's now trimmed it down to 4. What do you call it? Dr. Corcoran has changed his schedule because he was supposed to be out of here by 1. So now he's altered it because time of the essence, and they are going forward with the rebuttal. They're only going to hit on those key points. They're not going to make this long at all. So rebuttal will be done today. But in fact, as we're speaking on the phone, everybody is hustling in the hall. I mean, they've got their stuff set up in the hall with printers and redacting, and they're doing all of this stuff to get it done by 10 minutes to 12. So, and Carell's, of course, is being an idiot. Oh, and I just want you to know, too, Mr. Shapiro was very nice to me today. I don't know why. I think it might have something to do with my TikTok that I blasted him on. But, he's being he was quite nice to me twice today. But Nick is, and Nick will be doing the questioning of Dr. Corcoran. It's not going to be Mr. Anderson.
Yeah, I like that. I like Nick. He can boil down to the issues really quickly. I love Mr. Anderson as well. The both of them are phenomenal lawyers.
Absolutely,
but Nick has a way. Nick has a way of getting right to the point, especially when it's heated, and I like his ability to phrase questions. When he's walking that line, especially when the judge made a ruling saying, I'll let you take 2 steps this direction, but not 3. He is able to thread that needle and ask those questions in a way that really works. And so I'm looking forward to it.
Hunter, like I said, he was more humble today than he has ever been before. And his arrogance was gone, and I think it's because he knew he absolutely knew that it was going to be revealed in front of the judge that he did not turn over that IJ report. He did not turn it over.
And the judge called him on it. He's like, it wasn't in the memo, and he's like, oh, we turned over the January letter that references that, and that's all you need, right? That's Hunter's. Well, you've got everything. It says it exists. That should be all you get. But nobody got. Mr. Hunter didn't get it, or Mr. Shapiro didn't get it, or sorry, they have it, I think. But Mr. Anderson, Mr. Whitney didn't get it, and the judge didn't get it.
Yeah. They have it. They just didn't turn it over because they keep standing on that part. Well, we don't think that it's relevant to this case, but it is. And Nick pointed out the certain areas which he got through the deposition of Ms. Grant. Oh, and did I tell you that Corcoran was sat in on that deposition?
Yeah, I heard that. I heard he was there.
Okay, yeah.
That's going to be spicy. I think they've got enough from that they don't need the document. And that's why Mr. Whitney's saying, let's just go ahead with what we've got. It's fine. We've got 2 banker's boxes of stuff, which I'm surprised they turned over in physical form instead of a digital. But 2 banker's boxes of documents we haven't even looked at yet that the defense says is relevant. We haven't even gone there, but we're ready to proceed anyway. They have enough that they want to move forward. They really want the jury to hear this. Yeah.
Yes, and Nick is very confident. And the jury. You're going to have to wait for me to call you this afternoon, because you and your chat is like, and you're blowing up the internet, Scott. Just so you know.
Sorry.
No, don't say you're sorry. That's good for you.
I will undo that.
Don't say you're sorry. It's good for you. You're blowing up the internet, so I'm going to. I want to spill so bad, but I'm going to wait till this afternoon. But let me just say this to you: I'm not a happy camper. We'll just leave it there. On that note,
if you've got Jules, here's what I'll say. I love that you share information with us. We would love for everyone to be able to follow you on TikTok. If you've got something big to release it on TikTok first. Let us tease your channel so that people can find you over there and find you on that channel. I think you have been putting in incredible work, and then afterwards come and summarize it with us. That would be great. So.
All right.
Look out for you first.
That's what you want.
So we really appreciate what you've provided for us, and as much as I'd like to have the scoop first before anyone else, you go first.
How do you like that little tidbit I sent you?
I've loved every tidbit you've sent me. This is wonderful.
Oh, I got more. When I get home tonight, I've got more. Well, I actually already put it out on my TikTok yesterday. Which, by the way, thank you so very much, chat, all of you for following me on TikTok and for participating in the comment section, and most of all, participating with me on my live on Saturday evening. And then I spilled, I dropped some stuff yesterday. You might want to look. It's in regards to Shapiro and in regards to an interview that he did last week that totally contradicts what I put out on TikTok, and I put the receipts. The receipts are there. Okay.
That is awesome.
So he lied to the press. He lied, straight up lied to the Herald Tribune, to Fox 13. He completely lied to the press. And now on my TikTok, it's there with the receipts. And you know, so there you have it. But yeah. And I got more. I got something else I'm going to send you tonight. I can't send it now because it's on my laptop at home, but I will send it to you, and you're going to be quite shocked.
Awesome. I'm looking forward. Jules, you are an incredible court watcher. We are so grateful that you've chosen to give us some updates. We love hearing from you. Keep up the good work. I know you've made some connections in this trial that will last a long time, and friendships. And thank you for doing what you do.
Thank you. I also understand that in your chat, I think it's your chat. I'm not sure if it's your chat or somewhere, but it was blowing up in the internet that I was sitting between the two good doctors.
We saw you. So
oh, you did?
Yeah, we can see it. So.
Yeah.
That's awesome.
We're okay. Well, let me go. I need to try to get some food in me. We go
like
back
15
in
minutes,
at
barely.
10. Yeah. So okay, everybody, love you guys. Thank
love you, Jules. Thank you so much.
Hey, yeah, I'll talk to you later.
Yep. Bye-bye.
Bye.
All right. Let's see. Let me swap back here. I managed to do that without losing the Zoom feed, so we're good. All right. So I do want Jules has put in so much work here. I think it's only fair to let her reap the benefits of all her hard work. I mean, just being in court every day, this is a huge thing. Being there every day, taking notes and watching. I realize a lot of you don't follow on TikTok. I'd like her to release it there so that she can benefit from her work there instead of me reap the benefits from her work. That's why we're doing that. She's going to share with us afterwards. We're not going to miss anything. If you don't have TikTok, we'll get that same information from her. It'll just be a little bit delayed, if that's all right. Very, very appreciative of Jules. That's amazing. She's wonderful. And we are making her a custom hoodie as well. And thank you. I'm working with some great viewers who are designing the custom hoodie. So I appreciate that. All right. Poll. Will juror number 1 be yeeted? Greeners, this is one of the polls. I normally don't like doing polls until after closings, but this is a poll that I can get behind. And I will see if I'm in the minority or here. Do you want to use that word? Greeners, I'll type it verbatim. Will juror number 1 be yeeted? And it's a simple yes, no, because those are the only options. Really, there's and this decision is going to be made later today. The judge is going to make this decision after the jury's released. So the poll is up right now. But this means that this juror will be present, whether or not he gets yeeted at the end of the day. This juror will be present for the questioning of Mr. Corcoran, who the whole IJ situation. And this juror, as Mr. Anderson pointed out, asked a direct question to defense, saying, are you saying that the finding was this hospital had everything, all their ducks in order and everything was good? He asked that question. Mr. Anderson mentioned that this morning in discussion with a judge. So this juror has a vested interest in this bit of information. He's got notes on this issue, and he's going to hear something to the contrary, and that's going to go like, bing, light bulb moment, and I'm pretty sure we're going to get a question from him as well, if not a whole sheet of them. So that'll be awesome. All right. It looks like I'm losing by a long shot on a 3-7 type ratio. But let's see. Yeeted means removed from the jury. Yes, kicked out. It's a young kid's terminology that we're using. Rob's one of the young uns. I think he used the term first. So yeet is to throw or to I think throw is the right word. You can yeet something over the fence, throw it over the fence, or yeet it out the window. Plaintiffs have the law on their side. Defense has a spiritual psychic on theirs. I'd say in a lot of this, Christina, especially we went through the DVs, which is the directed verdicts. The directed verdicts, the defense had the law on their side for several things, where it's just the law is written in such a way that it makes it very difficult to sue a hospital to hold them accountable in the way that the plaintiff was trying to do so. It's very hard to, even allow certain testimony against the hospital. The rules of evidence are really, it's a Emily D. Baker law language, so that's where Rob got it. EDB. So yeet is an EDB word. She's young and hip, that's why. Baker started yesterday before Rob had a channel. I love them both. They're both amazing. So if they both use YouTube yeet terms, I will defer to their superior logic on all this. Jules hinted she was sad about something concerning the jury. I've heard that. I think the juror's going to go. That this is my take. I think the judge will dismiss the juror, and that'll be it. We'll be down to 11, and we're going to get a new juror on the deliberating body, the 6 that will deliberate, and maybe that one's going to be more friendly to the defense. I don't know. They need to have a unanimous ruling. They have to come back and all vote the same. Let's see. I don't have TikTok anywhere else. Info will be at Jules. Once the other Jules, the Jules that called in, once she shares the information on her TikTok, she'll share it with us, and we'll discuss it, or I'll discuss what we watched on our TikTok. But we'll get you the same information. All right. What's the concern with the juror? Lil Miss, the defense is upset because throughout this trial, juror number 1 particularly, and to some extent some other jurors, but they only filed a motion about juror number 1. Juror number 1 has been asking questions that on the face value might look as if he's already decided which side he sides with. He's already reached a conclusion in his mind, or maybe has a bias in a certain direction. At least the defense has interpreted his questions to mean that. Now, the juror asks these questions in written form and hands them to the judge. The lawyers discuss those with the judge, and they sometimes change the questions. They might cross off part of it. They might eliminate some. They might change some wording, and then they ask the question to the witness. In doing this, that bias has, in a large part, been removed from the questions that the witness hears and that the other jurors hear the juror had asked. So I don't think that when they say they've expressed an opinion, it's expressed to the jurors, which would be a problem if he expresses an opinion to the jurors. So that would go to keeping him on, but I don't know. I do believe the judge is gonna release this one juror. Jamie Wingood, welcome to the gallery. Love that blue courthouse. Thanks for your second month of support there. Carol C. Mammy says, celebrating 16 years of sobriety today with all you. Carol, 16 years. That is awesome. So big congratulations. That is wonderful. Thank you for sharing that huge benchmark with us. Here's to 16 more. That's wonderful. Emily D. Baker is the same age as me. Why does she look so much younger than I do? Let's see. Gloria says, I can't seem to find you on Discord. The way to find me on Discord, Gloria, is I don't have my own Discord. We have partnered with, or we've made friends with As the Gavel Drops, a Discord page that is all about true crime. And you can find that by just typing !Discord like this in chat anytime we're live. And then hopefully, if the bot is handling all the commands that are coming to it, it will reply with a little quote like this and give you a link to join. And that's how you can join that page. That's a wonderful page that has documents, calendars, discussion, basically everything, open communication as far as chat rooms, They do watch parties, things like that. It's a wonderful page to follow pretty much anything true crime related. If there's a case you've heard about on the news that you're interested in following that's coming up soon, odds are that Discord page has a document section that's specialized on everything you could want. Some of the documents are expensive to retrieve, and they've been able to do that and post them for everybody else, so you don't have to spend the money on doing a FOIA request or something like that. So they do a great service over there. Highly recommend them. Brianne says, EDB used yeeted when she talked about the detective testing the phone in the Murdaugh trial. Yes, he yeeted around the hotel room. He yeeted the phone to see if the light would turn on. And then all of us, Brianne, all of us started throwing our phones as well. I wonder what phone sales looked like the following week as we've all thrown our iPhones around to see if we could get the light to turn on. Okay, we've got the poll still going. We're gonna wrap it up here in just a minute. V Takes Sue says, the defense purposely cut off the questions and interrupted the questions to infer bias. If you read the rebuttal, you can see why he could actually stay. And I have not gone through the rebuttal on this. At least I've read just a first few paragraphs of it. I haven't gone the whole thing. So maybe if the judge likes what the plaintiff has to say, the juror won't go. Right. I think I just missed a comment. I don't want to miss it here. MAE Nerd says Jules only has 3,000 followers. Let's get her some help. I realize that a lot of this community is not on TikTok, but if you are on TikTok, I would love it if you would go over and subscribe to Jules. That would be wonderful. That's the platform she chooses to share on, and that's wonderful. I'd love for her to be on YouTube, but that it's easier for her to do it that way. But that's wonderful. The law tubers say that Washington case law means the juror stays because he's been seated. Defense cites cases to unseated jurors. Yeah, I think they had some pretty good case law, at least on the defense side. That seemed to resonate in my head anyway. All right. Any questions about what's happened to this point? So where we are right now, we've raised the IG issue. That's how the day started. Let's go here so you're not staring at the wall. How about this? Hey, here I am. Okay, so the day started with Mr. Whitney telling the court that he did not receive the documents that the judge told him to receive, that they did a deposition, that in the deposition they basically had confirmation of their worst fears as far as what the situation was, that they did receive a lot of documents, and now they would like to present rebuttal. The defense went up to reply, and their reply was cut short immediately. Mr. Hunter was pretty much cut off, and the judge questioned him at length, saying, why did you not produce the document I asked you to produce? And he talked about everything else he produced and how the 2 bankers' boxes worth of stuff was produced, but the actual document in reference was not relevant. And his response that he filed, and the motion he filed, was to that extent, to say, and this is why we didn't produce it, because it's not relevant. Instead of producing it and let the judge determine, the judge was not very happy with that, and the judge at that time reserved judgment on sanctions. Sanctions are basically punishments that the judge can hand out against the defense in this case. So the judge is still going to make that. Let's see. Mary says, no, they didn't. RA, you need to read plaintiff response citing the actual case law. Defense didn't expound. I read a little bit. That's where I stopped. I think they both cited the same case, and one viewed it differently. I'll have to look into that, Marie. So it sounds like maybe the plaintiff did a better job on citing case law than the defense. Thanks for the correction. I'll stop spouting that information then until I educate myself further. So the judge did not sanction him at that time. He did express displeasure to a great deal, and Mr. Hunter very carefully responded in ways to make it sound like they did provide everything that had been requested, but clearly that one document, the original finding, was not. Every time the judge was questioned, the judge questioned him about the initial report, which he had also said should be turned over. Mr. Hunter tried to make it look like this was initial report by the hospital, that we did our own report and this is what happened. But he said, yeah, there was on that day, there was a media report. We had self-reported the same day. But the judge saw through that and saw that they self-reported after the media published an article about it, which is very, very different. That's you caught us. Yep, we have a problem, instead of we have a problem before you caught us. Sarah Gingo, what about Maya being listed in the IJ as a patient example for violation? That's why the defense is so reluctant to turn over the actual IJ. Sarah, I would be very, very surprised if Maya was listed in that. But if it was, that's first of all, that is huge. That is beyond huge. This would be career ending for some lawyers, I think, on the defense side. Like bar card, bar license, bar number gone. I don't think that would be the case. I don't think it is. First of all, I think the only people that are referenced were in the cardiac unit, and those were 12 or 13 children that passed away in the cardiac unit. I think they're the only people. But that would be massive. I don't know how they could hide that document if she was in that. That would be massive. K-Rab says, defense misrepresented the cases they cited. Rob pulled the cases and went through it with us on his live stream. So you're saying I'm wrong. Let me go ahead and clear the poll out here. Let's see what we're going to end it. It looks like it's about 70-30. 70% saying no, the juror's not being removed, and 30% say yes. 30% are right. No, just kidding. 30% are with me in the minority there. We'll find out later today how that happens. In the motion for sanctions, check the argument starting page 23. Mathis, I'm looking at that. Let's see, I'm on page 207. I've been trying to follow court and read. Okay. Page 1, 8, 14, 27. There we go. 23. Let's take a quick look. The defendant has presented a false impression to the jury. Without question, the defendant has presented a false question to the jury about the defendant's compliance with Joint Commission and federal patient safety officials' quality and risk management standards. Mark Anderson's lengthy description of the Joint Commission quality review, how arduous it is, and the defendant is accredited after going through the arduous process, was presented for no purpose other than to convey the impression that the defendant now meets and has always met the Joint Commission and CMS's high standards. Talks about Mr. Shapiro. We know from Mrs. Green's affidavit and deposition, including the documents produced at her deposition, that the immediate jeopardy findings and notice and the defendant's corrective plan were not limited to the cardiac program. From what we now know, Mark Anderson's testimony was at best a half-truth on the material issue of the defendant carefully prepared and put before the jury. And we know from the cross-examination of Mark Anderson that his testimony was a half-truth because he was only given selected information by defense counsel. We heard the judge dig into that, as he specifically grilled Mr. Shapiro and said, did you provide these reports? And Mr. Shapiro initially said, yes, we gave him information, but then he said, did you provide the reports? He said, no, I didn't. Roro just gifted 5 memberships. Thank you very much. Oh, my goodness. We have time. Read it with us. It's 300 pages. It's 300 pages. And I haven't eaten breakfast yet. Okay. Shouldn't something like juror number 1 being Polish have come out during voir dire, thus making this potentially a non-issue? It could have, but I don't think the defense mentioned that he related to the Beata because he's also Polish. I don't know. I don't think that holds a lot of weight with the judge. It's like, oh, we've got another somebody from Poland, Polish ancestry on the jury. That clearly can't be. I don't think that's going to be an issue. CC says, 7 months member today. It's been so enlightening, educational, and fun at the same time. Thank you, RA, mods, and the chat. I would thank them in the other order: chat, mods, and then RA. But that's the order that you guys are just incredible. Thank you for all you do. Or maybe you can put the mods up higher. They work really, really hard. Both Rob and Ian both said no on removing the juror. I'm in the wrong, apparently. You were wondering which book to do a reading of? It's this one. I can read this part if you guys want to cover it. Is there anything else you'd want? Oh, hang on. What's happening here? Where are we at?
Mr. Whitney, I think she would need to address it. I'm not familiar with the issues.
Your Honor, maybe to be efficient, Ms. Ferrier found a couple of things that need to be renumbered on the verdict form.
Can she email that around?
I will, yes, Your Honor. She sent it to me, and I'll send it on. So yes.
It's just on the verdict form as opposed to the instructions.
Yes, I don't think the instructions route people to other. The instructions just go linear.
That's correct, except for in the wrongful death survivor claims, there's a couple of cross references on claim numbers, but I hope I got those.
Oh, okay. Let me send this.
I know Ms. Cross is primary on this, but I really don't think this requires her to weigh in. It requires the court to tell us what to do.
What exhibit number and what page are we talking about?
2819A. I can hand it to the court. It's easier. 2819A 003. The defense's issue with this, Your Honor, is that there's highlighting that's embedded in here. The reason being, I received these in paper on Friday evening, and as I was thinking through questions, I highlighted some things. We're not able to cure that at the moment, so either they go back to the jury like that, or perhaps the defense can send us these pages for Ms. Green this evening, and we can send back to the jury without the highlighting. Oh, you told us okay? Yeah. Oh, it's okay. Never mind.
All right. So the highlighter gates is over before it even began.
I guess so.
Hashtag highlighter gate.
And so Ms. Croyles is reviewing the last exhibit.
Yes, Your Honor.
Now, and I don't know, Mr. Shapiro, if you're able to. Ms. Croyles earlier today said that there was one defense exhibit she wanted. Yeah. Are you able to pinch hit for her?
Yeah,
since we've got 6 minutes.
Not accurately, would be whatever, if you don't mind.
Well, I want her to finish whatever she's doing, so.
Okay, I can ask her what she's
Your Honor, while we're in a lull, when we're done with this, the jury's going to come back and there's going to be the rebuttal case, right? So I guess I'm trying to figure out, I won't be needed till late today? Later in the day.
I mean, I'm going to be giving the jury instructions. I see you sent around two cross references that have to be changed. Hopefully,
in the verdict form, yes.
Yeah. You know, I don't know if you are coming back later on this afternoon or not. I don't know. That's up to you and your team.
I can come whenever I'm needed. I was going to do. I don't think I need to be present for the rebuttal case. I was going to go ahead and sign off now, and then maybe Samantha or somebody can let me know or Nick when it's time to come back.
I think they heard you.
Right. I'll text you.
Okay, thanks, Nick. All right, we'll see everybody later. Thank you.
Mr. Shapiro.
Sure, there was two exhibits that were discussed with Ms. Dede during her direct and cross-examination. Clay, can you pull up 3217-0722? This is with regard to the birthday card that there's some dispute over whether it was delivered.
Bias and violation of the juror instructions to not form an opinion.
You know what? That's fine. It's part of the group from 718 through 722. If you want to start at 718, you just scroll through the course. Pages 718 through 722.
(718) through what?
722. This is all about the delivery of the birthday card.
Trying to fix the audio as best I can, but they've got...
Didn't we already have something like this?
I thought it was admitted into evidence without objection. Ms. Crowell tells me it wasn't.
Madam Clerk, is Exhibit 3217, pages, was it 718 through 722 in?
Not that portion.
I had the same recollection as Your Honor. Ms. Crowell told me it wasn't formally admitted.
Well, the clerk's telling me it's not in, so.
Did she testify to this?
Yeah, we would have an objection to Ms. Beatty's email to Wendy Kowalski claiming that, well, whatever she claims.
Hearsay.
It'd be hearsay.
I believe she testified to this. It also goes to her action plan, not to the truth of the matter. So.
Still hearsay.
Well, it would be for the truth of the matter because we're trying to put this on DCF. So we object to that page. As for the email with the birthday card on 721, we don't have
this one?
No. We don't have objection to that.
Oh, yeah. Yeah, the one, yeah. Okay.
Anything else?
No, this was discussed. I thought we had moved it into evidence. We had verified all of this with Ms. Beatty. We would ask this to be admitted.
What was the first page that we're seeking to admit?
722 is the last email. They're in sequence between 718 through 722, and 722 is the email.
So what you're asking for starting with 718?
Yes, I don't think they have an objection for 718 through 721, correct, Mr. Whitney?
If I could see 1920 again.
They're just the scans of the birthday cards.
Yeah, no, yeah, that's right. We have no objection to 18 through 21. We object to 22.
Okay, the court's going to receive Exhibit 3217, pages 718 through 721. I'm going to exclude 722 on hearsay grounds.
Well, do we want to withdraw?
Anything else?
Okay, that's fine. Nothing, Your Honor. Thank you.
That was Mr. Shapiro.
That last
pinch hitting for Crowell's.
exhibit that you were working on, Ms. Crowell's, with the plaintiff's team?
We've discussed the redactions. I can proceed without it, and if it happens to be handed to me in the middle, I'll address it, but we can move forward.
Judge, the only issue with the exhibits, and it can be corrected before it goes back to the jury, it doesn't need to be corrected before it's shown to the jury, as they have highlighting.
I think your colleague just...
Oh, you already talked about it? I'm behind the times, Judge.
There apparently is no highlighting gate going on, so...
Okay. I defer.
Anything else before we bring in this jury?
Not the plaintiff's owner.
Defense, anything else before we bring in the jury?
Don't believe so, Your Honor.
Let's bring in the jury. Yes, sir.
All right, so this is going to start with the spicy rebuttal. We expect that at this point, Mr. Whitney is going to call as his next witness, Dr. Cochran, who is the the witness will testify about all this information about the IJ situation. And the jury, this is the first testimony the jury is hearing all day. So this is going to be spicy. There probably will be objections. And I can't wait to hear how the jurors hear and receive this evidence.
Hey, please be seated, everybody. Members of the jury, I want to confirm while you're away, you did not discuss this case amongst yourselves. You did no investigation and received no information. Is that all correct?
Correct.
Didn't see any media accounts. Is that correct?
Correct.
And no one approached you. Is that correct?
Correct.
Okay, Mr. Whitney, your next witness, please.
Plaintiff's call, Dr. Joseph Corcoran.
Did I miss 2 objections? I think I did.
Please have this swear or affirm that testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
I do.
Afternoon, Dr. Corcoran.
Good afternoon, Mr. Whitney.
I promise this will be the last time. Let's talk.
Promises.
Let's talk about how Johns Hopkins All Children's Hospital was managed during the time of Maya Kowalski's admission. And specifically, I want to touch on how risk management was integrated into the hospital's organizational structure. Let's start at a high level. And the jury has heard some discussion of the Joint Commission. Would you reaffirm for the jury the role that the Joint Commission plays in hospital accreditation and governance?
Yes, so the Joint Commission is a nonprofit organization that evaluates hospitals and other healthcare entities on a recurring basis to make sure that they are in compliance with the regulations, conditions of participation that are really the owner's manual to how to run a healthcare facility like a hospital.
And you just mentioned conditions of participation. Are those derived from federal regulatory guidance?
Yes, they are. So conditions of participation are actually published by CMS, the Center for Medicare and Medicaid Services, and they really form the foundation or the backbone of the accreditation process.
So we have the Joint Commission, it's a private entity. We have CMS, it's a federal entity. And then in Florida, is there also a state regulator that looks at these issues?
There is. The Agency for Healthcare Administration, also known as ACA, is based in Tallahassee. They oversee licensure and regulatory compliance for the state.
Now, with respect to the governing body of Johns Hopkins All Children's Hospital, have you come to learn about self-reports of deficiencies at the governing body level to these 3 entities?
Yes, I have.
What have you learned in terms of self-reports to, let's start with ACA in December of 2018?
I understand that the hospital leadership, sometime around the Christmas holiday, but probably just prior to, actually went to Tallahassee to address in person issues that had been identified within the hospital that put them at odds with the conditions of participation.
Was there also a self-report to CMS?
Yes. In the week prior to Christmas 2018, ACA was also in December of 2018. But in the full week prior to Christmas of 2018, a leadership group also traveled to Atlanta, which is the regional office for CMS, and had a similar conversation with the federal regulators about shortfalls that they had been identified inside the program.
And then, given these issues and these self-reports, did the Joint Commission also become involved?
They did. And that was done through a self-report that I believe was done either electronically or in writing On or about the 28th of November, 2018.
All right. And so you had then both the federal and the state entity and the private nonprofit joint commission looking at and scrutinizing the hospital's management structure at that point?
Well, yes, they were looking at it from that point, but there also had been some visits earlier in the year as well.
All right. Did these issues manifest for the first time in December of 2018?
No.
All right.
My understanding is that the issues were first identified at the end of 2015. So they were not new issues.
All right. Let's walk through the timeline with some documents. So if we could please display 2811A, page 1.
The silence from the defense team is deafening.
Dr. Corcoran, at the top of 2811, I see a header that says Agency for Healthcare Administration. Is that the Florida agency you talked about?
Yes, that's ACA.
Judge, I'm sorry. This doesn't say A, so I just want to make sure we're looking at the right document.
2811 was not redacted.
I thought you said A.
I'm sorry. My apologies. 2811. All right, we're looking at 2811, Agency for Healthcare Administration. And below the Agency for Healthcare Administration, right there, if you could keep that where it was, what is this document? It says in the top left box.
Correct. This is a statement of deficiencies and a plan of correction.
And if you could note the date on the right side there for me.
February 23rd, 2017.
And so what's the relationship to the date of discharge of Maya Kowalski? Is that approximately a month and a half?
Yes, sir. About 6 weeks.
And this is a good view, so just keep it like this, please. And then the last two paragraphs we can see there on the left side, where were the deficiencies identified within the hospital?
In the risk management department as part of a risk management survey.
All right. If we could now display Exhibit 2815. I see CMS at the top right. Is this the federal agency you were referencing?
Yes, sir. Centers for Medicare and Medicaid Services. That's the federal regulatory agency.
And this letter or notice is dated January 31st, 2019. And who's it addressed to?
It's addressed to the interim CEO of the hospital, Dr. Kevin Sowers.
Have you come to learn when Mr. Sowers took on the position of interim CEO at Johns Hopkins All Children's Hospital?
He became interim CEO in December of 2018. I'm not sure of the specific day, but it was in December following the departure of the previous CEO.
And who did he replace?
Dr. Jonathan Ellen.
And how long had Dr. Jonathan Ellen been the CEO of Johns Hopkins All Children's Hospital?
Gosh, 6 or 7 years, if memory serves.
So Dr. Ellen would have been the president and CEO of Johns Hopkins All Children's Hospital during the time of Maya's admission?
That's correct.
And if you could zoom out a bit for me, and that's a fine view there. In the second paragraph in the letter, it references a determination of immediate jeopardy. Do you see that?
I do.
Would you please explain to the jury what immediate jeopardy is?
So when deficiencies or non-compliance with the conditions of participation, the rule book, when those deficiencies are considered egregious, widespread, actually it's defined further down as, could you scrap that please? It's defined as an immediate or serious threat to patient health and safety. So an immediate jeopardy is as severe a finding and it carries an equally severe threat if an immediate jeopardy is not remedied quickly in a timely manner. With an immediate jeopardy, you are typically required to provide an immediate mitigation plan before the survey team leaves. You then have to send a corrective action plan within 10 days and have that largely executed within 23 days. If you fail to meet that 23 days, you potentially lose access to all funding from Medicare and Medicaid.
Is it more or less a death threat to a hospital?
It is a financial death threat to a hospital, yes, sir.
I'm sorry, what's the legal base leading, Your Honor? Overruled.
Is there any classification under CMS evaluation and survey more severe than immediate jeopardy?
None that doesn't involve literally taking over the hospital.
All right. If you could drop that and then pull up the bold text there, that the 42 CFR sections for me. Now, a few moments ago, you referenced conditions of participation.
Yes, sir.
And we see here reference to the Federal Code of Regulations. Are these the conditions of participation you were referencing?
Those are 4 of them.
All right. And why are these 4 on this document?
Okay, so the immediate jeopardy was centered on 4 specific shortfalls in their exercise of meeting the conditions of participation. Governing body is the interaction of the board, which has ultimate responsibility for the entire facility, and the 2 primary parties, the medical staff, represented by the medical executive committee, and the administration or management of the hospital, which starts with the CEO. QAPI, quality assurance and performance improvement. That is making sure that we're staying between the guardrails and delivering good care.
I'm going to stop you there if you're.
Thank you.
All right. So if you look at these 4 things, these are the specific deficiencies that Johns Hopkins All Children's Hospital was found to have exhibited or demonstrated at this time.
These were the areas where their deficiencies were so egregious and widespread that they contributed to this immediate jeopardy. Correct.
All right. And have you had an opportunity to hear the VP of Patient Safety and Quality discuss these issues?
I did.
Who was that?
Ms. Green.
What was her first name?
Virginia.
Okay.
Is this a quiz?
Does Angela sound right?
Sure. I'm sorry.
That's okay.
I apologize to Ms. Green.
In terms of having been issued a finding of immediate jeopardy, did Ms. Green conduct a retrospective review of hospital records to see where these deficiencies should be placed and the responsibility placed?
Yes, she did.
And how far in retrospect did she look back to determine where the hospital had fallen short?
She said that one team in the hospital went back 3 years, and I believe that she took her response back 5 years.
Judge, objection, hearsay.
Party admission.
Overruled.
And so whether it was 5 years, so they're conducting this retrospective review in January 2019, receiving this letter.
That's correct.
It would take us back on the 5-year basis to January of 2014.
That's correct.
Or on the 3-year basis to January of 2016.
That's correct.
In their review, without getting specific, were specific deficiencies noted in that retrospective review?
There were.
And generally, did those have to do with adverse patient outcomes?
Objection, Your Honor. I think we're going beyond scope.
Sustained on that one.
All right, I'll move on. Let's put up 2817, please. Now we're going to get into some of the internal communications at Johns Hopkins that surrounded.
Should be 2817A.
2817A.
Sorry to interrupt.
No, thank you. Okay. So here it's 2817A. We have an email from Ms. Green dated February 25th, 2019. So this would have been just following the notification of immediate jeopardy. Is that correct?
About a month after, yes.
And then we can see there her position at the time. What is the role within a hospital of the Senior Director for Patient Safety and Quality?
Well,
objection, Your Honor, foundation.
Overall, as the title suggests, they lead a team whose primary objective is to make sure that the care as it's delivered is delivered in a safe manner. Above all else, do no harm. And so they are responsible for making sure that the care is safe and the quality of the outcomes are optimized.
If we could advance to page 3 of 2817A, please. And if you could get a whole page view for page 3. All right. So I want to focus for a moment first on the subject line at the top of this email. It says, how about this for Kevin's talking points to the board on CMS 2567? Now, here, who is Kevin?
She's referring to Kevin Sowers, who was the interim CEO that replaced Dr. Ellen.
And the CMS 2567, is that the finding of immediate jeopardy?
CMS 2567 actually refers to the form number. Government issue forms always have an ID number on the base, and CMS 2567 is the page, the report that the findings are actually published on and made available to the hospitals.
All right. And so in the middle of the page, there's a paragraph that's short. It says there are 4 major areas we are actively working to improve. Would those map back to the 4 conditions of participation we saw a moment ago?
They do.
All right. Let us advance to page 5 of this exhibit, please. And we're going to talk specifically about the governing body and what types of issues were noted within the hospital during this retrospective review. The first bullet point under governing body, if you'll read that to yourself, and my question for you is, what have you learned about what was lacking between the message and the elevation of information between the president and the board in the previous 3 years?
So again, the board has the ultimate responsibility to make sure that everything is running as expected. It was demonstrated through this process that there was poor communication where problems were not shared appropriately. They weren't shared between, remember we talked about divisions, they weren't shared laterally, they weren't shared up. And they were certainly not getting shared to the board, so the board really was not able to do its job of overseeing the quality of care.
And then if we move down to the third primary bullet point, there's a smaller one in between, that's why I said primary. But it begins, restructuring of risk management to report directly to the health system. When Ms. Green, or Ms. Franklin, references reporting directly to the health system, what is she referencing there?
She's talking about having a direct link of communication to Johns Hopkins Health System in Baltimore. Prior to all of this, Johns Hopkins All Children's Hospital was the only one of the Hopkins affiliated hospitals that didn't have that link. In other words, at Johns Hopkins, everything was by design kept locally and was supposed to be managed locally. This gave them an opportunity and access to the expertise that is, that candidly is one of the things that Johns Hopkins is really known for around quality and patient safety. So it was giving them access to that expertise.
So just so I make sure I understand, there are several Johns Hopkins hospitals within the Johns Hopkins Health System.
Correct.
Johns Hopkins All Children's Hospital is one of them.
That's correct.
And it was discovered during this process that Johns Hopkins All Children's Hospital was the only Johns Hopkins Health System hospital where risk management at the hospital level was not reporting to the system. Is that right?
That's correct.
Then if we move down 3 from the bottom, it says the revision of the complaint and grievance process. There's been some discussion in this courtroom about the complaints made by the Kowalski family. What is the proper operation of the complaint and grievance process as it relates to risk and patient safety within a hospital?
Check your eyes beyond scope.
So, a grievance actually is recognized as having specific responsibilities. As a hospital operator, if my team received a grievance, we were required to answer that grievance within 10 calendar days. And there were, again, communication issues where grievances and complaints, like the Kowalskis shared with members of the staff at All Children's, were just not addressed at all, let alone in 10 days.
And then the last I'd like to focus to on this page is the last bullet point. It says massive education campaign on speaking up and speaking out. Have you had an opportunity to hear Ms. Green discuss this campaign?
I did.
What was the genesis of this massive education campaign?
So she described that members of the care team in a variety of positions, if they raised awareness of something not working, whether it's an outcome or whether it's a glitch, there was, number one, it was difficult to get an audience. And when you did open your mouth, she cited examples of where there was retribution against a whistleblower, a complainant. This speaking up and speaking out was a program that they put in place, kind of like see something, say something, and it was to change that. It was to encourage people to speak up when they see something wrong.
Was this because there was a culture of retaliation and retribution previously?
Yes, sir.
You know how leading culture conclusion?
On both instances.
If you could repeat your answer just in case.
Yes, there was she spoke of a culture of retaliation and retribution.
Against internal employees?
That's correct. Anyone who spoke up did so at significant risk.
If we could advance to the next page on page 6, please. Here, Ms. Green or Ms. Franklin references multiple town hall meetings. Do you see that reference in the last bullet point?
I do.
Have you had the opportunity to review some video of those town hall meetings?
Yes.
What were acknowledged as several of the hospital's failures in those town hall meetings?
So the town hall meetings were hosted by Dr. Sowers, Kevin Sowers, who was the interim CEO that followed Dr. John Ellen's departure. And he was very candid about where they were falling short and basically promising to do better. He acknowledged that their shortfalls in governance were, I believe the term was, substantially contributed to prior lapses in care. He talked about why they got the IJ, what was involved, and how they needed to turn things around. He characterized at one point that Hopkins let us down. And I think he was speaking for the Johns Hopkins All Children's Hospital community when he made that statement.
You threw in the middle of that IJ.
Yes, sir.
Define what that acronym is, just in case.
Again, I'm sorry. Immediate jeopardy. That's the financial death threat that I referenced earlier.
All right. If we could advance to 2818A, beginning at page 069, please. Yeah, first one, first page. If you'll just zoom out so we can see the whole page, please. All right. Now, am I correct that this is the form 2567 that was discussed earlier?
You can see on the bottom left, it says Form CMS 2567. Yes.
So this would be the document that CMS speaks to the hospital through about where the deficiencies were noted.
That's correct.
And am I correct that in the left column, on some pages you'll have more description of the deficiencies, but in the right column you'll have the hospital's efforts to correct their deficiencies?
That's correct. So the left side is where they cite in the first column, they cite the specific standard or condition of participation where the hospital is not in compliance. In the wide column to the right is where they will describe, this is the standard, this is what we saw, this is where you're not meeting expectations. And it tends to be fairly specific. To the right of that, the broad column is where the hospital writes in their plan, their corrective action plan to address that specific element of the shortfall.
And Mr. Reyes, if you would, there's two bullet points there on the right in the right column. If bold text, if you could just pull out the bold text for each of those so we can focus on those. All right, so this first bolded bullet point speaks to the organization as it related to the risk management department. What did you learn about the failures and the ways that the hospital integrated risk management into their division level operations?
So this points out that risk management was not included in the process. And
further down in that paragraph, it references, before that bold bullet point, it says the JHATCH functional org structure chart, was updated to reflect the relationship of the MEC. What is the MEC in this reference?
Medical Executive Committee.
All right. So
and they oversee the medical staff.
And so it was, at this point, having the deficiencies been noted, the org chart was restructured so that risk management was properly reporting to or talking to the MEC, medical staff, the president, the board. Is that right?
That's what it indicates, yes.
And then the next bullet point, if you'd read that to yourself, about no evidence of risk management reports. Mm-hmm. And describe to the jury, please, what kind of failure that indicates.
This was very surprising. It indicates that over 15 months prior to the survey, that there was no demonstrated effort to track and trend what was going on in the hospital in terms of quality. I think Dr. Perno and Dr. Napolitano both talked about tracking and trending as the key function of the risk management committee, which is different than the risk management department. And if you're not collecting data and if you're not sharing data, it's impossible to do that. So the idea of tracking and trending is if you notice something that starts to go off course, you push it back on course before it drifts way off course. So without the tracking and trending, there really were no guardrails effectively.
If we could advance to page 72 of it's 3 more pages. Next page. And the top, that's perfect. Read that first bold bullet point to me, if you could.
Starting with according?
Yes, sir.
You want me to read it out loud?
No, I just want you to read it to yourself.
Okay.
And explain to the jury the significance of adverse medical incidents residing with the risk manager and not being elevated.
Right. So adverse medical incidents covers a variety of harms that occur in the hospital impacting mostly patients. And so it looks like those harms or adverse medical incidents got to the risk manager, but again, they weren't shared. And they weren't shared up to leadership. Jackie Crane was over the risk management department until her departure. And there was no portal until after corrective action was put in for these to be shared at a system level. So, I mean, it's metaphorically, it's the equivalent of just being stuffed in a drawer.
And you mentioned there Ms. Crane, who was senior counsel.
She was.
And when these issues were finally discovered by the federal regulator, was she removed?
She exited at the time that Dr. Ellen exited.
Now, this document is quite detailed, and the jury will have at least 16 pages back there, so I'm not going to go through every specific deficiency. Let's move to 2819. 2819A, excuse me.
I was ready.
A is the redacted copy. It has Mr. Hunter's email address removed from it.
All right, so here we have an email from Ms. Green, January 16th, even before the CMS letter was delivered on January 31st, correct?
That's correct. This is dated January 16, 2019.
And it's addressed primarily, or at least first, to Mr. Sowers, the interim CEO?
Correct.
All right, and then she attaches, let's go to page 2 of this, please. She attaches the hospital's anticipation of what's coming and how they're going to rectify the situation. So let's go to page 3. And we've seen these terms in, let's say, federal regulatory agency speak, but here they are in the hospital's words. So we're just looking at the focus area of governance and the two primary findings there. Would you speak to those? Let's start with over-reliance on department-level case review. Would you please explain what that means?
Right. So recall that the Department of Pediatrics had 15, and at this time I believe they had actually 20 divisions reporting up to it. So the Department of Pediatrics, which is pediatric medicine, managed 15 to 20 different divisions, and then the Department of Pediatric Surgery managed all of the surgical subspecialties. And so they in this governance structure, they created parallel systems for quality assurance and performance improvement. And so, again, they were kind of left to police themselves.
And the second one there, issues did not flow freely to the board. You've spoken about that a little bit earlier. Is there anything to add?
No, again, if the board is accountable. If something goes wrong, the board has its feet held to the fire. But as we've seen elsewhere, if the information is not flowing in and they're not able to pull the information up, they can't do their jobs.
And then we get to the second focus area, which is culture. And it references the fear of retribution with speaking up that you mentioned earlier.
Yes, sir.
Well, how does hospital culture manifest at the patient level?
So,
Objection, Your Honor, beyond scope calls for speculation.
Overruled.
So culture starts at the top, and one of the elements of just culture, which is actually a formal program, one of the elements is that you really want to think about what's best for patients. And it acknowledges that mistakes can be made, and it tries to differentiate between I made a mistake or I knew it was wrong and I did it anyway. The focus on culture as the patient sees it, that's really the patient experience. Are my needs being met? Do I feel like I'm being listened to? Are people advocating for me? Maya was 10 years old, celebrated her 11th birthday at the hospital.
Let me interrupt you for a question before I get an objection.
Sure.
You mentioned an advocate. What is the concept of a patient advocate within a hospital?
Well,
Judge, you want to be on scope?
Overruled on that one.
A patient advocate is somebody who is keeping an eye on all the moving parts. There's a lot of focus on what the doctors do, appropriately. But there's an awful lot of people that have to do their jobs well if that care is going to hit the target. And so an advocate is someone who is kind of watching all the inbound aircraft and making sure that they're aligned for what's best for the patient.
Is it true that a patient advocate would be someone that would be present with the child over the course of their admission?
Leading.
Not side by side. I'm sorry, Judge.
I'm going to sustain the leading.
Have you observed the different, and had an opportunity to watch the testimony of the different witnesses that the defense presented here?
Many of them, yes, sir.
Did at any point you see someone who claimed to be the patient advocate for Maya Kowalski?
Objection, Your Honor. Relevance calls for conclusion. Calls for argument.
Overruled.
Somewhat surprisingly, no. We heard a lot from members of the teams, the medical team, the social work team, the risk management team, and there was a lot of team management talked about in how Maya's care was delivered. But I don't recall hearing from anyone that was really playing guardian angel, somebody who was really looking out for Maya and her care.
If we could advance to page 5. And this is the last one we'll speak to in this hospital presentation. Disclosure and communication with families. And then it says inconsistent practice and documentation after adverse events. Would you please explain this concept in the context of hospital management and the importance of communication with families?
Objection calls for argument and for a narrative.
Overruled. You can answer.
Thank you. So I tell my doctors and my team, when I was in the role, I told my doctors and my teams, if you make a mistake, own it, just like I tell my kids. So disclosing, hey, we made a mistake, is considered an important first step in communication and regaining trust that can very easily be lost if a mistake is made or if outcome is not what everybody intended to get. So inconsistent practice means that there was no endorsed or encouraged best practice for all of the divisions and ultimately the departments to follow.
Through your observation of the testimony here, including that of Dr. Jennifer Katzenstein, has it come to your attention that Jack and Beata Kowalski attempted to communicate their concerns with the hospital?
Objection, Your Honor. Based on province of the jury's calling for editorial comment on the testimony.
Sustained.
We can take that down. Based upon your background training experience and to a reasonable management probability, do you believe that the deficiencies that we've discussed here caused or contributed to the patient experience and the harm done to Maya Kowalski?
Objection, foundation.
Overruled.
Without question. The gaps in the function of the governing body. Again, Dr. Sowers said it was a contributing factor in previous lapses. I have no reason to counter that opinion. It's undoubtedly true that they contributed.
All right, nothing further this time.
Now Mr. Hunter has cross. And
Mr. Hunter, are you
going to try this?
It's not me.
Lots of nerves on the defense table. I had a smile for Mr. Whitney. That was great work, Mr. Whitney.
Good afternoon, Dr.
Good afternoon, sir.
You were provided a number of documents regarding various surveys, correct?
I saw several documents that involved surveys, yes, sir.
Were you given a set of documents regarding a Joint Commission triennial survey from September of 2015?
I saw the summary of it, yes, sir.
That resulted in the Joint Commission accrediting the hospital, did it not?
In 2015, yes, sir.
All right. And that accreditation was good for the following 3 years unless it was revoked, correct?
That's correct.
All right. And did you also see a survey, and incidentally, these surveys are fairly arduous events, are they not?
Typically, you've got 3, 4, maybe 5 surveyors on site for 3, 4, or 5 days, yes, sir.
When you were at Brandon Regional Hospital, did you handle those?
I was absolutely involved in every day that they were on site.
Very searching review, correct?
They were stressful, yes, sir.
All right. They went to all aspects of the hospital, correct?
They did.
All right. So when they did that at Johns Hopkins All Children's Hospital in September of 2015, they reaccredited the hospital, correct?
Yes, sir.
And then in 2016, they did a follow-up random review. You saw that, did you?
I don't. Could you refresh my recollection on that, sir?
Sure. Wasn't there in March of 2016 a follow-up review of evidence of compliance with the accreditation they had been granted the year before, in March of 2016?
Improper way to refresh recollection.
Right. If you're going to refresh his recollection, why don't you show him the document?
Let me get that pulled up, Judge. Let me ask a couple questions first before I do that. Excuse me.
Okay, so this Mr. Hunter has the benefit of knowing all the files that were in those boxes.
You were present during Ms. Green's deposition the other night, right?
I was there. Yes,
and
sir.
Were you provided a copy of the review done by the Joint Commission in March of 2016?
Mr. Hunter, I can't say with certainty that I was. It was Parents' Weekend at my son's college, and I was up in Gainesville. So I played dad instead of expert witness this weekend. I can't tell you which documents, off the top of my head, which documents I saw and which I did not. I certainly did not see but a small fraction of what was turned over.
Okay. Well, did you see a risk management survey that was done by ACA in February of 2017?
Again, I'd like to have my recollection refreshed. I don't recall which ones I've seen and which I didn't see.
Did you see?
Just hand them the document if you...
Judge, I'm sorry that there's a stack of documents that would gag 3 billy goats and a maggot about this tall.
I don't understand what that means.
Well, it's a lot of documents. And I don't have at my fingertips the ability to grab that particular document.
3 billy goats and a maggot.
Do we need to take a few minutes so you can organize?
It would be very helpful, Your Honor.
Why don't we take 5 minutes? Members of the jury, do not discuss this case amongst yourselves. Do not do any investigation and receive no information. All rise.
Okay, by a show of hands, has anyone heard the 3 billy goats and a maggot saying before? Is that a thing? Or is that just Mr. Hunter? There's a stack of documents that could gag 3 billy goats and a maggot. Show of hands in chat. If that's this is in your regular vernacular. I'm not seeing any hands.
The jury is out of our presence. Doctor, you're in the middle of your testimony. Do not discuss this case with anyone. Mr. Hunter, do you need 5 minutes, 10 minutes? How much
10
time?
minutes would be fine, Judge.
I'm sorry?
10 minutes would be better, Judge.
Okay, we'll be back in 10 minutes, but remember we have timing issues with the witness, so...
Yes, sir.
Okay, 10 minutes.
Okay, I don't know what that means. The judge said he didn't know what it means. But billy goats will eat anything, and I guess maggots will eat anything the billy goats leave. We'll once again, Mr. Hunter comes out with first he buried Dracula years ago, and now he's got 3 billy goats and a maggot. So, way to go. This is interesting. Okay, so what we have Mr. Hunter doing right now is he has the benefit of knowing everything that was in those 2 bankers' box worth of documents that were turned over to the plaintiff. That he knows the plaintiff has not had time to go over yet, and he knows this witness has not reviewed yet. So he's drawing out all the good documents that were in there and saying, did you see this one? Did you see this one? Did you see when we passed this test? Did we see when we got this gold star on our forehead? Did you see this? And he's going through all that process. He doesn't want or doesn't need to have each of these documents brought up and set in front of this witness and have him cross-examine. He's not going to burn the time on that. He wants to get as many of these out in the gotcha moments with this witness as he possibly can. Did you see this one? Did you see when this agency did this? Did you see the one in February? What about the one in June? And he's going to have to say no. And this witness did a great job. He's like, look, I was dad over the weekend. I was not expert witness. By the way, I'm getting paid $0 for doing this. This is all pro bono. And so he says, I was my son's game. Okay, and you guys dumped, finally, at the last minute, a truckload of documents. And I've only seen a handful of them, and I can't tell you off the top of my head. So I don't think it's going to work the way that Mr. Hunter thinks this is going to go down. Gil says, Dr. Corcoran's metaphors versus Mr. Hunter's metaphors in this trial in a nutshell. See, Jules is calling right now. Let's see if we can bring her on the line here.
From Jules.
Jules, we got a little break here.
Or high five, Nick Whitney. I love you. You knew this was going to happen.
Hey, Jules, are you there? Jules, are you there? Okay, we might have a hot mic from Jules as she's high-fiving Nick Whitney. Jules, can you hear me?
I'll absolutely do that for you.
Okay, I'm gonna drop the call because I don't think she meant to call us there. A high five from Jules. It's an honor to be butt dialed by Jules. Really, I mean, to be by anybody. I mean, so at least at one point they were thinking of me on their phone, and now they called again. So we'll see if she calls back. All right, judge is making him work. Yeah, the judge is. Wants him to follow through on the step he's taken. He's brought it up and said, hey, did you see this one? And the witness is like, I don't remember. Refresh my recollection. And the next step is to refresh his recollection. Is to hand him the document, give him a moment to review it, and say, oh, yeah, I remember. Yeah, it rings a bell now. Yeah, ask me your question. Or have the witness alternatively say, nope, this one's all new to me. I didn't have a chance to look at this one yet. Either way, Mr. Hunter doesn't need that second part. He just wants the first part where he says, what about this document? What about this document? What about this document? And so the judge is sort of calling his bluff a little bit on this and saying, I'm not going to let you just, run roughshod over the witness with all these documents, because he knows the plaintiff has had no time to go over these, that there's pages and pages and pages, boxes of stuff this witness has not seen. Let's see, quick recap. Picky, what we have right now is the plaintiff is just questioned on rebuttal, so using some of their time. And Mr. Whitney used 37 minutes of their hour and 20 minutes they have left, right? So he used 37 minutes of their time getting rebuttal testimony to what the defense raised at the end of their case, where they had Mr. Anderson, their witness, testify that the hospital was doing great from a management perspective, from an oversight perspective, that they were wonderful. That triggered this big, huge. They triggered the deposition that happened over the weekend on Friday. It triggered a huge document dump. The judge was very angry. He ordered a lot more, at least one more document that was not provided. But it triggered all this, and now we've got a flurry of motions. All right, we have a motion from the plaintiff to sanction the defense. Okay, it's like 30 pages of sanctions or something against the defense. We have a motion from the defense to sort of put all this in perspective and say, but don't sanction us because it wasn't relevant. And so all this is happening. The judge is going to rule on those later. The sanctions, they may still happen. That'll happen later. The directed verdict, which the plaintiff has asked for, basically saying, Judge, because of all this, because of what's come to light, because of what they didn't provide, we would ask you to just rule right now and tell the jury, don't worry, jury, I've got this one. I'm going to check the box for you on this charge. The judge has set that aside as well. I'm going to delay that. I'm going to talk about that later. I'm reserving my right to rule on the directed verdict. So directed verdict and sanctions comes later, maybe even later today. But in the meantime, we're going ahead. And we're going ahead with all 12 of the jurors. We still have the juror number 1 who's sitting there that the defense has filed a motion saying he needs to be kicked off the jury because he's biased and he broke the rules. He's formed an opinion, he's expressed it. That discussion happens tonight after the jury goes home. But in the meantime, this juror, even if he does go home, he's got one more chance. He's got one more chance to ask some stellar questions, and he doesn't know. This juror does not know that he's even in discussion. They haven't seen any media reports. But there's one more chance for him to ask some questions of this witness, specifically relating to this IJ incident, this immediate jeopardy finding that the hospital had some serious problems that were systemic throughout the hospital, all the way up to management. So bad that at least 5 heads rolled when this came to light. At least 5 top people, chop out, new people in. Big things. Mr. Whitney has expertly used the hospital's own words, their own emails, and it would normally be hearsay, but this is a statement by an adverse statement from a party opponent, basically confessing to something, and you can use that. That gets around the hearsay rule. So we have their emails saying, here are our talking points for the president of the company. I think it was the president, I forget his name, or the acting president, to use to say, here's how we're addressing these major problems. And he gets to use that's from the top, admitting the problem, and here's how we're trying to fix it. So he did a great job. I can see why Mr. Whitney wanted to go ahead with what they had right now without stopping to tear through everything. Mr. Hunter sort of wishes they had torn through everything, but it's not going to happen. Anyway, this is spicy. This is good. This is the moment that we were waiting for, and Mr. Whitney did a fantastic job. He just admitted he can't find the documents himself. Yes. That was really good. Let's see. The court is not letting Mr. Hunter testify. Hey, little guy, how's your hand? Doing okay? It's numb. Are you going to be able to play the iPad? Sort of. Yeah. My youngest son loves to cook ramen in the microwave, and he spilled some on his finger after he cooked it in the microwave, and now he's on your hand. Sorry. So he's getting treatment for that, and he wants to now play the iPad. So, and his hand is good enough to play the iPad. So no blisters, not a bad burn, but it's an owie, and to him it's very big. All right. I don't think he used the riddle correctly. The moral of the story is the 3 billy goats gruff, never be greedy. Yes, so Auntie Candy. Mr. Hunter he said there's more documents, enough documents to choke 3 billy goats and a maggot, which, yeah, we'll just leave that there. All right. Even if juror number 1 is kicked off, he has contributed so much to this trial. Yes, he has. Great questions as well. Gaming comes before injury. Lavender oil. We've got lidocaine aloe vera right now. So we're taking care of that. So the billy goats are basically up to your neck in, and the one maggot added is the straw that broke the camel's back. Valkyrie, are you saying this is a saying? That's a thing? And where did that come from? I mean, if you Google it, can you find anyone in the history of time, at least recorded time on the internet, having used that saying before? I heard of gag-a-maggot. That's like something's really disgusting. Thal, my friend. Thal, good to have you here. Long time no see. Welcome. Let's see, the juror can just go home and watch. Once the juror is dismissed, Kathy, if the juror is dismissed, and I've put on record that I think he will be, I'm in the minority, and all the legal minds that know better have said no. So I don't know. I may be right, may be wrong. But But if the juror is dismissed, it's a full dismissal. Judge is back here, so we're going to start in just a second. And the juror at that point could go and talk to the press. If he
Yes, sir.
Ready to go?
Yes, sir.
Let's bring back the jury. Yes.
I don't think the judge was happy about this delay, by the way. That Mr. Hunter is not ready and saying he can't find the documents. It's not lost on him that the plaintiff has the same duty to dig through, not knowing what's in there, to find documents. Kenny, that's probably the case. She was calling and then probably talked to somebody and wasn't able to talk. She might have tried to hang up and wasn't able to.
Please be seated, everybody. Members of the jury, I want to confirm while you're away, you did not discuss this case amongst yourselves. You did not do any investigation and received no information. Is that all correct?
Correct.
No one approached you about this case. Is that correct?
Correct.
And you didn't see any media coverage. Is that correct?
Correct.
Mr. Hunter?
Yes, Your Honor. May I approach the witness?
You may.
Dr. Corcoran, I've got a accreditation report here from March of 2016. You ever seen that before?
I don't believe so.
Okay. So, you've never reviewed what I just showed?
I don't believe I've seen this particular report. Yes, sir.
Your Honor, may we approach for a moment?
Sure.
That's an objection right there. It's going to be made in the presence of the judge at sidebar. Mr. Whitney's going to argue this, basically saying, look, we came in here shorthanded. All this dumped on us Friday night. There's 2 bankers' boxes of stuff, not digitally provided, but physical copies provided. And now he's going to beat my witness up for not knowing what was in there. Chrissy, yes, today's been a spicy day. It's been amazing, and we're right in the middle of it right now. Mr. Hunter's going to continue.
So the jury's aware you were provided a number of documents, or you attended a deposition Friday night.
I did.
Okay. There were a number of documents that you got to see as a result of that, correct?
Yes, sir.
Okay. The one I just showed you, you said you'd never seen before.
I don't recognize it. It may have been introduced, but I don't recognize it.
Well, my question to you is, do you have any reason to question the proposition that in March and April of 2016, a joint commission survey occurred unannounced at All Children's Hospital and their accreditation was affirmed?
Objection. Counsel testifying.
Overruled. You can answer.
I'm sorry, can you repeat this question, please?
Yes, sir. Do you have any reason to question that in March of 2016, followed up in April of 2016, a joint commission survey took place at Johns Hopkins All Children's Hospital and that their accreditation was affirmed?
So I have no reason to question you, and that if accreditation was renewed in 2015, then unless there were a flagrant violation, accreditation would not really be on the table at that time.
Well, wouldn't there be occasional random follow-ups to accreditation inspections?
Short answer, no. Most of the time, Joint Commission returns to a facility in response to a complaint or awareness of some kind of a problem.
So you've never heard in your long experience of random surveys taking place after an accreditation in the preceding years?
Objection. Argumentative.
Overruled.
There can be follow-up surveys. When the accreditation survey is done, then CMS actually audits the work of the Joint Commission and will come in and do, I'm blanking on the term for it, but they will basically come in and affirm that the Joint Commission survey is accurate.
Okay. The document I just showed you was a Joint Commission survey, correct?
I believe so, yes, sir.
Okay. And you have no reason to question that it affirmed the accreditation?
Well, don't think that was in the time frame. Typically, CMS comes back in 45 days or less. So I don't think that's the kind of survey that I was referring to, sir.
All right. Well, let's go with this another way.
May I, if you'll show me the document, I'm happy to do a quick review of it.
Well, I'll be happy to show you this and the two subsequent follow-ups from these complaints.
Thank you, Barbara.
Just the three, or is that it?
This is a different one.
Okay. Can you give me a minute to look at them?
Sure.
Okay.
Perhaps, Mr. Hunter, you could return to the lectern.
Perhaps, Mr. Hunter, you could return to the lectern. That was a get out of the witness's face. And that was very nice. Get out of the witness's face. The judge is fuming. He is furious. He's being quite respectful in his words and his tone, but you can tell that he's mad even that Mr. Hunter had to take 10 minutes to find these documents. He is not happy, and I think sanctions are definitely on the table.
So on the survey done March 7th, which was unannounced by the Joint Commission, they found elements of performance where there was insufficient compliance. Social work consult for a patient on suicidal precautions was not performed until approximately 9 hours after. There was another element of insufficient compliance that related to utilization of moderate or deep sedation or anesthesia.
And were there, were there indications of a follow-up that established compliance?
I'm looking for that in the next visit, sir. You just want to match up the ECLD. So this
got to bring in more dirt.
Visit that was approximately a month later is a survey addressing different elements of participation, different standards.
And it indicated compliance.
This shows compliance. This still has some outstanding issues.
And then there's a subsequent that shows that was placed in compliance, correct?
1 second, sir. So this survey dated 4/22, which is the 45-day evidence of standards compliance, does show compliance with the anesthesia-related fallout, but not the leadership one. And this one,
on Hunter.
dated May 3, the 60-day visit, does show LD 040105 is now compliant. So from March until May, they had issues and they corrected them.
And that's fairly typical of Joint Commission surveys, is it not?
Yes, sir.
Happened in your hospital, didn't it?
Many times.
Okay. And incidentally, there's a number of ACA inspections of your hospital, correct?
ACA is a frequent visitor to most hospitals, sir.
Okay. Frequent visitor to Brandon Hospital, correct? For complaints and otherwise.
I will tell you, during my tenure, they were frequent but not overwhelming.
Now, isn't it also true, sir? Well, let me just ask it this way: you were given a report of an unannounced accreditation survey by the Joint Commission of Johns Hopkins All Children's Hospital in August of 2018.
Unannounced in August of 18. Wasn't that when they had their re-accreditation visit?
Yes, sir. Yes, sir.
And there was a second visit?
Yes, sir.
The same month?
Yes, sir.
I don't believe I saw that one.
Okay. But those visits resulted in reaccreditation, did they not?
Not the second visit. That's not a reaccreditation. They were reaccredited in August of 18,
okay,
but that was their triennial review. Yes,
okay,
sir.
So the point I'm making here is that in August of 2018, there was a triennial reaccreditation survey done by the Joint Commission that resulted in reaccreditation, correct?
Right, and all of the violations were on the safer matrix in the lower, less frequent quadrant.
That's where you want them, right?
Amen.
Okay. So in August of 2018, the 3-year accreditation that was issued in September of 2015 was continued, correct?
Somewhat surprisingly, yes.
All right. Well, editorial comment aside, it was continued, correct?
Well, again, given the presence of ACA Joint CMS starting in April of that year, yes, they got away with a remarkably benign evaluation,
okay,
and it was, in fact,
and it indicates effort on their part to do that, correct?
Okay.
Incidentally, were you provided information regarding a CMS survey of all children's in May of 2017?
Again, can you show me the document? So
Sure, I'm showing
refresh?
the witness trial exhibit 2823-001 marked by plaintiff.
This witness can just ingest
Yes,
new
this was a
information.
visit specific to the pharmacy.
Showed compliance, correct?
I believe there were no issues identified on that visit.
Okay. Now, let's talk for a minute, if we could, about some of the reports that counsel walked you through. Let me first direct your attention to trial exhibit 2811. You could put that up for me. I'm not sure we need to see the details of it, but
family loves.
Was there any indication in that report, and you reviewed this, right?
I did. Okay. This today.
Okay.
Yes, sir.
You testified about this a few minutes ago.
I did.
For counsel.
Yes, sir.
Okay. So, were you aware of any Joint Commission survey of the hospital being done at the same time or around the same time as this particular report?
I'm struggling to answer clearly because there were so many surveys. Candidly, Mr. Hunter, keeping ACA from CMS is a challenge given the short timeline and my cursory review of just a part of the documents that you shared.
Well, let me show you what I'll represent to you as a Joint Commission correspondence to Mr. Sowers dated February 25th, 2019. We ever shown that?
Yes, this is a letter that documents the acceptance of the conditions of the plan for corrective action from the IP. Is that correct?
I believe you'll see
from the IJ. Sorry, the immediate jeopardy.
I believe you'll see that indicates that there was a survey done by Joint Commission at or about that time that resulted in a finding of compliance.
Yes, the services at your hospital were found to be in substantial compliance.
Okay.
That was a joint commission survey that occurred, correct?
And that was done 1 month after, or 23 days actually, after the IJ. And 23 days is kind of that magic window that if you're not in compliance by then, you are at risk for losing your funding.
I'm glad you brought that up. So the IJ was issued by CMS, correct?
Correct.
All right. This is the Joint Commission.
Right.
They're not the same thing.
They're not.
Okay. So the Joint Commission found that there was substantial compliance, and the CMS was in the process of following up on the IJ, correct?
So it gets even stickier because the CMS surveys are typically handled by ACA surveyors.
Okay. Well, whoever was doing that, they lifted the IJ at about this time, February 25th, did they not?
They lifted the, no. What they did at that time was that they accepted the corrective action plan. The IJ threat was still in place until, I believe, late May or mid-June of that year. And in fact, the hospital requested and was given 2 extensions to comply, and then ultimately had signed an agreement, a binding agreement with the federal government that it would accept having a consultant in the facility for the next 12 months who would oversee or direct the compliance, and in exchange the federal government takes the threat of losing funding away.
But the IJ was lifted.
Again, they accepted the plan of correction.
Hunter needs to sit down.
And lifted the IJ as a result, correct?
No, sir, because again, they were still under threat of being removed from funding until late May or early June.
But at that point, the IJ was ultimately lifted, correct?
At the end of June, yes. I'm sorry. I thought you were asking about that February date.
All right. So we can agree the IJ was lifted.
With an asterisk because of these extraordinary.
And we can agree that there was substantial effort put forth at compliance.
Oh, absolutely.
All right.
The new team actually did well.
Okay.
They worked hard.
Well, let me come back to that in a minute. In this 2811, where is the reference to nursing service?
This survey was conducted in conjunction with a risk management survey.
Okay. That's all? Just risk management?
From what you're showing me, yes, this is a risk management survey.
All right. Where is the reference to risk management activities in the fall of 2016?
There's nothing specifically mentioned about 2016 in this unannounced complaint investigation.
Okay. Now, there was talk about trial exhibit 2815. Let me ask you to get that up if you could, Clay. And you talked about 4 areas that it addressed. And this is the announcement of the IJ in January of 2019, correct?
January 31, 2019, yes, sir.
Okay, and that's January of 2019 is about 2 years after Maya Kowalski was discharged, correct?
That's correct.
All right. Now, in this statement of the grounds and the findings that are based on the IJ, with the basis for the IJ, where is the reference to the nursing service?
It's not in this letter. It's in the CMS 2567.
By all means, do you have that handy?
No, sir.
Okay. Well, in this letter here, is there anything basing the action on the hospitalist service?
Medical staff.
Medical staff in general.
Right. No
specification to the hospitalist service.
Not in this letter. Again, this is the overview, not the detail.
Okay. So the detail is in the 11119 form.
2567.
2567 in the lower left-hand corner.
Yes, sir.
Okay. So you looked at all 100 and some odd pages of this?
I did not see the version with the corrective action plan. I looked at the original document, which was 49 pages.
Okay. And I may have that in my hand, too. I just can't tell the weight of these things.
Fair enough.
But I was curious, in looking at this document, did you see any specific reference to the PICU intensivist service?
The intensivist physicians were not specifically mentioned. No, sir.
Nor were the hospitalists, correct?
To my knowledge, no, sir.
All right. And you didn't see any reference to the pain management service either, did you?
No, but again, the issues that were cited are the ones that support them and also oversee them.
Right? They oversee them, but we're talking about them themselves, the people.
Yeah, and it's
not
unusual.
The structure of the people.
I understand your question now. It's unusual for specific physicians or specific medical groups to be identified in these kind of surveys.
And in that survey, did you see any reference to what was happening on the 7th floor, the medical surgical unit, in October of 2016?
Well, again, no, because the survey is not geared to follow specific physicians, physician groups, and their individual practices. That's a job that falls to the medical staff led by the MEC, and that's what was called out here. So more.
But there's specific examples given for most of these things, and so what I'm trying to find out is, did you see in this report, in the original report that put in place the IJ, or was the basis for what was put in place as the IJ? Did you see any reference to the events of October, November, and December of 2016?
Specific to those dates, no, sir.
And you saw no reference to the psychology service specifically, did you?
That's correct.
And you saw no reference to the psychiatry service, did you?
For those dates, no, sir. You're correct.
Now, there was reference to your discussion of Trial Exhibit 2817. A. Excuse me. See, she does it to me too.
A's the redacted copy. If they show the wrong copy, it's a big problem.
It sounded to me like you were saying that the problem, or one of the problems addressed here.
Can you put that document up, sir?
Oh, sure. Can we put that up? I just got a couple of questions about it.
Sure.
First of all, it indicated they were working to improve the situation, right?
Yes.
Okay. And in some of the documents you made that we were referenced here, specifically 2821A, you weren't asked about that one.
I don't recognize it by number.
2821A in evidence. You can put that up. Well, let me finish. It's too quick for me. Let me just ask you, first of all, before we leave 2817, it sounded to me like what you were concerned about in this document was the extent to which risk management was not reporting upward.
That was one of the talking points that they developed for the interim CEO to address with the board.
And they were trying to...
Was sharing of information, correct.
Okay. So information wasn't getting shared by risk management, right?
That's the inference from their talking points.
All right. So let's go back, if we could, to what I was referring to a moment ago, 2821. This is a letter dated 10 February 2019 regarding the statement of deficiencies, right?
Yes, sir.
Okay. And this letter indicates, does it not, that efforts to address what later became the basis for the IJ had already begun by the time of the inspection, correct?
That's incorrect. This is February 10 of 2019. The survey was 10 days earlier. This is the response to it.
Understood. This is the response to the inspection report from January 7th to January 11th. And this was on time, submitted within 10 days, correct?
From the January 31 report back, yes,
right.
sir.
And this letter summarized efforts that were being made to address the IJ concerns, correct?
It does, and as I said, the new team actually worked really hard. It was too late to help Maya, but this was good work.
It was, the new team was already in place by the time of the inspection, correct?
They were assembling. I think Ms. Green actually took her role 3 or 4 days before 12 surveyors arrived. But yes, sir, they were assembling. They were mustering.
Well, the executive team was already in place and already addressing these concerns by the time the inspection team arrived, correct?
I can't speak to the entire team. They had 8 departures in leadership, so I don't know that all 8 spots were backfilled, but I do know that there was an interim CEO in place. Regarding the other 7 positions, I have no idea when they were filled.
You've shown us his talking points and the efforts that were being made to address the situation, correct?
Following the survey, yes, sir. And he was also one of the, per Ms. Green, he was also one of the attendees at the visits to CMS in Atlanta and ACA in Tallahassee.
They have a moment, Your Honor.
You may.
Is he done? Is that the best he could do, was ask a question and end up getting more bad information brought out about the hospital?
That's all I have. Thank you, sir.
Whoa! Whoa!
Mr. Whitney.
Since your weekend plans are now in front of the jury, you went to the Florida football game on Saturday.
You didn't have to remind me, sir.
I thought the black uniforms were going to work, but no.
Oh, well, we lost.
All right.
That's all I'd like to say about it, sir.
Sure. And you spent Friday night with me and Mr. Hunter at a deposition of Ms. Green.
I did.
And how long did that last?
We sat down at about 4 o'clock. I want to say we left the building somewhere 7:30, 7:45.
Before that deposition, had you ever seen the first corrective action plan from Johns Hopkins All Children's Hospital?
Not to my knowledge, no.
And just so that your diligence is not in question, first of all, we left with a stack of papers, did we not?
A box full, yes.
Thank you, Your Honor. Relevance to be honest with you.
Overruled.
We left with a box full of papers.
Yes, sir.
And you did not spend your weekend reviewing everything that was provided on Friday night, did you?
No, sir. As I said, I was a dad this weekend.
And then 2 more boxes were provided to us over the weekend.
That's what you told me, yes, sir.
So the fact that you haven't seen a particular survey is not a reflection of your diligence, is it?
I hope not.
Okay. Now let's talk about surveys. That's what they are, right?
They
survey?
are. They are.
And these folks that come from whether it's the Joint Commission or CMS or ACA, they're in their hospital for what, a week?
They can be there. Typically, they run 3, 4, or 5 days. Now, a complaint survey can be in and out in a matter of hours or a day. But when they're full surveys, they're multiple days with multiple surveyors. And typically what they'll do is, for an accreditation survey, for instance, they will bring an engineer to look at the heating and cooling, to look at all the mechanicals of the elevators. They'll bring nurses in to look at nursing things. They'll bring in pharmacists to look at pharmacy things.
The short answer is they're there for a brief period of time in any hospital during a survey.
It feels like forever, but they're typically there for 3, 4, or 5 days.
All right.
And with the CMS survey that was done January 7th through the 11th of 2019, my understanding is that there were 12 surveyors.
All right. In the intervening 3 years between an accreditation or reaccreditation, the Joint Commission folks or the CMS folks or the ACA folks, they don't live at the hospital, they don't reside at the hospital, they're not there every day, right?
You try to keep them at bay.
The system, as it is reliant on self-reporting, is it not?
It's encouraged, for sure.
It's reliant on the hospital that's being evaluated being an honest actor.
Correct, and there are some specific fallouts that require timely notice. For instance, an adverse event requires a Code 15 filing if it's severe enough. And so that needs to be, Tallahassee needs to be notified ASAP.
And in this instance, was it discovered that Johns Hopkins All Children's Hospital was not self-reporting adverse events in a timely fashion?
Objection, Your Honor. Be honest to it, Rolling.
I'm going to sustain that one.
Understood. This was all the genesis of an eventual self-report by Johns Hopkins All Children's Hospital, right?
Objection, leading, Your Honor.
Overruled.
The survey that ultimately led to the IJ, which was backdated to 4 or 5 months earlier, did involve self-reporting.
What drove that self-reporting?
Objection, Your Honor. False speculation by the witness, like foundation.
Overruled.
There were several issues at the hospital that were well documented by local press that actually ended up being a finalist for the Pulitzer Prize for investigative journalism.
Objection, Your Honor. Move to strike, not responsive.
The jury's going to disregard the comment about the Pulitzer Prize.
Sorry, Your Honor.
Could we approach, Your Honor?
I'm done with that line of questioning.
They're going to approach anyway.
Having observed the trial here, have you seen or heard any testimony from anyone with the title of vice president or above from the hospital to explain that they had this all under control during 2016 and 2017?
Objection, Your Honor. May we approach?
Sure.
Here we go. Now we have the approach. We'll turn the sound off there. There we go. Okay. So they're going to talk this over. The comments, the little editorial, the little ad Dr. Cochran put on there about the journalists at the Tampa Times when they ran, I think it was the Tampa Times, when they ran this article and printed it, it was like a finalist for a Pulitzer Prize for investigative journalism. That's too much. Okay, you can't go there. That was too much, and the judge sustained that. Had he not thrown that little jab about the Pulitzer Prize award-winning reporting about this, uncovering the truth, digging at the truth, there would have been no. I think the judge would not have sustained any objection against just the, that first part of the answer. But because he added the Pulitzer Prize part, it got struck. Anyway, the jury heard it anyway, which is You can't unring that bell. The jury heard it. It's Pulitzer worthy. Okay, we do need to save time for jury questions.
Objection sustained.
Looks like Mr. Whitney might be the limit of where he can go on this one. So he's used about 45 minutes on this witness. They don't have much time left.
I think I'm going to leave it there for now, Dr. Corcoran.
There we go.
Anything further, Mr. Hunter?
Is he going to try this again? Yeah.
Members of the jury, do any of you have any questions?
Yes, they have questions. Here we go. Hang on. Let's see if they excuse the jury. If they excuse the jury, I'm going to be able to hear them and bring them to you. If they don't, sounds like they're not excusing the jury. Yeah, the witness is still there, so we're not going to hear the audio. I was going to try to bring you the audio, but can't do that. Sorry. The stack of papers. Stack of papers has been brought to the judge. Judge is standing at his desk. Witness is still seated there. They have the white noise machine on. Everyone's huddled around the, as you can see there now. Everyone's huddled around as they're reviewing each of these. Be careful, number one. Yes, be careful. Now, I'd say keep doing what you're doing. I think he's being honest to himself, so. Right, we heard the papers. We want 50 questions. I don't think we have that many. I think I'd guess just from how it looked on the Zoom that we have maybe 3 or 4 at the most. Lisa, I didn't eat breakfast this morning, and my family brought me Bojangles. So I've got some fried chicken. Just finished the mashed potatoes and gravy, and I've got one of the world's best biscuits that I'm going to devour as well. Did they do anything to juror number 1 yet? Someone bloody random. Love the name. Sorry, anyone in the UK. Which you might be, by the way. They have not brought up this issue yet. This is going to happen after the jury is excused for the day. The judge is going to handle the whole motion to dismiss a juror. And so the jury's going to go home, which is sad because if they end up dismissing the juror, then that juror comes back again tomorrow only to find out he's been dismissed. So we'll see. But that's going to be happen at the end of the day today. So the spiciness isn't over. Once court ends today, when they're done with testimony, and I don't know where they're going to leave it. I know we're not going to closing statements today. Those start tomorrow now. They were supposed to be today.
Members of the jury, I'm not going to ask the question that was posed, but Mr. Whitney will ask questions, then Mr. Hunter will have an opportunity to follow up.
The 2019 immediate jeopardy finding and all of the corrective actions that were performed by Johns Hopkins Ultramar Hospital. Is it a fair, well, first of all, there was a retrospective analysis that led to this. Is that right?
Objection, Your Honor. He's leading.
Overruled.
Right. So, yes, they look at what led to the problems. If you think about it as a firefighter shows up, puts out the fire, but looks at whether the electric panel has any issues, whether there's carpet in front of a portable heater. They look for the causes of what allowed the problems to show up.
And is it accurate summarization of your testimony to say that the issues that, as they're contained in that dense federal document, surfaced as early as 2015 within the hospital?
Yes.
Objection, leading, Your Honor, and also argumentative.
Overruled on both.
Yes, there were 4 or 5 pediatric cardiac surgery.
I'm going to remind you of the instruction.
Sorry. There were 4 or 5 PAs in the operating room who had concerns.
Objection, Your Honor.
let's not go
Let me
into
ask the
details.
question. Let me ask another question.
The
Let me ask the question.
Okay.
Sorry. We're testing you. Were there self-reports at the employee level in the hospital dating back as early as 2015 of issues with patient care?
Objection to predicate foundation. Judge, we approach.
Encourage.
Okay, so the issue we have here, as he said, cardiac. We need to not talk about cardiac. That's the ruling from the judge. We're not going into that. Okay, that's where the hospital admits we had major problems. We had 13 young kids die in the cardiac unit, basically. That's my understanding of it. Can't bring that in. That's not okay. So Mr. Whitney needs to be very careful here that this witness, who has done a stellar job to this point, doesn't blow the whole thing as he walks triumphantly out the barn doors, which were opened by the defense, I might add. So we'll see. Mr. Hunter's going to object already that he said in the cardiac. We'll see if that's a problem or not. No heart issues are to be mentioned. Crazy Cat Queen. We have the depot, and I'm looking at possibly reading some of the spicy exchange between Mr. Whitney and Mr. Hunter at the depot, and narrating that for you. I would be playing both people, so I'd have to talk out of both sides of my face, and I don't know, put on wigs for one person or the other. But that's let's see. That's going to be starting, I think, at, page 216. Page 216. Let me look at the spiciness at 216. Out of 327 pages, I might add. Lots of stuff. There we go. 212, 13, 14, 15, 16, 17. Okay.
Any other questions, Mr. Whitney?
Not this time, no.
Mr. Hunter, any other questions?
No, Your Honor.
Members of the jury, any other questions from the jury? May this witness be excused.
Yes, Your Honor.
Yes, Your Honor.
Thank you, sir. Thank you for being here.
Thank you for your consideration of getting me to the doctors.
So the witness makes it out in time to go to his appointment.
Plaintiffs, any further evidence in rebuttal?
So you might have to have somebody call in.
Is the plaintiff's resting?
We're resting in rebuttal.
They just
what
rested
we're
in
going to
rebuttal.
do, members of the jury, we're going to give you probably 10 or 15 minutes. I'm going to be talking jury instructions with you when we come back. It's just going to take a while, so just steel yourself that you're going to get to listen to me give a lot of instructions. So if you need to use the restroom or whatever, that's fine. Do not discuss this case amongst yourselves. Do not do any investigation and receive no information. Let's take 15 minutes.
All rise. Jurors exit.
All right, so we have a 15-minute break. I have lunch all over my desk, so I can't show you my desk. We made it up to 1,771 objections. That's a lot of objections. Let's see if Jules is able to call it out.
The jury is out of our presence in a moment. We'll go on a break. I was going to have Mr. Reyes, you're going to be the one that is putting these up as I speak, or is that going to be Mr. Cottrell?
Your decision, Your Honor.
I just need one of you to do it. And I just need, you want it in a PDF format? Is
Yes, Your Honor.
that? Okay. So it will be re-emailed out to the lawyers in a PDF format. And so if the lawyers can get it to whoever is going to be putting it up on the public gallery boards. I'll also bring in the paper versions as well. Mr. Elegant gave us a couple of verdict form changes. I made those. I'm so sorry?
Those are the only things that we know.
Knock on wood. So let's take 15 minutes, and then we'll come back, and I'll start reading jury instructions, and then it's my intent to send the jury home after that.
I'm sorry, you say you'll have a paper copy for us?
Yes. They I think are now finished printing.
Okay.
So I will have them when we come back.
The plaintiffs renew their motion for the court to instruct the jury concerning the circumstances that unfolded this past weekend. As this has turned out, the defense has managed to pull a delay of key documents for 5 years into a methodology for getting exactly what they wanted in front of the
Mr.
jury.
Anderson, if there's something you want me to consider, put it in writing. Give me something specific. Otherwise,
I will judge you.
Okay.
So we have that coming up too.
I'll be back in a few minutes.
All rise. This court's in recess.
Mr. Anderson is still focusing on that initial document, which the judge is very well aware was not provided. It still was not. We are not done with the objection count. I know it says 1,771, and the plaintiff just rested the rebuttal case. We are not done because there's still, even though it is frowned upon and it's like sort of like bad form, there still can be objections through the closing arguments. Let me show you where we're at as far as the guesses. Let me bring on. Let's see, where is it? The other downstream here. Here we go. All right. Here's our guesses. Let's jump ahead a little bit. There we go. Let's slow it down. 17. Here we go. We'll let that play for a little bit and see how close everyone was, because we're at 1771 right now. I'm looking at reading some of this. We might do it. Let's see. Because it got spicy. It got really sort of intense. I'm trying to see when it's. I want to make sure they're just two players. Okay. I did get word that the Rob's not going to be able to recap this one tonight. Kurt is doing one, and if I can, I'll try to do a redirect to Kurt's channel. Let's see if it'll let me here. We're not done yet today. I'm just telling you where we're going tonight after we're done. Kurt, where you at? On civil law. Okay, he's got the rebuttal case. November 6 highlights. Okay, I think I've got the one for tonight. I'll redirect to the one tonight after we're done. That one doesn't start till 7 p.m. So we can go join Kurt for that. But where we're at right now, we've got a bit of a break, right? The next portion, I mean, talk about going from 1,000 miles an hour to 2 miles an hour. We're going to go. Oh, we're way past the winners. I should have paid attention. Let's scroll back and see who ended up in the lead. There we go. We're going to go. We went so fast from just spicy, huge, proverbial bombs being dropped in testimony. We went from that to, oh, look at that, Natalie O. Natalie O stands alone with the current winning amount. Great job, Natalie. We're going to see where it ends after the end of closing arguments. We'll see who wins there. All right. That being said, we're going really fast, and now we're going to go to what could be considered a boring part of the trial. I personally think it's very crucial, but it's because it's like reading the instructions to a brand new board game. If you want to play a game, if you want to play the game the right way and experience it to the fullest enjoyment you can, you probably need to follow the rules that are well thought out and prepared and written out for you. Okay, just picking up a board game and just trying to figure out how it works, that's a nightmare scenario. The jury is given a list of instructions, jury instructions that are like the board rules, the board game rules for this game of deliberation, which they're going to begin very shortly, probably tomorrow afternoon. And these jury rules are going to be read to them, and we're going to hear them. And some of them will sound very repetitive because we have multiple charges, and even though they're very similar, there are some very subtle differences that are involved in the jury instructions for what they're supposed to consider and what is included and what is not, and what their options are. And if they find for this, then they go to this. So if A, then B, but not B if no A. You're going to have a lot of these. You're going to have a lot of legal speak, some definitions. You're going to hear some basically phrasing of the responsibilities of the juror and what you're supposed to do and how you're supposed to fill it out. I'd recommend listening to it because of all this throughout this whole trial, in the very beginning, it started with a huge list of offenses, allegations that were thrown against the hospital saying this is what they did wrong. And some of them got whittled away. And they were like, no, that's part of the dependency court stuff. We can't go there. That comes out. They made an omnibus ruling and said, no, that's not going in. Some things were sort of pared down or reworded. This is going to be our first indication of what's really left in detail, where it's going to be read to us in detail about what the jury has to consider. And just know that none of this in this portion is talking about punitive damages. Those damages come later. That's a second portion of the trial that the jury's going to consider that for. Magical Mary says, Friday depot transcript on Sarasota County site, motion to sanction, last exhibit. Yes, that's where you can find it. 327 pages of goodness. Happy Phantom, welcome to the gallery. Good to have you here. I'm trying to think of how we can read through this. I have not pre-read it. Let me give you just a little snippet. I believe this question is from Whitney, and I don't know. Is it Miss Green? Was the witness? Question, ma'am. The court's direction was to produce anything related in any way to the immediate jeopardy classification or finding. And if your counsel wants to comment on the record, I'd be happy to give them the opportunity. Mr. Hunter counsels. We provided the action plans to the materials that we were able to get for you. As I've told you, we've got some other files on the way over here that we were not aware of until very recently. But I don't think she understood that she was looking at her personal computer for this. I think we can probably make that happen pretty quickly. Mr. Whitney. Do you have a laptop with you here this afternoon? Answer. I do. Question. How long would it take you to produce to us the drafts of action plans and anything else that would be on your personal computer? Answer. I don't know. The question I would have is how many drafts do you want? Question. I want all of them. Answer. Do you want? Question. How many do you have? Answer. I don't know. Question. Okay. Answer. I understood this request to be. Question. Indicates affirmatively. Answer. For the survey reports, the action plans, says the answer, that were generated, not from the emails with the action plans going back and forth. I did not understand that request to be for that. Question. Okay. Well, you have, in addition to the drafts of the action plan, emails back and forth with other, I'm going to assume, Johns Hopkins leadership and patient safety representatives. Is that right? Answer. Yes, I'm sure there are. Question. All right. And my question to you, ma'am, is how long would we have to break here for you to produce the drafts of action plans, the emails regarding the immediate jeopardy, and any other conversations regarding action plans and anything else you might have in your personal possession? Answer. I can't predict how long that would take. Question. The limit is this. We're here. It's Friday afternoon at 4:30. We have limited time. This is going to be taken up on Monday morning. So how would you like to proceed? Mr. Hunter, let's take a break for a minute and let's you and I talk for a minute about preference and we'll go from there. Mr. Whitney, I'd like to. Can we do it on the record? Mr. Hunter, I'd prefer not to. I want to find out from her exactly what she's got and get the computer booted up because I need to see what we're talking about. Mr. Whitney, I'd prefer we give Mrs. Green a chance to grab her computer, and if you'd bring it in here and open it up and tell us what you have as you review your files. Mr. Hunter, well, she's going to review it with me first, but that, Mr. Whitney, you're certainly welcome to, once she tells us, identifies the documents she has in her possession. If you believe that there's a privilege over one of these documents or more, we'll raise the issue then. But I want to be present when Mr. Hunter says, well, I understand what you want and what we want. I'm telling you what I'm going to do. Mr. Whitney, and what's that? Mr. Hunter, I'm going to ask her to boot up her computer. Mr. Whitney, yes. I'm going to try to do the voices. Mr. Hunter says, and we're going to look at what she's got, and then I'm going to tell you, and then you can see it. Mr. Whitney says, we're going to do that. We're going to do that on the record, though. Mr. Hunter, no, sir, we're not. Let's go. Mr. Whitney, you're taking the deponent out of the room for a private conversation about what files in her personal possession? Mr. Hunter, I'm taking the deponent to another room to boot up her computer and see what's there, and I want to ascertain it's not interspersed with this privileged information. That's what we're going to do. Mr. Whitney, as I've told you, you're free to raise the privilege, but we object to this process and we think it's improper. Okay, so this is just an idea. This is just an idea of what happened on Friday in this, and we've got a 327-page document to go over that has this. Oh my goodness, this has been a battle. This has been a battle. These documents, this issue has been a battle for 5 years. For 5 years. Oh man, and the judge is not having it, and the judge is aware of all this now. This is wow. Anyway, how do I find this depot, Amanda? It's on the website. I think somebody who linked that just a minute ago. You can search for it. It's going to be over on the Discord page. That's probably the easiest way. If you type !Discord in chat and join the Discord page as the gavel falls, right here, there's somebody typed it. Thank you, Amber, for that. This is just a snippet. Okay, this is like 2 or 3 pages of, because depositions are spaced out quite a bit, but it's all in there, and they've got it all over there on Discord. What are the punishments for a lawyer being sanctioned? That is also in here. I think we have 30 pages of information about sanctions. There's a ton on Law and Lumber's Discord as well. That's a great place if you have access to that one already. That you can find it over there. They just need to write the check. Tiger Girl. They've wanted to write this check for many, many years. They've wanted to settle. They've wanted to make this all go away. They wanted to sweep the remnants of it under the rug, bury it with Dracula's corpse. They would love for this to go away, and the family says, no, we'd like a verdict. We'd like a verdict. We'd like a jury to hear this, and that's where we are. So Hunter's doing his job, advocating and protecting his client. Yeah, he's fighting hard for this, and to his credit, to this point, he has still kept that initial document out of the public eye, which is amazing, considering the judge's ruling and order previously. Your enthusiasm for this stuff, I love it. I really do. You can hear. I wish we had the video, because this was video recorded. Okay, so somewhere out there's a copy of a video. I don't know if it'll ever be released publicly, but there's a copy of this discussion on video, back and forth with their own voices. Hunter is protecting himself. KBF, I don't know if that's true. I just know that Mr. Hunter, being outside counsel for the hospital during this time period, has already admitted that he has basements full of documents regarding this, that he was up to his eyeballs in this when it happened. I will tell you that the Mr. Hunter we heard last week before the deposition, where he was telling the judge, I know some dates, but I just don't want to, I think I can recall a little bit about this, but I'd have to dig in my files for this. We saw a different Mr. Hunter today. We saw Mr. Hunter who instead was knew like the back of his hand, like the back of Kathy Beatty's hand. He knew. Sorry, I had to go there. He knew everything. He knew the dates when it happened, all the different inspections, when there were the findings, when there was a corrective action plan, when the finding was lifted. He knew everything. And I'm telling you that he did not learn that this weekend. That he knew that before. His memory just got a lot better this week. Let's see. If you guys would be so kind, I know a lot of you might be new here. I love all of LawTube, and many people do things a little bit differently. And I'm not here to attack them on any front. On this front here, because we have an audience that my wife's a homeschooler. We have homeschool groups that watch this, and literally I've got homeschool groups that watch this and are learning about the law through watching trials. We do ask that the cursey language not be used. I've filtered it out through the YouTube filter. So if you type something and it has some harsh language in there, some rough language, and it doesn't appear on the screen, that's because YouTube is blocking that from appearing. But if you go easy on the mods a little bit and see if you can rephrase your comment, maybe without some of the expletives, that would make your message appear and we'd be able to see it. So thank you. How was that to his credit? He ignored the judge's order and will most likely be sanctioned. Well, to his credit, he's held his own. He's going down fighting on this one. He's the last man on the ship, I think, but he hasn't rolled over on this. He hasn't given up, and it's possible that the sanctions, and I think somebody said this in chat, the sanctions that could come as a result of this, of not turning over the document, are preferable to the defense than the damage to the hospital that could come by this being made public. So that's I think the gamble and the, well, I would say not a gamble, but a calculated risk decision they made. Okay. If Maya or Jack want the video released, it can be, as it is their privilege. I'm not sure. It might be released. It just might not be in there yet. It's not going to be played to the jury. This is not going to be evidence that's admitted in trial. So we might never see it. The back of the hand comment. I did post a video on this channel just last week where we took some of the screenshots. You remember the issue with Kathy Beatty and the picture. There was one particular picture where they appeared to be photographing the neck area and the top of the chest of Maya, and she has her two hands holding her shirt, like pulling, like holding her shirt open to expose the neck area, and there's a third hand in there also sort of pulling the shirt back. Nobody from the hospital who was there, and apparently there were only two people. One was the bedside nurse and one was Kathy Beatty. No one can tell us whose hand that is. I went and I took some still images of Kathy Beatty from when she testified, both in her deposition and when she testified on the stand in trial. And there were times where she was fixing her hair or something like that, and I found the exact moment when the hand was in the exact same position relative to the camera, or very, very similar position relative to the camera. And so I took the screenshots of those and overlaid them and used some transparency methods. I have not modified the color. I haven't done any color grading. I haven't done any Photoshop. All I did was overlay the images and help people take a look at it and help them decide if in their mind that's the same hand. So if you want to see that, that's on this channel. It's on the videos. It was not a live. It was just an upload. I rarely upload videos, but that was one. Texticular Trauma says, I'm a former CSI, hospital and DCF in cahoots. Hospital gave terms and conditions to DCF as legal advice used in DCF attempt to stay involved, but DCF had to withdraw and close file April 2017. Saying they're in cahoots. Chris Dilello, welcome to the gallery. Good to have you here, Chris. Thank you so much for your support. Magical Mary says, please hit the like button. Over 8,000 watching, only over 3,000 likes. Hey, 3,000 is wonderful. Thank you to the 3,000 people who liked the stream today. I appreciate that. Betsy Jean says, for the wonderful mods, they're absolutely incredible. We have to do something special for them for sure. I have not finished the voice comparison. That's something I'm still working on. I want to find a way. And this is trickier. It's harder to do that with voice because you'll have to just take my word for it that I'm not changing things on the voice. But I want to find a way to play sounds back and forth. And ideally, here's my dream world, right? I play a word or a clip, and you decide whose voice it is by voting. That's how I'd like to have it. So maybe we'll have to set up a video of some sort where we use the comments and you guys can vote on what the response is. But I think if I can get that done, I'm not sure. I'd like to get it done before the trial's over, obviously, but we'll see. I think that what we heard was pretty telling. Craig says the cost of sanctions if the plaintiff gets all asked for. I think the hospital feels it is less than the other lawsuits that are potential if the document is released. That is my guess. Yeah, that's the calculated risk. They said we'd rather take the slap on the hand and on the face for not complying in this court than potentially exposing the hospital to untold liability if the document goes public. The law license, I can't speak to. Obviously, the judge has raised this as a concern, where he's used some keywords that would indicate that the attorneys are walking a very fine line. But yeah, crazy. Thank you for those who have clicked the subscribe button. It's wonderful to have you here and join us. This is what I think is the best community on the internet to watch true crime in, and it is because of you. So thank you very much. It's wonderful to have so many new people here today. Let's see. You're welcome. No, it's all right. We've had I've had a couple homeschool co-op groups reach out to me, and one of them wanted me to. I hope they're not watching. One of them wanted me to help with teaching people about the court system, and I was trying to explain that I love the court, but I'm not the guy to teach it, and it was anyway. That's for another discussion, maybe for another day. They wanted to do a mock trial and have me be part of that, and that would have been interesting. Let's see. Kim R says, I was saddened by Hunter's disobedience and lack of reprimand. I don't think the sanction will even be brought up. Kim R, I think it will. And the reason why I do is because right at the end of the break, right before we broke, and we're still, just for the record, we're still, let's see, this is where we are. Right before we broke, Mr. Anderson gets up and he's like, hey, just for the record, Judge, I want to say this. And Mr. Anderson has the habit of it coming to his mind, and he speaks it to the judge. The judge prefers that you think this through and then write out a motion and address it to the judge, and then give him a list of what you want done for it. Here he's back already.
You're fine.
Matt, that would be awesome. I'd love to see that.
Somebody from the plaintiffs come. Somebody from the defense come.
I'm right here. Can you show the judge?
The judge has handed paperwork out.
That's how punchy we are.
Now, with respect to the dependency court order package, they're still being copied. I wasn't planning on reading them unless the parties wanted me to reread those instructions. I was just going to give it to them. I can do it today, or I can hand them those tomorrow. I'm indifferent on the timing.
There's a thick stack. Thick
Did
stack.
you need to give me this, Judge? It says jury.
No, you don't get the juries.
Yeah.
Sorry about that.
Got it?
Your Honor, if there's time, I would like to have it read one last time.
I'm sorry?
If there is time, I would like to have the defense orders read one last time.
You can take a couple minutes and look at it.
I'm trying to come up with a proposed order as quickly as I can. Are we going to go over, yes, we are on the verdict form. Okay.
No,
Because I have a concern.
You're not reading the verdict form today, Judge.
No, the verdict form would be discussed tomorrow.
Okay.
I would go over it tomorrow after closing arguments. Because I think that's in the last instruction.
Mine was, I'm still on...
Yeah, on page 68 of 68 is where we would be going over the verdict form, which will occur tomorrow.
I just had an addition to paragraph 41 in light of the circumstances.
To the verdict form or to the jury instructions?
Oh, to the verdict form. The fraudulent billing.
Well,
Mr. Kowalski needs to include...
Why don't we deal with that after we send the jury home today, if I'm not going to be reading the verdict form today?
Absolutely.
Judge, you included a in the defense packet, there was one that's not double-sided. Was that for you?
Well, that's actually for you. Mr. Hunter suggested you might not want a double-sided copy. So
I love you, baby.
Thank you.
So that's for you, Ms. Crowells.
Thank you.
I could use some help looking for that Adams Division L court again. They broke and canceled the web feed. I'm waiting for them to restart it again. If anyone wants to watch for that Colorado court again, that would help me.
So under dependency court order instruction, do you want me to hand it out today, tomorrow?
Our preference is tomorrow.
Tomorrow.
Let me guess, today? Okay. We have an agreement. I'm rolling with it tomorrow. Madam Court Reporter, you're welcome. I will have probably about 10 minutes of comments tomorrow morning before we bring in the jury. So I'm trying to figure out what time we need to start. If the jury is able to come at 8:30, if we start at 8:15, is that going to be enough, or do we need more time for any last-minute issues?
We're going to have some time out today after the jury leaves, right, Judge?
Yes.
Then next time's fine.
About last minute issued out.
I can't hear you, Mr. Hunter.
I'm sorry, I'm about last minute issued out.
Just in terms of timing, the court envisions that the plaintiff would put on their closing argument, the defense would do theirs, plaintiff would do their rebuttal, and hoping to get all that in before a late lunch. Is that optimistically what the court schedule would be?
I would love to be able to do it. I'm probably going, and I'm just telling the court deputies this for the first time. My thought is that they will, in the morning, get the jurors lunch orders, and so they can have lunch ready to go, that we will just take mid-morning breaks and not take a lunch break. And as soon as we send the jury back, the lunch will be ready for the jury and they can just dive right in.
The only issue in that, Judge, is you're doing 12 orders.
I'm sorry?
Are you doing 12 orders?
Well, what we do is we take 12 orders, but we don't call in 12 orders. Yep. We are good stewards of the public's money. We don't order extra lunches when we don't have to.
That's harsh.
Mr. Altenburn, are you ready for me to proceed, or do you still need a few more minutes? Plaintiffs, are you ready for me to start reading?
I just have, if I could approach, I have this instruction to look at.
Can you pull up whatever he's going to hand me?
Okay, so this is the instruction that he wants the judge. He's hurriedly written.
Or a version thereof.
Or a version thereof. His hand scribbled. Is this the adverse inference request? Or this is he asking for the jury to be instructed something about the document? Hey, Carrie, it's just one video today. We have not broken, so you just rewind to this one. Have not heard any SIR rebuttal yet. I'm not sure if there will be. Spoliation. Possibly.
Are you waiting for a response, Jeff?
I'm waiting for a response from the defense.
Well, to a large degree, I think this has already been handled by what's gone on in the last couple hours. It's not really written like an instruction and talks in terms of exploitation and tells you should not consider any questions regarding the alleged failure of Dr. Corcoran to review certain documents informing his opinions, nor an evaluation of Dr. Corcoran's opinions. That also was handled during the examination to explain when all this was done. This is basically things that the lawyers have already handled, and I don't see that it needs to be a special instruction, nor am I quite sure where it would be placed.
Here's my view. I don't think I'm going to give it at this point in time. I mean, certainly if the defense makes a point about this in the closing arguments, then I probably will have to give an instruction on it, but I suspect it's not going to be commented on in closing arguments.
Got a lot to cover in closing.
The testimony that was already adduced will suffice.
Thank you, Your Honor.
I understand the court's ruling.
There you go, Madam Clerk. Let's bring in the jury.
Okay, the jury is about to be read that thick stack of instructions. This is going to be a little long. It's going to be a little monotonous at times, but it's also very important.
All right.
So it's not going to be terribly exciting for the next part, but once this is done, they're going to handle the juror issue and see if a juror is going to be excused. So you don't want to leave, but if you tune out for a little bit, I won't blame you.
Okay, everyone please be seated. Then Coley. One correct juror member, please. Who's turn? Okay, members of the jury, before I start to read, I want to confirm that while you were away, you did not discuss this case amongst yourselves, you did not do any investigation, and you received no information. Is that all correct? Yes. And no one approached you about this case. Is that correct? Correct. And you saw no media accounts about this case. Is that correct? Correct. Okay. Now, members of the jury, that 68-page package I just gave you are the jury instructions that are going to be applicable to this case. I am going to read those instructions to you at this point in time. It's going to take me a little bit of time. You are free to listen to me or to read along or both. If I'm doing this properly, I'm also going to publish it on your monitors as well. And looks like Mr. Reyes is helping me out there. Thank you, Mr. Reyes. If I end up reading too quickly, just flag me down. If I mess up how I'm reading it, I'll probably just reread that little section. And every now and again, I'll take some water. Okay. And just to orient you, what we have done is on pages 2 and 3 of the jury instructions, we have listed out the claims and the issues and created a table of contents for you so that you will be able to more quickly find the specific instructions. And additionally, when we send back the evidence to you, we'll also have kind of like a table of contents of the evidence as well that you will have available to you. So, without further ado, let's go to page 4 of 68. Members of the jury, you have now heard and received all of the evidence in this case. I am now going to tell you about the rules of law that you must use in reaching your verdict. You will recall at the beginning of the case, I gave you a short explanation of the claims in this case and told you that I would provide a complete written set of instructions before you deliberated to reach your verdict. These instructions are the complete set of instructions that you will use in the jury room. When I finish telling you about the rules of law, the attorneys will present their final arguments, and then you'll retire to decide your verdict. The final arguments will occur tomorrow. As a reminder, I previously instructed you on all relevant dependency court orders binding Johns Hopkins All Children's Hospital, and I will be separately including those instructions for your review and use during your deliberations, and I'll give those to you tomorrow. As a further reminder, I also previously instructed you that Johns Hopkins All Children's Hospital does not have any immunity from the claims presented to you in this trial. As you understand by now, Jack Kowalski is the plaintiff in this case in 3 separate capacities. First, he claims damages for his daughter, Maya Kowalski, because she is under the age of 18 and is a minor. Second, he asserts claims for his deceased wife, Beata Kowalski, Beata Kowalski's estate, and Beata Kowalski's legal survivors as the personal representative of her estate. Finally, he claims damages personally on his own behalf. In these instructions, when a claim is made for Maya Kowalski, the instructions will describe Maya Kowalski as the claimant, even though legally Jack Kowalski as her father is the plaintiff. When Jack Kowalski is making a claim in his capacity as the personal representative of the estate of Beata Kowalski, the instructions will describe the estate as the claimant. Finally, when the claim is for Mr. Kowalski personally, the instructions will describe Jack Kowalski as the claimant. In these instructions, there are instructions for, and it should say 7, not 9, I apologize, 7 separate claims. These instructions are given to you in writing to use in the jury room, and they include a table of contents so that you can find the instructions for a specific claim quicker during your deliberations. Although these claims have been tried together, each is separate from the other, and each party is entitled to have you separately consider each claim as it affects that party. Therefore, in your deliberations, you should consider the evidence as it relates to each claim separately, as you would had each claim been tried before you separately. During this trial, you have heard evidence about rules or policies created by Johns Hopkins All Children's Hospital for its employees and for visitors. You have also heard evidence about a document described as the Patient and Family Rights and Responsibilities, or as a Patient's Bill of Rights. The fact that an employee may have failed to comply with these requirements is not a violation of a law or a breach of a legal duty. It is only evidence that may be considered by you to determine whether Johns Hopkins All Children's Hospital breached one of the legal duties or standards of care that I explained to you in these instructions. Likewise, the fact that an employee may have complied with these requirements does not mean that Johns Hopkins All Children's Hospital cannot be found to have breached one of the legal duties or standards of care that I explained to you in these instructions. Again, that fact is only evidence that you may consider to determine whether Johns Hopkins All Children's Hospital did not breach one of the legal duties or standards of care that I explained to you in these instructions. During the trial, you have heard testimony about whether Mr. Kowalski was prohibited at times by the dependency court from authorizing a doctor to administer ketamine to Maya Kowalski. When the dependency court entered the order on January 13th, let me just read that again. When the dependency court entered the order on January 13th, 2017, which discharged Maya Kowalski from the hospital and placed her in the interim care of her father, The dependency court prohibited Mr. Kowalski from authorizing a doctor to administer ketamine to Maya Kowalski. On April 20th, 2017, the dependency court entered a final order releasing Maya Kowalski from shelter status. That order ended the lawsuit in the dependency court and all existing orders. During the trial, you have heard testimony that Maya Kowalski experienced stress relating to this current lawsuit. Emotional stress that parties to a lawsuit experience because of their involvement in the lawsuit is not an element of damages for any claim in this lawsuit. Claim 1, false imprisonment. The first claim in this case is brought by Maya Kowalski against Johns Hopkins All Children's Hospital. Maya Kowalski claims that Johns Hopkins All Children's Hospital intentionally restrained Maya Kowalski on 3 separate occasions under circumstances that were unreasonable and unwarranted and without legal authority, which caused her harm. First, Maya Kowalski claims that she was intentionally restrained between October 7 and October 13, 2016, because Johns Hopkins All Children's Hospital did not release her to her parents in this period before the court in the proceedings filed by the Department of Children and Families entered its shelter order. Second, Maya Kowalski claims she was intentionally restrained on or between October 18th and October 20th, 2016, when she was moved from her normal hospital room to another room containing video recording equipment, where she claims she was confined for approximately 48 hours. Third, Maya Kowalski claims she was intentionally restrained on January 6, 2017, when she was confined in a room where some of her clothing was removed against her will, and she was restrained while photographs were taken of her body. Johns Hopkins All Children's Hospital admits that it intentionally kept Maya Kowalski at the hospital between October 7 and October 13, 2016. It admits that it intentionally placed Maya Kowalski in another room on and between October 18th and October 20th, 2016, not 2026, 2016, to be video recording. It also admits that it took photographs of Maya Kowalski. As to each instance of claimed false imprisonment, Johns Hopkins All Children's Hospital denies that its acts were unreasonable, unwarranted under all the circumstances, or without legal authority. The parties must prove all claims and defenses by the greater weight of the evidence. I will now define the terms you will use in deciding this claim. Greater weight of the evidence means the more persuasive and convincing force and effect of the entire evidence in the case. False imprisonment means that Johns Hopkins All Children's Hospital restrained Maya Kowalski with the purpose of causing the restraint or acted with knowledge that Maya Kowalski's restraint would, to a substantial certainty, result from the acts of Johns Hopkins All Children's Hospital. To be restrained means that Maya Kowalski was held against her will and did not consent to the restraint. In other words, a person is restrained when she is not free or does not reasonably believe she is free to leave the place to which she has been confined. To be restrained, a person must be aware of the restraint. An act of restraint is without lawful authority if Johns Hopkins All Children's Hospital did not act under color or a claim of lawful authority for that specific act. An unlawful and intentional restraint is a legal cause of loss, injury, or damage if it directly and in natural and continuous sequence produces or contributes substantially to producing such loss, injury, or damage, so that it can reasonably be said that but for the unlawful and intentional restraint, the loss, injury, or damage would not have occurred. In order to be regarded as a legal cause of loss, injury, or damage, an unlawful and intentional restraint need not be the only cause. An unlawful and intentional restraint may be a legal cause of injury even though it operates in combination with the act of another, some natural cause or some other cause, if the unlawful and intentional restraint contributes substantially to producing such loss, injury, or damage. The issue for you to decide on Maya Kowalski's claim against Johns Hopkins All Children's Hospital are: A, whether Johns Hopkins All Children's Hospital, without legal authority, intentionally caused Maya Kowalski to be restrained against her will in a manner that was unreasonable and unwarranted under the circumstances, and if so, whether that restraint was a legal cause of loss, injury, or damage to Maya Kowalski. On the verdict form, you will be asked to make a decision concerning these issues for each of the 3 separate occasions claimed by Maya Kowalski. If the greater weight of the evidence does not support the claim of Maya Kowalski for any of the 3 occasions, your verdict should be for Johns Hopkins All Children's Hospital. However, if the greater weight of the evidence supports the claim by Maya Kowalski for one or more of these occasions, then your verdict should be for Maya Kowalski and against Johns Hopkins All Children's Hospital. If you find for Johns Hopkins All Children's Hospital, you will not consider the matter of damages. But if you find for Maya Kowalski, you should award Maya Kowalski an amount of money that the greater weight of the evidence shows will fairly and adequately compensate her for her loss, injury, or damage, as the greater weight of the evidence shows was caused by the occasions on which you find she was intentionally restrained. If you find for Maya Kowalski, you shall consider the following elements of damages for her. A, any bodily injury sustained by Maya Kowalski and any resulting pain and suffering, mental anguish, inconvenience, or loss of capacity for the enjoyment of life experienced in the past. There is no exact standard for measuring such damage. The amount should be fair and just in the light of the evidence. And B, the reasonable value of medical and psychological treatment necessary or reasonably to be obtained by Maya Kowalski after she reaches the age of 18. If you find for Maya Kowalski but find that no loss, injury, or damage has been proven, then you should award Maya Kowalski nominal damages. Nominal damages are damages of an inconsequential amount which are awarded when a wrong has been done but no actual damage is proved. A parent is entitled to certain types of damage for a claim brought on behalf of a child. In this case, Jack Kowalski is the parent entitled to these damages. If you find for Maya Kowalski. If you find for her, you shall consider the following elements of damages for Jack Kowalski. A, the reasonable value or expense of hospitalization and medical, psychological, and nursing care and treatment necessarily or reasonably be obtained by Jack Kowalski for his child Maya Kowalski in the past or to be so obtained in the future until Maya Kowalski reaches the age of 18. If your verdict is for Johns Hopkins All Children's Hospital on each claimed occasion of false imprisonment, you will not decide the issue of punitive damages. If, however, you find for Maya Kowalski against Johns Hopkins All Children's Hospital on any of the claims of false imprisonment, then there is an additional claim in this case that you must decide. You must decide whether, In addition to compensatory damages, punitive damages are warranted as punishment to Johns Hopkins All Children's Hospital for the false imprisonment claims you have found for Maya Kowalski and as a deterrent to others. In this section, this additional claim for punitive damages involves only the claims for false imprisonment. The trial of punitive damages is divided into two parts. In this first part, you will decide whether the conduct of Johns Hopkins All Children's Hospital is such that punitive damages are warranted. If you decide that punitive damages are warranted, we will proceed to the second part of that issue after you have finished deliberating, during which the parties may present additional evidence and argument on the issue of punitive damages. I will then give you additional instructions, after which you will decide whether, in your discretion, punitive damages will be assessed, and if so, the amount.
Page 16.
Punitive damages are warranted if you find by clear and convincing evidence that employees of Johns Hopkins All Children's Hospital involved in any false imprisonment were personally guilty of intentional misconduct or gross negligence which was a substantial cause of loss, injury, or damage to Maya Kowalski, and that A, the officers, directors, or managers of Johns Hopkins All Children's Hospital actively and knowingly participated in such conduct, or B, the officers, directors, or managers of Johns Hopkins All Children's Hospital knowingly condoned, ratified, or consented to such conduct of Catherine Beatty or other employees of Johns Hopkins All Children's Hospital, or C, Johns Hopkins All Children's Hospital engaged in conduct that constituted gross negligence and that contributed to the loss, damage, or injury to Maya Kowalski. Under those circumstances, you may, in your discretion, award punitive damages against Johns Hopkins All Children's Hospital. If clear and convincing evidence does not show such conduct by employees of Johns Hopkins All Children's Hospital involved in the false imprisonments, punitive damages are not warranted against Johns Hopkins All Children's Hospital as to false imprisonment. On the verdict form, you will be asked to make this decision for each of the three occasions claimed as false imprisonments. Intentional misconduct means that the employees of Johns Hopkins All Children's Hospital involved in the false imprisonments had actual knowledge of the wrongfulness of their conduct and the high probability that injury or damage to Maya Kowalski would result, and, despite that knowledge, intentionally pursued that course of conduct resulting in injury or damage to Maya Kowalski. Gross negligence means that the conduct of the employees of Johns Hopkins All Children's Hospital involved in the false imprisonments was so reckless or wanting in care that it constituted a conscious disregard or indifference to the life, safety, or rights of Maya Kowalski. Clear and convincing evidence differs from the greater weight of the evidence in that it is more compelling and persuasive. As I have already instructed you, greater weight of the evidence means the more persuasive and convincing force and effect of the entire evidence in the case. Clear and convincing evidence is evidence that is precise, explicit, lacking in confusion, and such weight that it produces a firm belief or conviction without hesitation about the matter in issue. A manager is more than a mid-level employee. It is someone who holds a position with the corporation which might result in the manager's acts being deemed the acts of the corporation.
We're on 19 pages in out of 68.
The second claim for your consideration is a claim of battery brought by Maya Kowalski against Johns Hopkins All Children's Hospital. Maya Kowalski claims that Catherine Beatty and a bedside nurse whose hands are shown in photographs and evidence, both of whom are employees of Johns Hopkins All Children's Hospital, committed battery by engaging in harmful or offensive personal contact upon Maya Kowalski with the intent to cause such contact. Maya Kowalski claims that Johns Hopkins All Children's Hospital is liable for battery for the acts of Catherine Beatty or bedside nurse during the time that Maya Kowalski was in the hospital. She claims that Miss Beatty committed battery by giving her unwanted touching, including hugging, patting, kissing, and placing her on her lap. She also claims that Miss Beatty or bedside nurse committed battery during the incident when Maya Kowalski claims she was intentionally restrained on January 6, 2017, and photographs were taken of her body. Johns Hopkins All Children's Hospital admits that it would be liable for any harmful or offensive contact with Maya Kowalski by Miss Beatty or the bedside nurse because their actions were done in the course and scope of employment with Johns Hopkins All Children's Hospital. Maya Kowalski must prove all claims by the greater weight of the evidence. I will now define some of the terms you will use in deciding this claim. Greater weight of the evidence means the more persuasive and convincing force and effect of the entire evidence in the case. Battery means a harmful or offensive physical contact upon another with the intent to cause such contact or the apprehension that such contact is imminent. It is not necessary that the contact cause physical injury. It is enough that the actor intends to make the contact and that the contact would be offensive to a reasonable person under like circumstances. A battery is a cause of loss, injury, or damage if it directly and in natural and continuous sequence produces or contributes substantially to producing such loss, injury, or damage, so that it can reasonably be said that, but for the harmful or offensive physical contact, the loss, injury, or damage would not have occurred. In order to be regarded as a legal cause of loss, injury, or damage, a battery need not be the only cause. A battery may be a legal cause of injury even though it operates in combination with the act of another, some natural cause, or some other cause if the battery contributes substantially to producing such loss, injury, or damage. The issue for you to decide on Maya Kowalski's claim against Johns Hopkins All Children's Hospital are whether Miss Beatty or bedside nurse committed a harmful or offensive contact upon the person of Maya Kowalski with the intent to make a contact that a reasonable person would find to be offensive under like circumstances. On the verdict form, you will be asked to decide this issue for each of the two batteries described. If the greater weight of the evidence does not support this claim of Maya Kowalski for either of the alleged batteries, your verdict should be for Johns Hopkins All Children's Hospital. However, if the greater weight of the evidence supports the claim by Maya Kowalski for one or both of the alleged batteries, then your verdict should be for Maya Kowalski and against Johns Hopkins All Children's Hospital. You will be asked on the verdict form to make a decision about the alleged battery on January 6th, 2017, separate from the other alleged battery. If you find for Johns Hopkins All Children's Hospital on both claim batteries, you will not consider the matter of damages. But if you find for Maya Kowalski against Johns Hopkins All Children's Hospital, you should award Maya Kowalski an amount of money that the greater weight of the evidence shows will fairly and adequately compensate her for the loss, injury, or damage, as the greater weight of the evidence shows was caused by the batteries committed by Catherine Beatty or bedside nurse. If you find for Maya Kowalski against Johns Hopkins All Children's Hospital, you shall consider the following elements of damages for her. A. Any bodily injury sustained by Maya Kowalski and any resulting pain and suffering, disability, or physical impairment, mental anguish, inconvenience, or loss of capacity for the enjoyment of life experienced in the past or to be experienced in the future. There is no exact standard for measuring such damage. The amount should be fair and just in the light of the evidence. And B, the reasonable value or expense of psychological treatment necessarily or reasonably to be obtained by Maya Kowalski after she reaches the age of 18. If you find for Maya Kowalski, but find that no loss, injury, or damage has been proven, you should award Maya Kowalski nominal damages. Nominal damages are damages of an inconsequential amount, which are awarded when a wrong has been done, but no actual damage is proved. Jack Kowalski is also entitled to certain types of damage as a parent for this claim brought on behalf of Maya Kowalski. If you find for Maya Kowalski against Johns Hopkins All Children's Hospital, you shall consider the following element of damages for Jack Kowalski as Maya Kowalski's parent. A. The reasonable value or expense of hospitalization and medical, psychological, and nursing care and treatment necessarily or reasonably obtained by Jack Kowalski for his child Maya Kowalski in the past or to be so obtained in the future until Maya Kowalski reaches the age of 18. Because the claim for the battery that allegedly occurred on January 6, 2017 occurred at the same time and place that Maya Kowalski claims she was intentionally restrained, your award of damages for this claim against Johns Hopkins Hospital should not duplicate an award that you make for the same loss, injury, or damage on the claim for the intentional restraint. If your verdict is for Johns Hopkins All Children's Hospital on the claim of battery on January 6, 2017, you will not decide the issue of punitive damages. If, however, you find for Maya Kowalski against Johns Hopkins All Children's Hospital on the claim of battery for the incident on January 6, 2017, then there is an additional claim in this case that you must decide. You must decide whether, in addition to compensatory... Let me start that sentence again. I apologize. You must decide whether, in addition to compensatory damages, punitive damages are warranted as punishment to Johns Hopkins All Children's Hospital for the battery claim you have found for Maya Kowalski and as a deterrent to others. This additional claim for punitive damages involves only the claim of battery on January 6, 2017. It does not apply to any of the later claims in this lawsuit. The trial of punitive damages is divided into two parts. In this first part, you will decide whether the conduct of Johns Hopkins All Children's Hospital is such that the punitive damages are warranted. If you decide that punitive damages are warranted, We will proceed to the second part of that issue after you have finished deliberating, during which the parties may present additional evidence and argument on the issue of punitive damages. I will then give you additional instructions, after which you will decide whether, in your discretion, punitive damages will be assessed, and if so, the amount.
We're on page 26 right now.
Punitive damages are warranted if you find by clear and convincing evidence that Catherine Beatty or the bedside nurse involved in the claim of battery on January 6, 2017, were personally guilty of intentional misconduct or gross negligence, which was a substantial cause of loss, injury, or damage to Maya Kowalski, and that A, the officers, directors, or managers of Johns Hopkins All Children's Hospital actively and knowingly participated in such conduct, or B, the officers, directors, or managers of Johns Hopkins All Children's Hospital knowingly condoned, ratified, or consented to such conduct of Catherine Beatty or other employees of Johns Hopkins All Children's Hospital, or C, Johns Hopkins All Children's Hospital engaged in conduct that constituted gross negligence and that contributed to the loss, damages, or injury to Maya Kowalski. Under those circumstances, you may, in your discretion, award punitive damages against Johns Hopkins All Children's Hospital. If clear and convincing evidence does not show such conduct by Catherine Beatty or bedside nurse, punitive damages are not warranted against Johns Hopkins All Children's Hospital. On the verdict form, you will be asked to make this decision as to the battery claimed for the January 6, 2017 incident. Intentional misconduct means that Miss Beatty or bedside nurse had actual knowledge of the wrongfulness of their conduct and the high probability that injury or damage to Maya Kowalski would result, and, despite that knowledge, intentionally pursued that course of conduct resulting in injury or damage to Maya Kowalski. Gross negligence means that Miss Beatty's or bedside nurse's conduct was so reckless or wanting in care that it constituted a conscious disregard or indifference to the life, safety, or rights of Maya Kowalski. Clear and convincing evidence differs from the greater weight of the evidence in that it is more compelling and persuasive. As I have already instructed you, greater weight of the evidence means the more persuasive and convincing force and effect of the entire evidence in the case. Clear and convincing evidence is evidence that is precise, explicit, lacking in confusion, and of such weight that it produces a firm belief or conviction without hesitation about the matter in issue. A manager is more than a mid-level employee. It is someone who holds a position with the corporation which might result in his or her acts being deemed the acts of the corporation. The third claim for your consideration in this case is as follows. Maya Kowalski claims that Johns Hopkins All Children's Hospital was negligent in the medical treatment of her while she was a patient at Johns Hopkins All Children's Hospital, and that its negligent treatment caused her harm. Johns Hopkins All Children's Hospital denies the claim. Maya Kowalski must prove all claims by the greater weight of the evidence. Greater weight of the evidence means the more persuasive and convincing force and effect of the entire evidence in the case. Preliminary issue concerning Dr. Sally Smith, a parent agent. Under Florida law, the Florida Department of Health is required to provide the services
of a multidisciplinary child protection team in each of the zones of the Department of Children and Families. That team must be led by a medical director who is a doctor board certified in pediatrics and who has additional training in child abuse. The medical director of the child protection team for the zone serving Pinellas County in 2016 and 2017 was Dr. Sally Smith. In that capacity, Dr. Sally Smith was required to investigate reports of child abuse that were assigned to her child protection team. The hotline report concerning Maya Kowalski was assigned to her team. The employees of Johns Hopkins All Children's Hospital were obligated to cooperate with the investigation by the child protection team. As the medical director of the child protection team, Dr. Sally Smith was required to be capable of providing certain additional services. Those services included medical diagnosis and evaluation services and medical evaluation related to abuse, abandonment, or neglect as defined by policy or rule of the Department of Health. A child protection team may also provide consultation with respect to a child who is alleged to be abused when requested by any other professional involved with a child. Johns Hopkins All Children's Hospital's doctors and healthcare providers, however, were not required to follow incorrect diagnoses or evaluations, and they had an independent duty to Maya Kowalski to exercise independent medical judgment. When Dr. Sally Smith provided these services in her role as the medical director of the child protection team, she was not providing those services as an agent of any hospital. Dr. Sally Smith's role as medical director of the child protection team did not extend to treating Maya Kowalski. The parties agree that Johns Hopkins All Children's Hospital is legally responsible for the medical negligence of its doctors who are its employees or agents. In addition to the negligence of doctors who are its agents or employees, Johns Hopkins All Children's Hospital can become legally responsible for the medical negligence of a doctor who is not an employee or agent of the hospital when the doctor is what the law describes as an apparent agent of the hospital. Doctors are not employees or agents of a hospital merely because they have staff privileges at the hospital. They can, however, be treated as apparent agents of the hospital if the proof establishes that they fall within this category. In this case, the parties agree that Dr. Sally Smith was not an employee of Johns Hopkins All Children's Hospital. There is, however, an issue for your resolution whether Dr. Sally Smith was an apparent agent of Johns Hopkins All Children's Hospital. Maya Kowalski claims that Dr. Sally Smith was an apparent agent of Johns Hopkins All Children's Hospital and that Dr. Sally Smith also was negligent in her medical treatment of Maya Kowalski while acting within the scope of her apparent authority. Johns Hopkins All Children's Hospital denies that Dr. Sally Smith was its apparent agent. Dr. Sally Smith was an apparent agent if Johns Hopkins All Children's Hospital, by its words or conduct, caused or allowed Beata or Jack Kowalski or both to believe that Dr. Sally Smith was an agent of and had authority to act for Johns Hopkins All Children's Hospital, and if Beata Kowalski or Jack Kowalski relied upon that belief
in dealing with Dr. Sally Smith as the agent of Johns Hopkins All Children's Hospital. A person is responsible for the negligence of its apparent agent at the time and place of the alleged negligence of the apparent agent if the apparent agent was acting within the scope of her apparent authority. If the greater weight of the evidence does not support Maya Kowalski's claim that Dr. Sally Smith was an apparent agent of Johns Hopkins All Children's Hospital at the time and place of any medical negligence that Maya Kowalski claims that Dr. Smith committed, that's Dr. Sally Smith, then your verdict on the claim of Maya Kowalski concerning the alleged medical negligence of Johns Hopkins All Children's Hospital in this case cannot be based on claimed medical negligence by Dr. Sally Smith. If, however, the greater weight of the evidence supports Maya Kowalski's claim that Dr. Sally Smith was an apparent agent of Johns Hopkins All Children's Hospital at the time of any act of medical negligence, and that Dr. Sally Smith was acting within the scope of her apparent authority, then your verdict on the medical negligence claim against Johns Hopkins All Children's Hospital can be based on the medical negligence by Dr. Sally Smith. Remainder of medical negligence instructions. Now that I have explained this preliminary issue, I will now define additional terms you will use in deciding this claim of medical negligence. Negligence is the failure to use reasonable care. Reasonable care on the part of a doctor or hospital is that level of care, skill, and treatment which, in the light of all relevant surrounding circumstances, is recognized as acceptable and appropriate by similar and reasonably careful doctors or hospitals. Negligence on the part of a doctor or hospital is doing something that a reasonably careful doctor or hospital would not do under like circumstances, or failing to do something that a reasonably careful doctor or hospital would do under like circumstances. Negligence is a legal cause of loss, injury, or damage if it directly and in natural and continuous sequence produces or contributes substantially to producing such loss, injury, or damage, so that it can be reasonably said that, but for the negligence, the loss, injury, or damage would not have occurred. In order to be regarded as a legal cause of loss, injury, or damage, negligence need not be the only cause. Negligence may be a legal cause of loss, injury, or damage, even though it operates in combination with the act of another or some other cause, if the negligence contributes substantially to producing such loss, injury, or damage.
Needed a double swig there.
The issues that you must decide on Maya Kowalski's claim against Johns Hopkins All Children's Hospital are whether the Johns Hopkins All Children's Hospital was negligent through any of its employee doctors or through any apparent agent doctor in the medical care and treatment of Maya Kowalski, and if so, whether that negligence was a legal cause of loss, injury, or damage to Maya Kowalski. If the greater weight of the evidence does not support Maya Kowalski's claim, then your verdict should be for Johns Hopkins All Children's Hospital on this claim.
That completes page 35 of
However,
68.
If the greater weight of the evidence supports the claim of Maya Kowalski, then your verdict should be for Maya Kowalski and against Johns Hopkins All Children's Hospital on this claim. If you find for Johns Hopkins All Children's Hospital, you will not consider the matter of damages. But If you find for Maya Kowalski, you should award her an amount of money that the greater weight of the evidence shows will fairly and adequately compensate her for the loss, injury, or damage as the greater weight of the evidence shows was caused by the conduct complained of. If you find for Maya Kowalski, you shall consider the following elements of damages. A. Any bodily injury sustained by Maya Kowalski and any resulting pain and suffering, disability or physical impairment, mental anguish, inconvenience, or loss of capacity for the enjoyment of life experienced in the past or to be experienced in the future. There is no exact standard for measuring such damage. The amount should be fair and just in the light of the evidence. B. The reasonable value or expense of hospitalization and medical, psychological, and nursing care and treatment necessarily or reasonably to be obtained by Maya Kowalski. And C. Any loss of ability to earn money in the future by Maya Kowalski. If you find that Johns Hopkins All Children's Hospital caused a bodily injury and that the injury resulted in an aggravation of an existing disease or physical defect, you should attempt to decide what portion of Maya Kowalski's condition resulted from the aggravation. If you can make that determination, then you should award only those damages resulting from the aggravation. However, if you cannot make that determination, or if it cannot be said that the condition would have existed apart from the injury, then you should award damages for the entire condition suffered by Maya Kowalski. The fourth claim for your consideration in this case is brought by Jack Kowalski against Johns Hopkins All Children's Hospital. He claims that Johns Hopkins All Children's Hospital fraudulently billed the Kowalskis and their health insurers, falsely claiming that the hospital was treating Maya Kowalski for CRPS. He claims this fraudulent information caused him harm. Johns Hopkins All Children's Hospital denies this claim. Mr. Kowalski must prove all claims and defenses by the greater weight of the evidence. I will now define the terms you will use in deciding this case. And members of the jury, where it says must prove all claims and defenses, it just should say must prove all claims by the greater weight of the evidence. So please strike out and defenses. Mr. Kowalski must prove all claims by the greater weight of the evidence. I will now define terms you will use in deciding this case. It's a lot of talking for me. Greater weight of the evidence means the more persuasive and convincing force and effect of the entire evidence in the case. A material fact is one that is of such importance that Mr. Kowalski or his insurance company would have acted or would have refrained from acting but for the false statement about it. Misrepresentation of a material fact is a legal cause of loss, injury, or damage if it directly and in natural and continuous sequence produces or contributes substantially to producing such loss or damage, so that it can reasonably be said that but for the misrepresentation, the loss, injury, or damage would not have occurred. In order to be regarded as a legal cause of loss, injury, or damage, a misrepresentation of a material fact need not be the only cause. Misrepresentation of a material fact may be a legal cause of loss, injury, or damage even though it operates in combination with some other cause if the misrepresentation contributes substantially to producing such loss, injury, or damage. The issues for you to decide on the claim for fraudulent billing are: A, whether Johns Hopkins All Children's Hospital made a false statement concerning a material fact in or in regard to its billing. B, whether Johns Hopkins All Children's Hospital knew the statement was false when it made it, or made the statement knowing it did not know whether it was true or false. C, whether Johns Hopkins All Children's Hospital intended that another would rely on the false statement. D, whether Mr. Kowalski or his insurance company relied on the false statement. And E, whether the reliance on the false statement was a legal cause of loss, injury, or damage to Mr. Kowalski. If the greater weight of the evidence does not support the claim of Mr. Kowalski, your verdict should be for Johns Hopkins All Children's Hospital on this claim. However, if the greater weight of the evidence supports the claim, then your verdict should be for Mr. Kowalski and against Johns Hopkins All Children's Hospital on this claim. If you find for Johns Hopkins All Children's Hospital, you will not consider the matter of damages. But if you find for Mr. Kowalski, you should award them an amount of money that the greater weight of the evidence shows will fairly and adequately compensate them for any monetary loss or damage sustained by them and caused by the fraud. You shall consider the following elements of damage. A, any deductibles or co-pays incurred by the plaintiffs as a result of Maya Kowalski's sheltering at Johns Hopkins All Children's Hospital, or increases in their cost of insurance coverage in the past or in the future, including increased premiums, co-pays, and higher deductibles, and reimbursement for the difficulty of finding insurance in the future. The fifth claim for your consideration in this case is brought by the estate of Beata Kowalski against Johns Hopkins All Children's Hospital. The estate claims that during the time that Maya Kowalski was a patient at the hospital, Johns Hopkins All Children's Hospital acted extremely and Let me read the sentence again. The estate claims that during the time that Maya Kowalski was a patient at the hospital, Johns Hopkins All Children's Hospital acted extremely and outrageously, causing Beata Kowalski severe emotional distress. In this claim, the estate claims that the extreme and outrageous conduct of Johns Hopkins All Children's Hospital caused Beata Kowalski to suffer severe emotional distress prior to her death. Through this claim, the estate now seeks to recover for that harm. Johns Hopkins All Children's Hospital denies this claim. The estate must prove its claim by the greater weight of the evidence. I will now define some of the terms you will use in deciding this claim. Greater weight of the evidence means the more persuasive and convincing force and effect of the entire evidence in the case. Extreme and outrageous conduct is behavior which, under the circumstances, goes beyond all possible bounds of decency and is regarded as shocking, atrocious, and utterly intolerable in a civilized community. Emotional distress is severe when it is of such intensity or duration that no ordinary person should be expected to endure it. Extreme and outrageous conduct is a legal cause of severe emotional distress if it directly and in natural and continuous sequence produces or contributes substantially to producing such severe emotional distress, so that it can reasonably be said that, but for the extreme and outrageous conduct, the severe emotional distress would not have occurred. In order to be regarded as a legal cause of severe emotional distress, extreme and outrageous conduct need not be the only cause. Extreme and outrageous conduct must be a legal cause of severe emotional distress, even though the act of another or some other cause also contributes to the distress. The issue for you to decide on the estate's, and that should read fifth claim. The issues for you to decide on the estate's fifth claim are: 1, whether Johns Hopkins All Children's Hospital, through its agents and employees, engaged in extreme and outrageous conduct during the time that Maya Kowalski was a patient at the hospital and acted with the intent either to cause Beata Kowalski severe emotional distress or with reckless disregard of the high probability of causing Beata Kowalski severe emotional distress. And if so, 2, whether that extreme and outrageous conduct was a legal cause of severe emotional distress to Beata Kowalski. If the greater weight of the evidence does not support the estate's claim, your verdict should be for Johns Hopkins All Children's Hospital. However, if the greater weight of the evidence supports the estate's claim, your verdict should be for the estate and against Johns Hopkins All Children's Hospital. If your verdict is for Johns Hopkins All Children's Hospital, you will not consider the matter of damages. But if the greater weight of the evidence supports the estate's claim, you should determine and write on the verdict form in dollars the total amount of loss, injury, or damage which the greater weight of the evidence shows will fairly and adequately compensate the estate for the loss, injury, or damage occurring prior to the death of Beata Kowalski on January 8, 2017. If you find for the estate, you shall consider the following elements. A, any resulting pain and suffering, mental anguish experienced by Beata. Let me read again. If you find for the estate, you shall consider the following elements. Any resulting pain and suffering or mental anguish experienced by Beata Kowalski prior to her death on January 7, 2017. There is no exact standard for measuring such damage. The amount should be fair and just in the light of the evidence. Now, members of the jury, I noticed that we, in one case, said that Beata Kowalski died on January 7th and another time on January 8th. I think the evidence was it was in that time frame. I apologize, I was not consistent, but the intent here is the damages before her death, okay? Whether it's on January 7th, the evening of the January 7th, or the morning of the 8th. Moving on to Claim 6. The sixth claim for your consideration in this case is a claim brought by the estate of Beata Kowalski. The estate claims that Johns Hopkins All Children's Hospital acted extremely and outrageously during the time that Maya Kowalski was a patient at the hospital, and that this conduct is a legal cause of Beata Kowalski's death by suicide. Johns Hopkins All Children's Hospital denies this claim. If you decide on the verdict form for the survivor claim, the fifth claim, that the estate did not prove its claim. Actually, can I see the attorneys for a second on this?
So the judge is catching typos. He's catching typos as he goes, and he might see something here that wants to make sure he's got right. What's happening right now is the jurors are reading ahead, going like, wait, what's he telling us to cross out? But Nurse for God, wonderful to have you here. Woohoo, 6 months. Love this chat. Thank you very much. Great to have you here, and love that you have a yellow courthouse by your name. Judge is doing a great job. We're over halfway. I think we're getting close to 3/4 of the way through this. These instructions. There are 68 pages total. There are 7 charges. 7 charges. The first one was false imprisonment. Second one was battery. Third was negligent medical treatment. Fourth was fraudulent billing. Fifth was intentional infliction of emotional distress. And the sixth one is J-Hatch, extreme outrageous behavior. That's the legal cause of Beata's, the reason she took her life. So this, obviously, if the jury finds for the plaintiff in this one, the potential for damages is very high in this charge specifically. But let's see. I did, for those that are asking, I did notice that Rob is not doing a recap tonight, and because that the one I could see that is doing a recap tonight is Kurt from Uncivil Law. I don't know what it's going to cover. Kurt's been in and out of chat for quite a long time here, so I'm going to do a redirect to his channel. I don't know how he's going to cover or what he's going to cover, but there's a variety of very talented attorneys that are in part of LawTube. Kurt is one of those, and so we're going to redirect to his live stream tonight for a recap for a legal analysis. I don't know how it's going to cover it. Hopefully, it answers all your questions that I'm not able to. But we've got that set up as a redirect when this one ends, just for your information. That being said, I am still watching the Colorado courts right now. We're waiting the case of the People versus Woodyard, which is the Elijah McClain police officer charged in the death of Elijah McClain. They are still deliberating. And so if anybody can join with me and keep refreshing the page on the Colorado Courts judicial branch page to see when the Adams Division L pops back up again and lets me know, I have authority to or permission from the judge to record that, and I'll post that on my second channel. That's over on the Top Mark Media channel, and we've got all the rest, almost all the rest of this case, except for when the court made some problems with the WebEx, but we've got pretty much everything else over there, and we'd like to bookend that with the verdict when that comes out, hopefully today. So thank you for that one. All right, the court's on Twitter. I'm keeping an eye on Twitter as well.
Pass me the note. Are we able to finish the reading of the instructions? Probably another 30 minutes. Okay. I'm going to restart at the beginning of page 46 because I don't exactly know where I was. The sixth claim for your consideration in this case is a claim brought by the estate of Beata Kowalski. The estate claims that Johns Hopkins All Children's Hospital acted extremely and outrageously during the time that Maya Kowalski was a patient at the hospital, and that this conduct is a legal cause of Beata Kowalski's death by suicide. Johns Hopkins All Children's Hospital denies this claim. If you decide on the verdict form for the survivor claim, which is the fifth claim, that the estate did not prove its claim that Johns Hopkins All Children's Hospital acted extremely and outrageously, causing Beata Kowalski severe emotional distress, then you must also decide in favor of Johns Hopkins All Children's Hospital on this sixth claim. However, if you decide on the verdict form for the survivor claim, which is the fifth claim, and that the estate did prove its claim that Johns Hopkins All Children's Hospital acted extremely and outrageously, causing Beata Kowalski severe emotional distress, then you must also decide the issues in this sixth claim. The estate must prove its claims by the greater weight of the evidence. I will now define some of the terms you will use in deciding this claim. Greater weight of the evidence means the more persuasive and convincing force and effect of the entire evidence in the case. Extreme and outrageous conduct is behavior which, under the circumstances, goes beyond all possible bounds of decency and is regarded as shocking, atrocious, and utterly intolerable in a civilized community. Emotional distress is severe when it is of such intensity or duration that no ordinary person should be expected to endure it. I apologize. Was I at the greater weight instruction?
You're at the issue for you to decide.
Okay, I apologize, members of the jury. The issue for you to decide on the estate's wrongful death claim are: 1, whether Johns Hopkins All Children's Hospital, through its employees or agents, engaged in extreme and outrageous conduct during the time that Maya Kowalski was a patient at the hospital, and acted with the intent either to cause Beata Kowalski severe emotional distress or with reckless disregard of the high probability of causing Beata Kowalski severe emotional distress, and, if so, whether that extreme and outrageous conduct was a legal cause of Beata Kowalski's death by suicide. Johns Hopkins All Children's Hospital did not need to specifically intend for the conduct of its agents and employees to cause Beata Kowalski to die by suicide. However, the agents and employees of Johns Hopkins All Children's Hospital needed to engage in extreme and outrageous conduct with the intent to cause Beata Kowalski severe emotional distress, or with reckless disregard of the high probability of causing Beata Kowalski severe emotional distress, sufficient to be a legal cause of her death by suicide. To be a legal cause of Beata Kowalski's death by suicide, the extreme and outrageous conduct must either: 1, create in Beata Kowalski an uncontrollable impulse to commit suicide, or 2, be a substantial factor in bringing about the suicide. Uncontrollable impulse means a mental state that prevented Beata Kowalski from appreciating the nature of the act of suicide or controlling her conduct. In order to be regarded as a legal cause of death by suicide, extreme and outrageous conduct need not be the only cause. Extreme and outrageous conduct may be a legal cause of severe emotional distress, even though it operates in combination with the act of another or some other cause, if the extreme and outrageous conduct contributes substantially to producing such severe emotional distress. If the greater weight of the evidence does not support the estate's claim, your verdict should be for Johns Hopkins All Children's Hospital. However, if the greater weight of the evidence supports the estate's claim, then your verdict should be for the estate and against Johns Hopkins All Children's Hospital. If your verdict is for Johns Hopkins All Children's Hospital, you will not consider the matter of damages. But if the greater weight of the evidence supports the estate's claim, you should determine and write on the verdict form in dollars the total amount of loss, injury, or damage which the greater weight of the evidence shows the estate of Beata Kowalski and her survivors sustained as a result of her injury and death, including any damages that the estate and the survivors are reasonably certain to occur or experience in the future. Elements of damage for the estate. In determining the damages recoverable on behalf of the estate of Beata Kowalski, you shall consider the following elements: the estate's loss of net accumulations. Net accumulations is the part of Beata Kowalski's net income from salary after taxes, including pension benefits, which Beata Kowalski, after paying her personal expenses and monies for the support of her survivors, would have left as part of her estate if she had lived her normal life expectancy. Elements of damage for surviving spouse and children. In determining any damages to be awarded the estate for the benefit of Beata Kowalski's surviving spouse and children, you shall consider certain additional elements of damage for which there is no exact standard for fixing the compensation to be awarded. Any such award should be fair and just in the light of the evidence regarding the following elements. A. Damages of surviving spouse. Jack Kowalski's loss of Beata Kowalski's companionship and protection, and his mental pain and suffering as a result of Beata Kowalski's death. In determining the duration of the losses, you may consider the life expectancy of Jack Kowalski together with the other evidence in the case. B. Damages by surviving children. The loss by Kyle Kowalski and Maya Kowalski of parental companionship, instruction, and guidance, and their mental pain and suffering as a result of Beata Kowalski's death. In determining the duration of those losses, you may consider the life expectancy of each of the surviving children together with other evidence in the case. C. Loss, support, and services. The survivors, Jack Kowalski, Maya Kowalski, and Kyle Kowalski's loss by reason of Beata Kowalski's injury and death of Beata Kowalski's support and services from the date of injury to the date of death. In determining the duration of any future loss, you may consider the joint life expectancy of the survivors and Beata Kowalski in the period of minority ending at age 25 of Maya Kowalski and Kyle Kowalski. And D. Medical and funeral expenses. The medical and funeral expenses resulting from Beata Kowalski's death paid by Jack Kowalski. In evaluating past and future loss of support and services, you shall consider the survivor's relationship to Beata Kowalski, the amount of Beata Kowalski's probable net income available for distribution to the survivor, and the replacement value of Beata Kowalski's services to the survivors. Support includes contributions in kind as well as sums of money. Services means tasks regularly performed by Beata Kowalski for a survivor that will be a necessary expense to the survivor because of Beata Kowalski's death. Any damages that you find were sustained by Beata Kowalski's estate and by Jack Kowalski, Maya Kowalski, and Kyle Kowalski shall be separately stated in your verdict. Mortality tables. In determining how long Beata Kowalski would have lived had she lived out her normal life, you may consider her life expectancy at the time of her death. The mortality tables received in evidence may be considered in determining how long she may have been expected to live. Mortality tables are not binding on you, but may be considered together with other evidence in the case bearing on her health, age, and physical condition before her death in determining the probable length of her life. In determining the duration of any future loss sustained by Jack Kowalski, Maya Kowalski, and Kyle Kowalski by reason of the death of Beata Kowalski, you may consider the joint life expectancy of Jack Kowalski, Maya Kowalski, and Kyle Kowalski, and Beata Kowalski. The joint life expectancy is that period of time when both the decedent and a survivor would have remained alive. The mortality tables received in evidence may be considered together with the other evidence in the case in determining how long each may have been expected to live. Any amount of damages which you allow for the estate's loss of net accumulations should be reduced to its present money value, and only the present money value of these future economic damages should be included in your verdict. The present money value of future economic damages is the sum of money needed now, which, together with what that sum will earn in the future, will compensate for these losses as they are actually experienced in future years. The seventh claim for your consideration in this case is brought by Maya Kowalski against Johns Hopkins All Children's Hospital.
Last claim, guys. We're
Maya
almost there.
Kowalski claims that Johns Hopkins All Children's Hospital acted extremely and outrageously during the time that she was a patient at Johns Hopkins All Children's Hospital. Johns Hopkins All Children's Hospital denies this claim. Maya Kowalski must prove her claim by the greater weight of the evidence. I will now define some of the terms you will use in deciding this claim. Greater weight of the evidence means the more persuasive and convincing force and effect of the entire evidence in the case. Extreme and outrageous conduct is behavior which, under the circumstances, goes beyond all possible bounds of decency and is regarded as shocking, atrocious, and utterly intolerable in a civilized community. Emotional distress is severe when it is of such intensity or duration that no ordinary person should be expected to endure it. Extreme and outrageous conduct is a legal cause of severe emotional distress if it directly and in natural and continuous sequence produces or contributes substantially to producing such severe emotional distress, so that it can reasonably be said that, but for the extreme and outrageous conduct, the severe emotional distress would not have occurred. In order to be regarded as a legal cause of severe emotional distress, extreme and outrageous conduct need not be the only cause. Extreme and outrageous conduct may be a legal cause of severe emotional distress, even though the act of another or some other cause also contributes to the distress. The issues for you to decide on Maya Kowalski's claims are: A, whether Johns Hopkins All Children's Hospital engaged in extreme and outrageous conduct and acted with the intent either to cause severe emotional distress or with reckless disregard of the high probability of causing severe emotional distress to Maya Kowalski, and, if so, whether the extreme and outrageous conduct was a legal cause of severe emotional distress to Maya Kowalski. If the greater weight of the evidence does not support Maya Kowalski's claim, your verdict should be for Johns Hopkins All Children's Hospital. However, if the greater weight of the evidence supports Maya Kowalski's claim, then your verdict should be for Maya Kowalski and against Johns Hopkins All Children's Hospital. If your verdict is for Johns Hopkins All Children's Hospital, you will not consider the matter of damages. But if the greater weight of the evidence supports Maya Kowalski's claim, you should determine and write on the verdict form in dollars the total amount of loss, injury, or damage which the greater weight of the evidence shows will fairly and adequately compensate Maya Kowalski for the loss, injury, or damage caused by the extreme and outrageous conduct. If you find for Maya Kowalski, you shall consider the following elements. A, any emotional distress sustained by Maya Kowalski and any resulting bodily injury, disability, or physical impairment, mental anguish, inconvenience, or loss of capacity for the enjoyment of life experienced in the past or to be experienced in the future. There is no exact standard for measuring such damage. The amount should be fair and just in the light of the evidence. B, the reasonable value of medical care and treatment necessarily or reasonably obtained by Maya Kowalski in the past or to be obtained in the future. C, any loss of ability to earn money sustained in the future. Aggravation or activation of disease or defect. If you find that Johns Hopkins All Children's Hospital caused a bodily injury and that the injury resulted in an aggravation of an existing disease or physical defect, you should attempt to decide what portion of Maya Kowalski's conditions resulted from the aggravation. If you can make that determination, you should award only those damages resulting from the aggravation. However, if you cannot make that determination, or if it cannot be said that the condition would have existed apart from the injury, then you should award damages for the entire condition suffered by Maya Kowalski. In deciding this case, it is your duty as jurors to decide the issues, and only those issues that I submit for your determination. You must come to an agreement about what your answers will be. Your agreed upon answers to my questions are called your jury verdict. The evidence in this case consists of the sworn testimony of the witnesses, all exhibits received in evidence, and all the facts that were admitted or agreed to by the parties. In reaching your verdict, you must think about and weigh the testimony in any documents, photographs, or other material that has been received in evidence. You may also consider any facts that were admitted or agreed to by the lawyers. Your job is to determine what the facts are. You may use reason and common sense to reach conclusions. You may draw reasonable inferences from the evidence, but you should not guess about things that were not covered here, and you must always apply the law as I have explained it to you. Let me speak briefly about witnesses. In evaluating the believability of any witnesses and the weight you will give the testimony of any witnesses, you may properly consider the demeanor of the witnesses while testifying, the frankness or lack of frankness of the witness, the intelligence of the witness, any interest the witness may have in the outcome of the case, the means and opportunity the witness had to know the facts about which the witness testified, the ability of the witness to remember the matters about which the witness testified, the ability of the witness to remember the matters about which the witness testified, and the reasonableness of the testimony of the witness, considered in the light of all the evidence in the case and in the light of your own experience and common sense. You have heard opinion testimony on certain technical subjects from persons referred to as expert witnesses. You may accept such opinion testimony, reject it, or give it the weight you think it deserves, considering the knowledge, skill, experience, training, or education of the witness, the reasons given by the witness for the opinion expressed, and the other evidence in the case. It is entirely proper for a lawyer to talk to a witness about the testimony the witness would give if called to the courtroom. The witness should not be discredited just because the witness talked with a lawyer about his or her testimony. In your deliberations, you will consider and decide several distinct claims. Although these claims have been tried together, each is separate from the others, and each party is entitled to have you separately consider each claim as it affects that party. Therefore, in your deliberations, you should consider the evidence as it relates to each claim separately, as you would had each claim been tried separately. Although these claims are separate claims, it is possible that separate claims may result in overlapping damages. Your verdict should not award damages twice for the same loss, injury, or damage, even if they result from different claims. Your award of monetary damages for each claim, if any, must not duplicate the same damage awarded in the other claims. That is the law you must follow in deciding this case. Tomorrow morning, the attorneys for the parties will present their final arguments to you. And when they are through tomorrow, I will have a few final instructions about your deliberations. Now, we're going to pause it right there.
Okay, so that's all 68
and
pages.
That's going to be all of the instructions I am going to read. Can I see the attorneys for a moment up here, please?
Sorry, you guys asked for a picture of the trees with snow, and it snows. It snows like once every 2 years here, and so this is the only one I've got with snow on the ground, and this is like snow on the beach in Florida type situation. It doesn't happen, so that's all I can give you. Anyway, no, that was like 2 years ago that picture was taken. All right, instructions were long and a little convoluted, but I think to the jury it made sense. I think it clarified a lot of things. We've got 7 charges now: false imprisonment, battery, negligent medical treatment of Maya, fraudulent billing, intentional infliction of emotional distress, and then 2 counts of extreme and outrageous behavior, which I think are tied to number 6, right? And one is regarding that it was the cause of Beata's taking her own life, and the other was for Maya and against her. So those are the 7 counts that will be going to the jury. Jay Shaw, welcome very much. Or Jasha, can we do a poll? We still have closing arguments. We still have closing arguments, and that'll be tomorrow. And then we'll do the poll. I promise we'll have the poll. We've been putting this off for a long time, but we will do it. Please show Ari and Mod some much deserved respect by hitting the like button and subscribe. It's all free. It is. Thank you very much, Casey Cat. I appreciate that. Thanks for doing both of those yourself. All right. As far as the instructions, was there anything that surprised you in what you heard? I'll say the first one, the false imprisonment. The J-Hatch denies the actions were unreasonable. J-Hatch admits it kept her at the hospital, placed her in another room, and took photos of her. They're admitting all those things. But when it comes to the battery, count number 2 of the battery, the Kathy Beatty and the bedside nurse allegedly committed battery by doing this unwanted physical contact while restrained during both that and during the photo shoot.
Members of the
That's
jury,
why she doesn't say it's her
in a
name.
moment I'm going to let you retire to the deliberations room, but you are not to begin to deliberate anything, because we're going to have additional arguments tomorrow and some further jury instructions. You're not going to go home just yet, but I am going to be sending you back into the jury deliberation room. So do not discuss this case amongst yourselves. Do not do any investigation and receive no information. Now, I'm going to send 11 of you. I'm going to keep juror number 181 out here with us.
Here we go.
Okay, so
Here
if
we go.
the 11 of you can go back into the jury deliberation room.
Okay, this is the decision. And 181's like, what did I do? What did I do? Big eyes right here. Big eyes, yeah. So here is the moment. The moment, juror number 181, also referred to as juror number 1 now. This is what we've been waiting for.
Please be seated. The only juror that remains with us is juror number 181. All 11 other jurors are not with us. I did receive your note, and I have discussed it with the attorneys, and I'm sorry that you're experiencing the issue that you put in your note. I don't want to say what it is. What I'm going to do
This is something else.
is I'm going to discharge you from your further service of jury duty. I already have a juror note for you.
This is a different
There's
thing.
a whole bunch of things I would like to say that I don't have time to go into, so I'm just going to kind of give you the short statements here. Number 1, I have already entered a court order prohibiting the disclosure of the names of the jurors until after the trial is over. You know the names of the jurors. So I'm telling you, until the trial is over and everything's done, you cannot let anyone know the name, identity, where they work. Do you understand that? Okay.
It's a male. It's a male juror.
You're going to be free of all other instructions. And so in a moment, I'll tell you what that means. But the bottom line is you're going to be free to talk about whatever you want You're going to be free to look at whatever you want. You're going to be free not to talk about whatever you want. That's going to be totally up to you. But one of the most important things I need you to remember is until this is all over, you cannot say anything about the names of the other jurors. Unfortunately, because I'm going to be discharging you, I cannot have you say goodbye to the others. And I feel very sorry that I'm going to have to do that to you. What I will do is if you leave your telephone number with the court deputy, and if you are comfortable with it, when this is all over, I will give your telephone number to the other jurors. And then they can contact you, and then I'll ask them to give me their numbers so that you all can communicate back and forth. But that's not going to happen until after this is all over. So it's totally up to you if you want to leave your telephone number for us to give to the other jurors. And again, I apologize that you're not going to get to talk or say goodbye to everybody else. You have given us over 9 weeks of your
life,
time and attention. You took copious notes. You asked lots of questions. You did everything we asked you to do as a citizen of the state of Florida. And I cannot tell you how much I appreciate it. I know you have a job, and I know your employer has given up your skills while you were with us. And so on behalf of all the lawyers in this case and on behalf of the court, I want to say thank you. I do have a certificate. I didn't know this was going to happen, so I don't have the certificate ready, but I will send that to you as well. Also, if you leave us your cell phone number, when we have a verdict, my assistant will call you. If you want to come on down to watch, you can do that. If you want to sign online to the Zoom or tap into any of the number of feeds that are being broadcast, you will be able to do that. So
we'll take you.
With that, I'm going to go ahead and give you the formal discharge instruction. And I'm going to file this note, although Madam Clerk, he put his name on it, so the name has to remain protected. On behalf, and Juror 181, on behalf of the parties, lawyers, and the people of the state of Florida, I wish to thank you for your time and consideration of this case. And I also wish to advise you of some very special privileges enjoyed by jurors. No juror, that would include you, can be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that the jury's deliberations, discussions, and votes should remain their private affair so long as you wish. And I know you didn't deliberate, and I know you haven't been discussing
this
the case,
is a personal
but I'm just reading
issue.
you the instruction.
It might be medical.
Therefore, the law gives you a unique privilege not to speak about the jury's work. The lawyers and their representatives are not permitted to approach you. They are not permitted to initiate any communication with you about the trial. However, you are free, if you wish to speak with any of the lawyers or anyone else about this trial, you may do that. Can't tell anybody the names of the other jurors until this is all over. So you have the right to refuse to speak with anyone, and you can also talk. It's going to be totally up to you. Please understand that a request may come from those who are simply curious or those who may seek to find fault with you. And it's going to be up to you to determine whether to preserve your privacy as a juror. So, do you have anything in the back room?
Please say eggs. Please say eggs.
So you do not need to go back in there? Okay, so what I'm going to ask the sheriff's office to do is to take him out that door and take him directly to his vehicle, and let me know when he is gone so we can then let the other jurors go, because I don't want there to be any possibility of them overlapping. So what I'm going to do is And I'm going to ask the TV folks, as he goes through this other door, let's make sure we do not capture his face. Thank you very much for yours. I hope the medical issue resolves in a quick fashion for you.
This is all medical.
Okay.
This has nothing to do with anything the juror did inappropriately. This is not a juror that has done wrong by the Florida standard jury instructions. This is strictly medical, and this was a note that was given to the judge this morning.
Sorry, I didn't mean to do that.
But it happened, Judge.
I just have to wait for another deputy to come so I can bring back the other 11. Why don't you bring them in?
The clerk's like, I could. Oh wait, no, that's a deputy. Never mind. All right, that is a hard thing. That juror gave 9 weeks of his life to this, and then it's the dilemma he's faced with a medical condition, saying, Judge, I can't continue. The judge excused the juror. Okay, that takes us down to 11. And we still have to have the discussion about number 1. And that will be happening this afternoon. But the question is, was this one of the deliberating jurors? And if it was, it brings on the alternate that the defense obviously is okay with having. What about the next alternate? If defense gets rid of number 1, or if they're successful in getting rid of number 1, it brings on another alternate. Is that someone the defense wants on the jury? Or suddenly will they start singing a different tune?
Okay, everyone, please be seated. Members of the jury, I want to confirm while you're away, you did not discuss this case amongst yourselves, you did not do any investigation, and you did not receive any information.
They're looking at the empty chair right now.
Correct? And no one's approached you about this case, is that correct?
Correct.
And has anyone seen any media coverage about this case?
No.
Okay. You will see that one of your number is no longer with us. He was suffering a medical issue. We will proceed with 11. Okay. I need him to get to his car because I can't have him have any contact with you. I've told him a couple of things. Number 1, that he is not allowed to disclose your identity or where you work until after this is all over. Okay, so don't worry about that. He understands that issue. I also said that if he wants to leave his telephone number, I would be happy to share it with you after this is all over. And if you wish to leave your telephone number so I can share with him, I'm happy to do that. It's just I told him he is not, and even if he has one or more of your cell phone numbers, he is not allowed to contact you until this is all over, and he understands that. But if for whatever reason he does attempt to contact you, you cannot have any contact. I apologize that you haven't had a chance to say goodbye, but that's just the way I need to run it this way. Okay, so as soon as I discharged him, he can't cross your path. So that is the reason why I've done it the way I've done it. Now, I'll also say a couple more things. Tomorrow you're going to be deliberating, and I have told you we're going to take your cell phone and any sort of like smart watch or anything like that away from you. A lot of times what juries find is when we get to this stage, things happen rather quickly, and then all of a sudden it's over and everybody's gone. If you all wish to share amongst yourselves your cell phone numbers and whatnot, it's up to you. I don't care. It's up to you if you want to do that. It's a good idea to do it today as opposed to tomorrow. Okay, just if you're going to do that, get it out of the way. And so when you come tomorrow, we're focused on the closing arguments and then the beginning of deliberations. Now, let's talk about the time for tomorrow. I asked you before we went to lunch if we can start earlier. I saw there might have been some, so I don't know. Do you want to start earlier, 30 minutes early, 15 minutes earlier, or the regular time? Early, so be here to start at 8:30. Is that comfortable for everybody? I mean, is it going to cause a problem for anybody? Okay. Now, a couple other things. I'm going to, when the When you come in tomorrow, we're going to ask for your lunch order from wherever we're going to get the lunch. I don't know where that is. So we'll get that done right out of the way. Just make sure on your lunch order you put your juror number, not your name, but your juror number on the order, because I don't want your names going to wherever we're going to go to lunch. So we all remember our juror numbers? Okay. Timing for tomorrow evening. I'm going to kind of let that be the jury's determination within reason. I mean, I'm not going to stay until, 1 o'clock at night. If you come and decide at some point you still want more time to deliberate, that's fine. If you want to leave at whatever time, so long as you put in a full day tomorrow, that's fine. If you want to go into the evening somewhat, that's fine. That's going to be up to the jury. I know is it Wednesday, we've got to stop early. So, we'll stop at whatever time we need to stop on Wednesday. So, have we heard if we're clear at this point? Okay. So, Juror 181 is now gone. Again, I apologize for the way all that went down, but it's the way I need to do it to make sure, one, that we don't have any sort of issue now that we're 9 weeks into this trial. I would hate to have an issue arise that caused us to start this whole thing over. So I'm just being overly protective of doing this properly. Do not discuss this case amongst yourselves. Do not do any. Is there anything else I need to instruct the jury before I let them go for the day? Okay, we will see you at 8:30 tomorrow. Do not discuss this case. Do not do any investigation. Receive no information.
All rise.
Okay, so we're down to 11 jurors, and there's a possibility of losing another one tonight. I'm not saying they're dropping like flies, but I was struck during this moment at the judge's understanding of how the sorry, I'm trying to switch between feeds and it's not working very well. Of how the jurors perceive the trial and the relationships that are formed and the friendships and understanding the timing.
No more than 10 minutes. Okay. I'm sorry?
What all do we have to do?
Well, we still have a juror disqualification motion.
Yep.
We've got apparently a couple of issues with the jury instructions. There's
a few jury exhibit, not major, but you can't agree on like 3 or 4 restrictions, Judge.
Okay. We'll take 5 to 10 minutes and we'll address all of those issues when we come back. Okay?
All rise. Close and recess.
Okay, so we're gonna jump to this screen here. Hang on one second. All right. We may have Jules call. I'm not sure. We're going to take 5 to 10 minutes of a break right now. What we've had happen today so far is that we had the fireworks from the IG situation. Most of that has played out. There are still elements of that still have to be resolved. The judge still has reserved his decision on sanctions. He's reserved his decision on a directed verdict relating to this. That's still out there. We had the rebuttal that the judge ruled that it was okay. It was coming in, and we had the rebuttal. Remarkably, defense sat almost silent through all of it. We got some objections towards the end. As the plaintiff got to the outer edges of what the judge authorized him to go into, realized he said he didn't want a huge, full, in-depth exploration of every dark nook and cranny here. So Mr. Whitney was able to very, very thoroughly cover the issue with Dr. Corcoran and did a great job of that. But when he got to the edge, it pretty much got shut down by defense by objection, and Mr. Whitney said, "I'm done." No juror question was asked. It was not asked. We did get Mr. Whitney asked a follow-up Mr. Whitney sort of rephrased the question and asked it. I'm not sure if that meant it came from juror number 1 and they were concerned about the issue with a pending motion regarding his dismissal. I don't know what the case is there. But that went through. We had a little bit of back and forth. Mr. Hunter crossed the witness on rebuttal, and basically tried to point out that he hadn't read all the documents in the banker's boxes of stuff that was delivered Friday night. Okay. And he's like, "Oh, have you seen this? Have you seen that?" And the witness is like, "Hey, show me. I'd be happy to comment. Anything you got, show me." Mr. Hunter got caught with his pants down a little bit. He's like, "Oh, I don't have it ready." And we had to take a 10-minute break. Hunter got the documents ready, gave them to the dude. The dude flips through. He's like, "Yeah, look, it says this bad about you here, it says this bad about you here, it says this bad about you here." It did more damage to the defense to have the cross. It would have been better if Hunter had just said, "No questions for this witness," and sat down. But it did. It added right here. This is true. Added to his credibility as a witness. It was really good. So that was phenomenal. It was really great. Once that was done, we went straight. Well, we had a little bit of breaks. We had a lot of breaks. We haven't taken one. I haven't got a lunch break. I ate chicken in front of you guys. Sorry about that. I usually don't like doing that, but I was starving. But we then went to jury instructions. 68 pages of jury instructions that the judge read to the jurors, as the jurors all had their own copies. They had these copies and they read them, and they went through all 68 pages. That it documented the 7 remaining allegations that the jury will be deliberating. The key parts in the instructions, the jury instructions, are that Johns Hopkins is not sheltered from any of these charges. The whole dependency hearing stuff does not shelter Johns Hopkins from any of the charges they're deliberating on. And these charges were spelled out pretty clearly in the instructions to how to find and what to do. If you find A, then you go on to B. Punitive damages, where those apply, where they don't apply, what you have to find first. Those are all spelled out. So the jury not only heard that today, watched it, they're also going to have their copy to review while they deliberate. We did hear that tomorrow morning the jury's going to start at 8:30, and I think tonight we have a few items to go over. I think we have a very minor a juror instruction or something that's it's the secondary instruction. They just want to make sure it was right. And that's what I heard from Ms. Correll's. So that's happening, I think, or that might be on the verdict form, actually. Then we have probably some last little bits of evidence or something just to make sure that everything's that both sides agree as to reactions or something before it gets submitted to the jury. And then we have the big issue of the juror disqualification motion that came in Friday night from Mr. Shapiro. And that is going to be decided. Now, the jury's out of our presence, so they're not going to know about this till tomorrow morning when they show up for work or show up for jury duty. And then possibly at that point, one of them might be informed, much like this one was today, that their services are no longer needed, and thank you very much. Take your bags and go home. No contact, no hugs, no goodbyes, no signing yearbooks, just go. And the judge has to do that because he releases that juror from that no talkie order. And as soon as you've released them, they can talk, but the other jurors aren't allowed to listen. So he says, I need to keep you separate until this trial's over. All right. I think Scott could do with the mushroom risotto. Thanks, Rebus. Trying to feed me fungus. I see what you're doing. What about sanctions? Sanctions we're waiting on. And I would say there were a couple key moments. This judge has looked very calm throughout today, but I can tell there are a couple moments he's been frustrated, and I think he's already leaning on the sanction direction. He's headed that way. So I think it's more probable than not that will happen. Did they release a juror today? Yes, Virginia Little. They released juror number 181 for a medical reason. He brought a note saying he's going through a medical situation of some sort. It sounds like he personally is. So he was released for that, and completely unrelated to the issue from Friday. But it was nice of the judge to at least consider and say, hey, if you'd like to know, leave us your phone number. When you're ready for a verdict, we'll call you as well. You can be down here for the verdict, so you can see it all go down. You can be there and see the conclusion. Because, if you've invested 9 weeks of your life into something every single day, okay, and not only just invested, but invested it and then not been able to talk to anyone, even your closest friend and confidant, about it for those 9 weeks, suddenly to be just ripped out of that and stuck back in life, that's very traumatic. That's huge. You can get PTSD from this. And the judge is like, hey, we want to include you. We want to make sure you still are able to contact the jurors that you've been sitting with for 9 weeks. You've probably made some friends. You've probably made some connections. You probably said, hey, when this is over, we'll have to go get a drink or something. And so he's He's facilitating that. He's being the matchmaker, is swapping phone numbers and passing notes back and forth. So that was nice of him. I liked seeing that. That was very thoughtful. All right, we've got just a couple more minutes of break before we come back to court. We're listening right now to the feed, and as soon as we get the feed back, as far as audio, we're going to take it when the judge is back, as they're ready to move on. I think we're going to start with the jury disqualification issue first. Once that's done, once we get rid of all of the rest of the paperwork, which shouldn't take too long, I think we've got less than an hour left in court for sure. But as soon as that's done, we're going to hammer out the details. I'm sure the judge will say how much or what time tomorrow we're going to start. The clock doesn't matter anymore. The clock's done. It's all finished. Closing statements happen tomorrow, and then the jury starts deliberating. We'll be in verdict watch by the end of the day tomorrow. All right. Are we sure he was one of the seated six? We are not. All I know is it was a male voice that I heard answering the judge's question. He was very quiet, but it's a male voice, and it was excused for a medical reason. Jules will probably be able to tell us more about this juror. The judge got a note from the juror in the middle of instructions. That's when the judge found out, y'all, that the juror had to have brought it with him this morning. It's like, I'm not sure when's the best time to hand this to the judge. Now as good as any. He's reading to us. He's talking to us. Let's hand him the note. Clock is out the window. Time flies. Yes, we successfully managed to get to the end of trial without anyone running out of time, which would mean Rob is right. Rob was right. It was fine. Time was not a problem. We got there. Juror 181 sent a note to the judge during jury instructions. He has a medical issue and has been dismissed. We'll cover the motion to dismiss juror number 1 after the break. Thank you, Amber. That's exactly what's going on here, and we're waiting for that audio. You'll hear the judge's door open as soon as it does, or you'll hear the judge as soon as he takes his seat. Let's see. Juror number 1 has not been sent home. Ariel, this is not yet. Juror number 181. 181 is this. Jules got his phone number? Or you hope Jules got his phone number? I would say this. I don't want to put that juror in a situation where they might accidentally break the judge's rules, and I wouldn't want that juror to definitely be in a situation where they're not comfortable. So if they want to speak to somebody, obviously there are many people that would love to hear that perspective. What did the court look like from that side of the juror box, from inside the juror box? But we'll see. We'll wait and see. Let's keep it real. Mr. Anderson ran out of time. They had 25 minutes left. 25 minutes left on their rebuttal case. Is your hand feeling better, buddy? That's good. Can you give me 5 with it? Or is it still... No? With that? Nice. All right. At this point, I don't think it would... Let's see. This one, I don't think he would give up the possibility of deliberating except for something serious because he already invested so much time. Yeah. 9 weeks in. Magical Mary says, Judge asked for a 15-minute tomorrow morning. Motion on sanction, maybe? Probably. It's probably going to be this. No, well, there's not much else you can do at that point, right? You've got directed verdicts, and sanctions are all that's left to handle. And now, looking at this count, we're up to 1771 on objections. I think a lot of you were guessed 1776, which is significant in U.S. history. For those that are curious, a lot of you guessed 1776. But we'll see if we get there. We'd only need 5 more tomorrow, and we'll get there. Oh, sound's back.
Hey, please be seated, everybody. Let's go over a few things before I forget. The plaintiffs used 50 minutes today. So in rebuttal, they consumed a total of 2 hours. The defense consumed 35 minutes. So in rebuttal, they consumed 55 minutes. So I think that concludes those time clocks. Now, you all were referencing that there might be some issue with the jury instructions.
Very minor, Your Honor. On the false imprisonment in the first...
Can you give me a page number?
Yes, I can. Page 13.
Page 13.
A and B on page 13A only includes in the past, and I think it should say and in the future. Or whatever language is acceptable, but I think that was unintentionally dropped out.
Wasn't this a question I sent around this weekend?
I wasn't paying attention.
You know, I think it might have been, but I sort of counted on Mr. Elliott to catch it. I didn't double check it, but I'm not going to object to this.
Okay, so we need to add or in the future?
Yes.
Yes, sir.
So what I'll do is I'll have the jurors open up their package and then I'll tell them to add those words in.
And I had a couple little things as well.
Okay. What page are you on?
Page 19 at the bottom, where it starts off with all children's, John Hopkins All Children's Hospital admits that it would be liable. For some reason, the standard sentence that would precede that, which is that John Hopkins All Children's Hospital denies these claims, got left off that one.
I had no idea it was so hefty.
It's just them owning up. Hey, it's us. We did it. Whoops.
So it would be Johns Hopkins All Children's Hospital denies these claims and then go into Johns Hopkins All Children's Hospital admits.
Yes.
Any objection?
Because it was missed of course and scope.
No objection.
Okay.
And then on page 41.
Mr. Elliott, were you trying to...
No, when you finish with the instructions, we need to do a jury verdict form change to match the change we just made. It's wrong there, too. On false imprisonment. So we'll come back to that.
Oh, on the damages.
Yes.
Okay. On page 41, when we agreed to drop the fraudulent billing down to Mr. Kowalski, I still had a them in line 3 and a them in line 5. And then in subpart A, it was the plaintiffs rather than him, and Mr. Kowalski.
Okay, so what should it read?
It should read, you should award him an amount of money that the greater weight of the evidence shows will fairly and adequately compensate him for any monetary loss. And then down in the elements, the sub A should read, any deductibles or copays incurred by Mr. Kowalski as a result of Mayor Kowalski's sheltering at Johns Hopkins All Children's Hospital.
We had an addition as well, Your Honor.
I can only do one at a time. Okay, so I've got on line 3 on page 41, line 5, and then so the plaintiff should read Mr. Kowalski.
Yeah.
I'm going to jump back in time just briefly here. There we go.
So 3 changes on page 41. Is that correct? 3
That's
changes
correct.
on page
That's all
41.
I had.
Is that correct?
That's correct.
There we go.
That's all I had.
Okay, Mr. Anderson.
Judge, we believe that, and I should have proposed this over the weekend, but we were a little preoccupied, as the court may be aware. This would be a C on page 41, and then in addition to question 41 on the verdict form.
Okay, well, just do one thing at a time. Please don't do multiple things. So what do you want added to the language on page 41?
And or any billing by defendant of charges for medical services you determined were unnecessary and or not performed. To take into account that we have the billing in evidence and testimony that it was unnecessary and that they did not receive the CRPS billing for at least the psychoanalyst, the psychological Dr. Katzenstein charges. In the record, we have the complete billing. We have a slide with the breakdown of those. I'm sure the jury hasn't gone in and broken them down like we have, but we've broken it down for Dr. Katzenstein charges, and we believe that if the jury thinks that based on the discharge form where there was no listing of CRPS, they want to get rid of some of those charges, it should be part of the instruction and the interrogatory
So
here.
what is the specific language you're asking to be added?
And or any billing by defendant of charges for medical services you determine were unnecessary and or not performed.
Two things. It wasn't pled. If it had been there, the expert that we brought all the way down from Baltimore would have talked about this. The impact on him for these things is in the copay for him personally, because Aetna's not really complaining about any of this. So I don't think that's necessary. And I'm not quite sure how they would, I'm not sure what the evidence is that allows them to figure out how to calculate this.
So that was your second reason?
I think, yeah, that might have been 3 reasons out of 2.
Any response?
That's an objection because it
Yes,
wasn't
Your
pled.
Honor. The evidence came in without objection. We put the billing in. We talked about the CRPS not being performed as it should be and not being treated. And there's also a reasonable inference from the evidence that none of the CRPS billing should be charged against them. Now, will the jury agree? I doubt it. But we believe with the evidence in the record right now, there should be at least language to that effect if they choose to believe that the Kowalskis were overbilled. And the pleadings collapse into the proof at trial, and we have in the billing records, we have in the coding so they know which ones are which, and we have in the testimony about the CRPS not being the real diagnosis, and of course Dr. Katzenstein giving 5 hours over the course of 97 days.
I'm not inclined to add that proposed little c to page 41.
Thank you, Your Honor.
Okay. Now, as far as the verdict form, I need to fix the question and add something to along the lines of in the future.
Yes, Your Honor.
So that means all of the verdict forms that we circulated to you all, we need to shred those, and I'll give you clean ones in the morning.
I think the problem is in question 8. The two false imprisonment ones, question 8 and question 13.
I think I flagged this issue over the weekend.
I was thinking you took this out of one of these instructions when we went through it, and was there proof for these things? But that's just my memory.
Well, we're talking about pain and suffering here going into the future. I think there's proof on that. Mr. Alburn, I think what you're thinking about is that some of these, it doesn't capture. Okay.
The list.
Number 12, expenses incurred in the future after she reaches 18. And I think, and then 14 is obtained in the future until she reaches.
This is what I'd ask Mr. Elliott and Mr. Altenburn to do. Get together, send me the specific language you want me to add, then I'll add it into the file. Just make sure it's specifically wherever you need it. If there's ultimately an objection to the language, send me each party's proposed language, but I don't think this is a controversial issue.
I agree. Mr. Elegant, I probably don't need to be in the courtroom for the next 4 or 5 minutes. I can walk out in the hall if you want to call me. We can settle this.
Okay. I don't know what's being argued next.
Well, you might need to be here. That's true.
So he just said, you want to step out in the hall and settle this?
The next issue we're going to deal with is juror disqualification.
Boom.
That, in my mind, is
paramount.
Where we're going next.
So, Mr. Elegant, why don't we just talk about it once that's finished?
Okay.
Thanks.
Anything else on the verdict form or jury instructions, or can I pivot at this point?
None on behalf of the plaintiff, Your Honor.
I have a question for you.
Anything else on the defense?
No, Your Honor.
Okay, here we go. This is the other big one.
Before us, a motion for juror disqualification of juror number 1.
Took care of that.
That was filed by defense. I've read the motion. I've read the response. You know, I'm happy to accept further argument. Hopefully, it won't overlap too much.
See that mountain?
No, I'll be brief, Judge. I appreciate. I know that you read the materials that have been provided to you. I do want to emphasize a couple of things and comment, if I can.
Sure.
I would say that I understand this is a very rare motion to bring. I've been practicing for almost 40 years, almost 200 trials, and I've never had to bring this kind of motion before. So I appreciate the gravity of it. I appreciate the unusualness of it, but we do believe that it's merited in this case. As you know, you're vested with the discretion in determining whether a juror has engaged in misconduct. And by misconduct, in this case, we don't mean that he has listened to news or done that things. But what we're talking about is that a juror that we believe has violated the instruction to not form any definite or fixed opinions about the merits of the case until all the evidence is in and arguments of attorneys and instructed on the law. We believe that deciding a case before hearing all the evidence is the antithetical to a fair trial. And I know that Your Honor has we've pointed out some of the jury questions from this particular juror, but there are a couple I just want to emphasize. I don't have a page number, but this juror particularly, in one of his questions, started with, you and this juror are not psychiatrists, we are humans and have feelings, etc. But goes on to say, is it possible that Maya's waning abilities could all or in part be contributed to what J. Hatch was causing? The limiting of family interactions and the stress and trauma Maya has testified to, documented statements to Maya about her mother's status, told to Maya by hospital staff, Miss Beatty. Could all this possibly have affected Maya's participation in your therapy sessions? To me, that, to the defense, that is a clear indication that this juror has already determined what the evidence is on those issues.
Okay, so which one in your motion are you referring to? What little letter? 2A, B, C?
Oh, I don't know, Judge. I'd have to go back and connect that, and I can do that if asked.
He just asked you.
The tenor of the questions that we've addressed in our motion and the specific questions that we reference clearly, in our view, show that this juror has predetermined the evidence. Just want to point out that in addition to those, this one specifically, Judge, and I'm sorry, I don't know if it's A, B, or C, but the question specifically states, will the jury be able to observe Sally Smith as a live witness or by Zoom during these proceedings? And goes on to say, are we able to be told, as there appears to be probable cause of improper actions of Sally Smith in her assigned role at J-Hatch, was she written up or coached? Is Sally Smith still performing duties at J-Hatch? To me, that is a prime example of the concerns that we have with respect to this juror, since he's already determined that there's probable cause that Sally Smith did harm and did wrong. To further,
even with the word may.
The word may.
Did you read that may be probable cause?
I don't think
it appears to be probable cause.
Well, again, Judge, though, it's a predetermination by this juror, his hostility towards the defense witnesses, his advising that he happens to be of the same ethnic background, and maybe we just thought she was pushy because of that. The fact that he considered one of the nurses a breath of fresh air because she's the first person to say anything nice about Maya. All of these, when you put them all together, Judge, are a pattern and an indication and evidence that this juror has already decided the case without any deliberation with his other fellow jurors, without any instruction on the law. Suggestions that the witness has overreacted, indicating his view of the CRPS. I mean, the hostile questioning of Miss Laporte. Are you attesting to this juror that you were the only one on the call? I mean, the whole tenor of all of these questions that we pointed out in our motion indicate that this juror has made up his mind. And it wasn't even, I mean, it was from pretty much after the Kowalskis testified. And from that point forward, I think the evidence shows he turned a deaf ear to the rest of the testimony, and that his questions indicate that. We think under the law that there is sufficient grounds here for this court to, in fact, change his status from being one of the jurors to one of the alternates, and that would be the appropriate to handle it.
Ooh, that's a
we
different
think the
outcome than what
Allberger
they asked
case
for initially.
supports that. We don't think it's necessary to interview the juror. We think that when you look at Allberger, that the appellate court will support that you as a trial judge were here and could judge this matter as the trial judge. The Washington v. State case that the plaintiffs cite to, which is first DCA, the tenor of those questions were not the same, Judge. The judge seemed just to be irritated because they were asking a lot of questions, but it wasn't that the questions were hostile or indicated that the juror had already made up his or her mind. So we believe that this is the appropriate motion to bring, and it should be granted.
Now, my reading of the Allberger, and that's Alberger versus Harbison, Harvison, 342 Southern 2nd, 537. There wasn't a discussion as to what the jurors' questions were. My recollection of that case was the trial judge had already determined, as a matter of fact, that the juror could not be unbiased and fair.
There's no detail in there's no detail in the actual case as to what it was. It just said that the appellee's counsel voices objections on the grounds that the nature and manner of the juror's questions, and it was apparent the juror had shown bias and lack of objectivity, and then a juror was substituted over objection, that the juror was substituted. And we think that that is the case we have here, Judge. I mean, when you look at the totality of these questions and the hostility of these questions, as we've detailed in our motion, and I could point out some others, but I think the court has read the questions. Certainly during trial, the court read the questions. There were times during this trial when we at the bench pointed out, Judge, that seems to be a question where this juror has already made up his mind.
Let me ask you this. I mean, everyone knew that this juror was former law enforcement. I mean, we knew that from day one, given his jury questionnaire. And isn't it something that law enforcement officers do is they confront people with conflicts in stories and evidence and see how they react? Isn't that just how a person digests information? And it's just, we knew he was former law enforcement, and therefore we could kind of expect that he was going to ask tough questions, sharp cross-examination type questions.
Well, Judge, I don't think these are tough cross-examination questions. I think these are questions that show a bias. They aren't objective questions. They are bias questions. When you talk about probable cause, when you talk about confronting a witness with, hey, wait a minute, maybe the reason Maya's having these issues is because of the fact that you separated her and you did this and you did that. Those aren't tough cross-examination questions. Those are questions that indicate a bias and that he's already determined that those facts are true.
Anything else, Ms. Crows, that you want to say?
If I can have a chance to respond to the plaintiff.
Sure. Who from the plaintiff is going to make the argument?
I will, Judge. It's interesting, the perspective, because I went back and looked at my notes from the first 2 weeks, and I had a big question mark next to Juror 1 as to whether he was dead set against our position based on the questions that he asked. He didn't say he had the same ethnic background. He said Nordic and a certain blunt way, I believe was his question. So he was not trying to identify himself because she's from Poland, and I think he's talking about Sweden. And the breath of fresh air, he just said, period. He wasn't addressing that, and we don't know from that. What we're doing here is trying to go back and do another voir dire or redo voir dire. This this juror, like the court said, is probing every bit of this evidence and every one of these witnesses. And thank goodness there are jurors like that out there. So just because he has asked these type of questions does not disqualify him. If anything, he seems like a pretty contemplative juror, as do all of ours. So that having been said, we don't want an appellate issue, any more of the appellate issues than the...
Well, let me just stop you right there.
Go ahead.
Ms. Crowells is suggesting that juror number 1 status be changed from on the jury to being an alternate. So effectively not disqualify him, just shuffle the chairs. At the end of the day, do you agree doing that because you're concerned about it for whatever reason? Do you agree to do that or not? Because if you're going to agree to do that, we'll walk a certain path. If you're not agreeing to do that, we'll walk a different path. You need a moment with Mr. Elliott and your team to decide that? Because when it's all said and done, if you're in agreement with Ms. Crowells on changing his chair from being on the jury to an alternate.
Well, my one question, I want to confirm who takes his place, obviously, which I think is juror number 5.
Whoever was the next.
My notes
she acts like she
we're
doesn't
not looking
know.
to shuffle the alternates, so whoever is the...
That's what I'm trying to figure out.
My notes have, and Madam Clerk, tell me if I'm wrong, that our jurors are 1, 17, 19, 93, 97, and 98. The first alternate is juror number 106, the retired electrician.
Yes.
Yes, Your Honor.
That's our understanding as well, Judge.
So
Defense is like, we know.
that's
we know.
the
one.
that's the first alternate. Do you all need 5 minutes?
Yes, Judge. We realize what we're trading out, I guess. And we understand the position of the defense is they just want to trade spots.
Well, we just want to, well, it's not unusual in a trial to sometimes make somebody that was a juror an alternate if they fell asleep during trial, if they had issues.
But they didn't fall asleep.
Our
They
position.
didn't have issues.
I'm just wondering if there's an agreement obviating a ruling or is a need for a ruling. And I just, 5 minutes, let's keep this to 5 minutes because.
Less than that, I just want to give us.
Do you want me to just sit here and?
Yes, Judge. Let's just.
If you need to call Mr. Elegant, you can step outside and call him.
I think I just need to talk to him.
I'll just sit here and look pretty.
Judge is good at that. Okay, so first of all, we might have him replaced. I might be right. I'm not trying to gloat. If I'm wrong, if they don't replace him, then I would say this is why you should get a lawyer and not try to represent yourself. So, Judge is just sitting tight. A lot of times he'll do this when there's a disagreement between the two sides. If he says, "Look, I'm just here as a referee. If you guys can agree on how you want to proceed, chances are I'm good with it." I'm like, "Yeah, sure. If you guys agree, as long as you're both on the same page, we're good with it." So he's presented it to him first. That would make this not be his ruling, and it would also make it sort of not like it would take like his decision out of the whole appeal factor here. So anything the judge can pass the buck on to put it back on the lawyers, I think he's going to do. Marie Baroque Namer. Baroque. I'm going to fake an accent. Baroque Namer. Is that right? Is that anywhere close? Welcome, Marie. Great to have you here as a new member. Welcome to the gallery. I'm just going to sit here and look pretty. So many sound effects, so many audio clips that we need. I'm just going to sit here and look pretty. Can somebody send me the link, like the clip of that from one of the feeds that doesn't have me talking over it, so I can find it? Has this alternate asked any questions during the trial? I don't know, but here's what I saw. When Mr. Anderson verbally said, "I'm just thinking through who would we get if we got rid of juror number 1," and defense is like, "It would just be, I don't know, whoever's next up, whatever that is," and as if they had not thought this through, like a million ways from Sunday, thought this through, and then when the judge is like, "Well, let me check my notes. It looks like it'll be the retired electrician," and everyone in defense is like, "Yep, that's him." They knew, and they're looking at number 1 and they're looking at the retired electrician and thinking, "I'll take the retired electrician any day over the retired police officer, the prior law enforcement." I'm not sure if he's retired, just law enforcement. So there are two ways to go here, and I wonder if they're two completely different outcomes. I wonder if the judge rules on it, it may be that he stays. But if the sides agree, he will allow him to go. It's a bad swap. I think it's a really bad swap. You've got a juror with law enforcement background and who appears to be on your side, or has asked questions. You're like, "Hey, I like this guy." The questions show that he's thinking, he's asking the right questions. I may like him. Law enforcement, he might be really good at convincing people to think along his ways. When it comes down to deliberation time, he might be a great person to have on your side, so to speak. Retired electrician, I don't know, not so much maybe. Let's see, you were closer the first time, but the first word you say is Burke. And then Namer. Okay, Marie Burke Namer. Burke Namer. Or Namer. Namer? Namer. Welcome, Marie. Either way, I got Marie right. So I'll stick with that. Say, ask for a ruling, says Tanil. Ask for a ruling. The judge is very cautious, and I love him. He does such a good job here. Let's see if if they're coming back here. I need to get Zoom back up. I had to quit for a minute. So.
I think I better stay with number one.
Good call.
I don't
So
think
you
we
were
have-
opposing the.
Yeah, I think I need to oppose that. I have very mixed feelings, but first, I think it's the right thing to do to keep him on there under the law and our system of choosing jurors. I don't see anything in his questions. I see him probing things deeply. And I think he, like I said, when we started out, I wasn't sure which side he's on, and I'm still not sure based on some of his questions.
Look at Shapiro's face.
I think the point should be he shouldn't be on anybody's side at this point, Judge. That's the point.
They all form opinions at some point and through it, and they're all cheering for one side or the other, and then they switch sides depending on the evidence. That's the nature of jury trials.
Shapiro's face. Judge's face.
So I need your final answer, Mr. Anderson, so we can get this thing going.
You're a lot of help.
So someone has to make a decision for the plaintiffs. So you are there. If not, I'll call Miss Lawrence. You can give me the final answer.
Sounds good.
Well, where did you?
Put him on the spot.
You'd like to sub in Ms. Lawrence as judge of the law.
We're not doing that, Mr. Whitney.
I forget what he said. I couldn't hear that. You like to something, Miss Lawrence? Mr. Anderson has a tough call here.
No, I changed my mind. I'll go with number 5. So I'll agree with you.
Ms. Lawrence, is this your final answer?
It's not number 5, it's 106.
Yeah, 106.
Well, hang on then.
It's the one he announced. The
I'm
electrician.
sorry. 106, prospective 106. And
he's counting 1, 2, 3, 4, 5.
Yeah, yes.
That's
where
what
he's
he
sitting.
meant.
Okay.
Yeah.
All depends on how you count.
All right. So are we concluded?
Defense is giddy at this idea.
Ms. Lawrence, is that your final answer?
Yeah.
Okay.
I think I'm going to go with that.
Okay, so what we're going to do, with the agreement of the parties, and this is the agreement of the parties, is
you see the jazz hands?
Juror number 106 will move into the status of being on the jury, and juror number 1 will move into the status of being an alternate.
Which alternate? Is he just going to swap with?
Is it going to matter after tomorrow?
It might.
Probably not, but
If someone has another medical emergency, we'll address it then. But let's just pray no one has another medical emergency. How about that?
Okay, Colorado court just reached a verdict.
Let's not go about.
You know who I didn't check with through this whole thing? My client.
Well, that would be important.
Yeah, hold tight. Yeah, don't go anywhere without calling
Well,
Jack.
let's let Mr. Anderson talk to Mr. Kowalski.
Okay. All right. Then can we move to exhibits, Judge? Unless you.
Well, let's give Mr. Altenburn another moment.
Yeah, I'm waiting.
How did he not check with Jack? Okay,
Judge, Mr. Altman and I weren't able to talk, but I did send him a text.
I'm going to go with my client. I have to switch positions because my client feels more comfortable with juror number
he's
1.
back.
So I'm going to switch
Jack.
positions based on my client's input.
Look at the frustration on defense.
Package.
Look at frustration on defense.
Okay,
Look
so
at Mr. Hunter.
So your final answer, and just so I'm clear, the plaintiffs are objecting to the switch and wants, if I were to deny the change, your client wants the appellate issue.
To such as it is, I don't think there's much of one, but
okay. So the final answer is you're objecting.
I'm objecting.
Okay. Anything further, Ms. Crowells?
Judge, I think we've laid out the bias that we believe this jury has shown. I think that the appropriate ruling for the court is to grant the motion. I think under the case law it's warranted. No, I have nothing further.
Court has before it the motion to disqualify juror number 1.
Now it's the
for
judge's
a question
decision.
of bias.
Still up in the air.
This is a very peculiar type of motion, in the sense normally when we see a question of juror misconduct, it's they've violated some sort of instruction of the court, like don't go to the accident scene, and they go to the accident scene, or something along those lines. The court has given instructions which the defense says that this juror has violated. For instance, instruction 202.2, you must avoid forming any final opinions. Keep an open mind. Actually, keep open mind is from 201.2. In this particular case, the evidence that the defense points to has to do with juror questions, and the court will, I think, without a doubt, everyone will agree that juror number 1 asked a substantial amount of questions. Now, to be fair, other jurors and alternates, although they don't know they're alternates, also asked a substantial number of questions. For instance, juror number 181, whom had the medical issue today, also asked a copious amount of questions. What we know about juror number 1 is he's a former law enforcement officer. We've known that since day one. That's on his juror questionnaire. Everyone's known that. And certainly he survived the individual questioning, then the group questioning that we had for all of the jurors. During the course of this trial, obviously I said juror number 1 has been asking a lot of questions, and I don't know, maybe 3 or 4 weeks ago, the defense started referencing their concern about this particular juror. And certainly I've been paying attention both before, but acutely aware of each and every question that comes from juror number 1. The case law that's been cited to the court from the case for the defendants is the Allberger case, and the best case, if you will, from the plaintiffs. I think it's, where did it go?
The fact that defense did jazz hands.
It's the Washington v. State case, which is 955 Southern 2nd, 1165. Judge Padovano, writing for the first DCA, talks about witnesses who ask probing cross-examination questions, and how that is not necessarily any indication that the juror has violated an order or instruction of the court. The court's instructions, can't form any final opinion. You have to keep an open mind.
Final opinion.
9 weeks into this trial, I can tell you without any sort of certainty that juror number 1 has been testing the evidence in this case. Every single witness. Well, I don't think he asked a question today, but I think he asked a question on almost every single witness that wasn't by deposition. And the witness, even after the defense 3 or 4 weeks ago started pointing out what they were contending to be prejudgment, this juror continues to ask probing questions. If he had already made up his mind, why would he ask so many questions? If he had a final or fixed opinion, why would he continue to do this? Now, yes, he put a lot of prefaces into it, but I would say that his prefaces talk about context. And we have to remember that the jurors asked their questions after all of the lawyers, and perhaps this is bad on me, but I did not constrain the lawyers to a strict direct, cross, and redirect. I let them go for recross and redirect and recross until the lawyers were finished with their questions. That's just because I view this as let's find the truth. And so I didn't want artificial boundaries on cross-examination and redirect to limit us. So the point is, sometimes it might be an hour and a half, 2 hours or so, or if we've taken lunch, even longer before the jurors were able to ask their question. And if they let's talk about this subject, and without providing context to the question, he might have written it down 2 hours before. So this juror was providing context. I have not seen anything in my mind that would remotely come to me to get to the conclusion that he has prejudged anything in this case. On the contrary, I am warmed by the fact that he has, in his mind, gone through, or what I believe to be his mind, based on the questions that he's asked, my observation. I mean, the guy sits, 5 yards from me. I've been watching him for more than 2 months. I mean, he's the closest juror to my physical vantage point and location. And I've been watching the guy. And I have no, not only do I not have a doubt, I don't have a reasonable doubt, but I have no doubt that this guy has not come up with any final or fixed opinion. And when I reviewed the motion, the only thing that gave me any hint of an issue was the reference to the shared cultural sense of Beata Kowalski and this witness. And I went back and looked at the actual question that was asked. And I don't see anything in here where this witness suggests even remotely that he is going to vote for the Kowalskis because of that, or vote against the Kowalskis for that. To me, it's just context. He was providing a situation of how he was framing the question. And then I go back to, this is a person with law enforcement background, and he's, in my mind, taking what is sharply conflicting evidence that both sides have skillfully and artfully put forward to this jury, and he's trying to make sense of it. Now, there was a reference in the motion to, is he communicating? Obviously, there's no communication in the jury room every single break, even if it's for 2 minutes. I ask if they have been talking with each other, and the answer is no. So I have no concern that there's any hint of deliberations or discussions amongst the jurors back in the deliberation rooms outside of the court's presence. So I don't see that as the case. So the only evidence here is his demeanor in front of me, plus the questions that he's asked. And I don't even get to the point of whether I need to discuss whether I need to have a conversation with him, because I'm not even close to the question of whether I have a reasonable doubt as to whether he can be fair and impartial, whether he has violated any court instructions. And I've seen no evidence that he has violated any court instruction. On the contrary, I think he's been doing exactly what we've asked the jury to do, which is, if they are so inclined to ask questions, and he's using his skill and expertise as a former law enforcement officer to do that. And that doesn't mean asking sharp questions, as Judge Padovano points out in the Washington case. That doesn't mean that the juror has come up with any sort of final or fixed or violated any instruction of the court. So I don't think I need to say anything more on that. So I'm going to deny the motion to remove juror number 1 from the juror. Juror number 1 will remain on the juror. The alternate, number 106, the retired electrician, will remain as an alternate.
So I will say right now, this is why you get a lawyer.
What's next?
Because they're
Judge,
smarter
we have
than
some
me.
exhibit-specific issues. Given the number of exhibits, not that many, but we were back and forth on the weekend on some of it is the language
Are we talking about the neutral statement in the
Yes.
Excel spreadsheet?
Yes.
Okay.
So, Exhibit 2165, Judge, is,
No, I'm happy. It's a good outcome.
the access log, and that's fine. But then for 2165A, which is just one page of it, they want to put Johns Hopkins All Children's Hospital access log. I'm fine with that. Access, Dr. Sally Smith, that she accessed it that day. I'm saying you don't get to put why you put the access log in. It should be just Johns Hopkins All Children's access log 10/8/16.
You know, Ms. Lawrence, you're going to be making this argument. Just to forewarn you, you're going to come up and you're making this argument.
I'm being bullied.
You're an attorney. You get to make the argument.
Judge, so that's the issue.
Okay. Ms. Lawrence.
They want to say why
Here
we
we go.
put it in.
Ms. Lawrence,
That
step
Dr.
up
Sally
to the
Smith
podium.
accessed it that day. I'm saying just the date of the access log gets put.
Okay, can I see what the physical document is that we're talking about?
Oh, I don't know.
This is a very small point.
Clay, can you put
The
up
judge wants
another
Ms. Lawrence up here.
It's your exhibit.
So Mr. Cottrell's computer just crashed. So Mr. Reyes, can you help us out real quick?
His computer crashed?
I don't know. That's what I lip read over there. Am I correct?
It's crashed 2 times.
What's the exhibit number?
Sure. It's Defense Exhibit 2165A.
Ms. Wiz, thank you very much for the gifted memberships. 5
Okay,
of you.
Miss. Let's bring up the exhibit so I know what we're talking about.
So, Judge, my-
Which page of this?
You guys seeing this?
It's just one page. It's 2165A. They put in the whole access log as 2165. They put this in as A. It's the access log from a particular date. I thought it was 10/8. Maybe it's 10/7. And we just say the date should be put on there. They want to put that this is the date that Sally Smith accessed the log. They want to put her name.
Well, do I see Sally Smith's name on here?
I think it's on there somewhere, Judge. My objection is that we've been neutral on all the other things.
Matthew Higgins.
Yeah, there's other people. That's correct, Judge.
Right, but what I'm saying is I'm not seeing Sally Smith, so is this the right page?
Oh, it should be. It's 2165A. That's what they.
What's the internal page number?
There's 234 pages, Your Honor.
Oh, I'm sorry. My fault. My fault, Judge. 71.
71.
Okay, Miss Lawrence, your argument.
Okay. It's a factual issue. It doesn't say that Sally Smith is an apparent agent. Everything else has been redacted, right? On the
Other pages,
on the
yes.
other pages. This is to orient the jury to see Sally Smith's name.
Anything else, Ms. Carls?
Go, Ms. Lawrence.
Woo! No, Judge. I mean, the whole point is to help the jury find things, so I'm going to agree with Ms. Lawrence's argument. We can leave in Sally Smith.
So what exactly are the wording? So I have 10/8/16, and you just want to put Dr. Sally Smith access the log? I mean, Judge, that's, okay. What is the exact wording you would like?
I think, however, Kelly has it on there is fine.
Well, I don't have that because I changed it. Just put Dr. Sally Smith? Is that acceptable?
You already said so it was access log hyphen Dr. Sally Smith?
It says John Hopkins All Children's Hospital Access Log -10/8/2016. And then we can add Dr. Sally Smith.
Yes.
If that's what you'd like.
That works for me.
Okay. The other one is, so, Judge, to aid the jury, we broke down the hospital admissions with neutral indexes. It's just what they're called, right? So we did it for the joint exhibit for the hospital, and then we did it also for Lori and Tampa General Hospital records. Their objection is that it's not done for all of the records, and it gives emphasis to these records. My response was, break out what you want. If you want other records broken out so there's an index so juries can find the discharge summary, or they can find consult notes or whatever, feel free to do that. They said we don't have time. So their objection is that on 3032, we broke out, and I'm happy to show that, Your Honor.
Yes, please.
If I could just, sure. So you can see on 3032, for an example, we broke out a particular hospital record, simply giving an index to the jury where to find the particular title of those documents with no description or anything. We also did it for 3047. Their objection is that somehow gives emphasis to those records. We were just trying to aid the jury. They don't object to the joint exhibits that were done, which were the Johns Hopkins records.
LJ Peach, thank you very much for the super chat.
As long as we're free to specify everything else, then we're okay with it. But it's going to get pretty convoluted if we start.
When you say specify,
yeah, I don't know what that means.
If we're parsing out every other exhibit.
No, just the hospital records.
Within these two hospital, or are you talking about other locations?
All of them.
Okay, Eagles Wings.
Eagles Wings.
Well, Judge, again.
It's going to take a while.
Let's be clear. These are massive hospital records, and all we did was put an index where to find whatever the document was titled.
Here's anything else, Ms. Lawrence?
Nothing.
Here's where I'm at. I am fine with what the defense has done for Lurie's and Tampa General. If the plaintiffs wish to do something similar before we come in tomorrow morning and it gets incorporated into the list, knock yourselves out. But do not make it argumentative. Do it very generically, blandly, like the Ms. Croyles.
Yeah, Judge, I would suggest it needs to be limited to records that are, 500, 600 pages, the hospital records. If they're going to start breaking out every index for the Eagle Wings, that's going to make this 300 pages long, for one, and we're going to have to go back and do that. I don't understand their objection to the hospital record being done.
What is the scope of the documents that are in evidence that you're contemplating having some sort of breakout in?
Dr. Hannon, Dr. Kirkpatrick, Eagles Wings, Shoshana Duncan.
How many pages are there each one? Are we talking more than 50 pages, more than 100 pages?
Likely, yes.
Judge, that's a completely different category. These are hospital records that are how are you going to break out Dr. Kirkpatrick's with some neutral thing? Office visit of? They're going to detail every office visit? We'll take it back. We were just trying to aid the jury when they go to these records. Where's the console? Because they have hard copies. They can't search them.
Look, I think we're going to give them a flash drive, I thought.
But that's going to search this. It's not going to search the records.
Correct. So, which is why I am fine with adding the detail that the defense proposes, and I'm also fine if the detail, if the plaintiffs wish to do this, but make sure it's in a neutral fashion and email
then we'll be going back to detail all of ours then too. Why don't we have a conversation?
Look, I think. And maybe this is an arbitrary number, but if we've got more than about 40 or 50 pages, then I think you might want to do it. If it's under some manageable level, probably don't need to do it.
Okay.
And I just don't have enough knowledge as to how many we're talking about. But we're not stopping the jury. We're not stopping all this to let this happen. So. If you want to do it, more power to you. But we're not stopping.
All right, Judge. Another issue is for their description of 2032, which are the suicide notes of 2017, they put suicide notes on 1/7/2017. I was fine with that. So then we, for our, for 3212, those are the suicide notes from 2016. So we called them suicide notes 2016. They said, no, we object.
It just went
you have
live.
to put just
I'm
as an
recording
email.
it. I got it. It's just live. The jury's coming in right now.
Well, if you're calling your 2017 notes the suicide notes, I think we get to call the 2016 emails suicide notes.
Did you call them the draft? Because I think that's what was referenced in front of the jury.
We can call them draft, Judge, if you'd like. Let's see. What I
let me hear from Ms. Lawrence the position of the plaintiffs.
Can we put the 2016 up? I'm not sure what she was.
Sure. What number are you talking
Sure,
about?
3212 and 3213. They're the exact same language as we can put draft.
Well, those are both 2017.
That's the objection.
No, but it's January 6th. I'm sorry. It's January 6th. If I misspoke, I apologize.
I thought you said 2016.
I didn't mean that. No, it's January 6th are the defense exhibits. They put in the January 7th one as the suicide notes. We're saying these are January 6th suicide notes. The date and the word suicide notes, like they did for the 7th.
Ms. Lawrence, your position.
I'm going to load the Colorado verdict to my other channel.
And I think earlier you said you were okay with adding the word draft. I think that's what they were called in front of the jury. That's my recollection.
I'll confer, but that's probably okay.
I'm okay with adding the word draft to it.
Okay. Let's see. I think that might be it, Judge. As far as descriptions, we have a couple exhibit issues, though. I don't think it'll be controversy, but I just need to clear it up. So the plaintiff put in Dr. Henschke's records, and they put them in with redacting some pages that we objected to, as well as they should have also been some language redacted. We then, on our own, also put them in. I just want to withdraw them because I don't think they're redacted. It's 3025. So we want to just withdraw 3025 because the records are already in and they should be redacted the way they've been put in.
Ms. Lawrence?
No objection.
Madam Clerk, are you okay if we do that? So we will remove from evidence 3025. Do they need to remain as marked, or are they just able to go back? And I just don't know the answer to that. Okay.
Okay.
So it sounds like 3025 is withdrawn and no longer in evidence.
Okay. The other issue, Judge, is when I was going through this, the actual records, trying to separate them out, index them.
And I appreciate you doing that. And I think the jury will appreciate it too.
Yeah. I'm trying to find the exhibit number now. I told you guys earlier.
3023?
It was a joint exhibit. If I could- Yes. The 1030 joint exhibit says Arnold Palmer Hospital 11/12/20 admission. I asked, did you guys check?
We cannot check it. We cannot remove or double check to see if they're the same exhibits.
No, but okay.
We do have them.
So here's what happened, Judge. Sorry. I noticed that the 2016 admission was also in that exhibit that was on my computer as 1030. Plaintiff said, well, you got to remove the 2016, which we put in later. We're happy to remove those pages. I just wasn't sure how to do that. So
I guess I'm not following what you're...
Sure. So we put in evidence, Exhibit 1030. We called it Arnold Palmer Hospital 11/12/20 admission, but only pages 1 through 467 are the 11/20 admission, 2020 admission. When you get starting on page 468, it's actually the 2016 admission, which we have in later.
Okay, so 1030 is a joint exhibit?
Yes.
And the plaintiffs do not want the 468 and beyond pages in 1030. They want it separated out.
That's my understanding from Kelly.
Okay, so, Madam Clerk, are we able to make Exhibit 1030 only pages 1 through 467 and then remove 468 to the end? Are we able to do that without causing you problems?
I just double check myself, please? I don't want to do it and then. Yeah, that starts the 2016, and it goes to
And Ms. Lawrence, do you need to or want to look at that exhibit?
605. So this is the 2020 admission. Yeah, when both sides have had it forever as this admission number, but it didn't notice it till we started indexing. So our suggestion is we just remove it back because we have that in separate entry. Okay.
I think there's a conspiracy talking about Florida State football back there.
I'm all ears.
So, Judge, we're good on that?
Those hand signals, Lieutenant, are not accepted in this courtroom.
We're getting there.
I don't know, Your Honor.
Okay, so going back to the business at hand, we all agree that pages 468 to the end are going to be removed, and so Exhibit 1030 will only be pages 1 through 467. Ms. Lawrence, is that correct?
Correct.
Ms. Crowells, is that correct?
Yes.
Madam Clerk, you agree? Perfect. What's next?
I think that's all I have, Judge. You can see we've been going back and forth, different colors when we've been communicating. I believe that's all. We just need to confirm with the clerks that we're good on exhibits that they need. I think we are. And then, of course, we'll talk about what we're going to do with descriptions, because I don't think either side wants to be up till 2 a.m. arguing over things
I
or
know
doing
I'm
things.
not going to be up.
And I would like to walk in with an agreed exhibit list. So
The question is, are you going to insist on doing that to Lurie's and TGH? And if so, like for example, Arnold Palmer and Dr. Kirkpatrick, which are both well in excess of the 40 or 50 pages, we don't want to be up late either, but we're going to draw attention to certain things as well.
I guess I don't understand why you think it draws attention. It's simply an index of a hospital record.
Well,
Can we just agree to do hospital records?
y'all know my position on it, so
Yeah, we'll talk, Judge.
y'all
Sorry.
can work out the details without me sitting here.
Okay. Yes, sir.
Are you finished with your
I am.
issues?
I am.
Mr. Altenburn, you seem to pop right up.
Because we're appellate lawyers. We got this solved.
I'm up also, Your Honor.
Yes. And so with the language that needs to be added to question 8 and 13 on the verdict form.
And is this something that you've emailed to me?
I believe I asked Tom to do that, but I think he's still stuck on the Zoom too. So
I would have, except that right now my email is not functioning from here, so I have to. I'm going to talk to our IT person when we get off. It's 7 words in 2 places. So.
Yeah.
So I understand.
We can send you an email, but what it's going to be is an add to question 8 and 13 of the phrase "and to be sustained in the future." That's it.
Well, this is going.
Just email that to me.
The verdict has been read in the Woodyard case in Colorado. I'm uploading that right now. It's already uploaded. It's just rendering right now on my Top Mark channel. So if you're following that, it will be over on the Top Mark Media channel.
I don't have it up in front of me, so.
That's where we've had the whole trial for that one.
So are you relinquishing the lectern, Mr. Altenburn?
I'm finished. If you're finished with
Mr. Alligator, have you relinquished the virtual lectern?
I'm done, Your Honor.
Ms. Lawrence, are there other issues that the plaintiff?
Nothing further from the plaintiff.
Okay. So let's just talk for a moment about how tomorrow is going to go. So we're going to arrive here at 8:15. I've got some words that I'm going to talk tomorrow, which will probably take 10 minutes.
8:15.
My hope is that the Excel spreadsheet issue will be a non-issue by tomorrow morning, that there will be a singular flash drive that both sides have looked, that you can give us so I can give to our IT person to make sure that there's no bugs on it.
Can I just, so I was just going to download whatever final list we agreed to on a flash drive, is that what you're saying?
Right, but it needs to be a clean flash drive that has nothing else on it, because it's going to go to the jury.
Take the family pictures off.
And both sides are going to look at it.
Take the family pictures off.
And then the flash drive, before we stick it into any computers, will go to court IT, who will scan it for viruses. Because even though the computer that is in the jury deliberation room has no access to the internet or whatever, I don't want that computer getting a virus. So
I don't want the bill for that either. So, yeah, let's do that.
okay. So that's what we're going to do with that. Now we're going to bring in the jury about 8:30. We're going to give closing arguments. There's 2 hours per side. I'm assuming Mr. Anderson's going to want to reserve some amount of time. Do you have an idea as to how much he's going to?
It's going to be approximately an hour and then an hour rebuttal.
We object. We object to that, Judge. That's not rebuttal.
An hour and 1 minute and 59 minutes in rebuttal.
Judge, we object.
I'm thinking probably an hour and 15 to an hour and 30, somewhere in that range.
Understood.
Okay, because this is not going to be.
Yeah.
Here's 5-minute conversation, and I'm gonna unload everything in the hour and 55 minutes I have.
To the extent it matters, Judge, the defense objects to them reserving more than 30 minutes for rebuttal. That seems, again, not rebuttal, but just a tactic, as they always accuse us of doing.
So, in any event,
So
we're not. We'll only take
Moving
short
on.
breaks for stretch breaks, restroom breaks. We're not going to break for lunch. We're going to go straight until we finish the closing arguments. Then I will go read the last couple of instructions, go over the verdict form. Now, I do want and need the lawyers to go through the evidence and ensure that it is what it is and that there's nothing inappropriate. I personally am fine if you do that quietly during closing arguments. But what I don't want to have happen is for us to do our closing arguments and then you all want to spend an hour with the clerk going through the evidence.
Huh.
And so if we're going to do that during closings, where physically would we be to do this?
Over there.
All right.
If that's okay with, are you okay with them doing that quietly during closings?
Mm-hmm.
Or would you rather them wait till after closings?
It'd be a lot easier if we waited, Judge. I'm just saying. I know it's not my call, but
Well, I just don't want to spend an hour watching the lawyers look at exhibits with the jury sitting there, ready to go.
so you can't send them out without the evidence going with them.
I'm not going to do that.
Yeah, I hear the honor. Can I ask, so are the exhibits in binders and we would just flip through them? Are they individual sheets?
They're all in binders. We kept them all in the binders, in numerical order.
Okay. All right, well, if we could sit over there, Judge, so we're not standing and being a distraction.
Are you okay with that during the closing arguments?
Yes, sir.
I mean, if you're not, then that's fine, and we'll do it after. Or conversely, do you want to do it tonight? But that means y'all have to stay longer, and I.
Either way, Judge,
and
whatever is
that might have
best for the
to
jury.
keep the courtroom deputies here as well, so that's a lot of overtime.
I'm assuming we couldn't remove them to a conference room and do it during closings. We'd have to leave them in the courtroom. Yeah.
You're not leaving the custody of the court.
Understood.
I can sit down there and watch them go through it, if that's easier.
There's a couple of mediation rooms around the corner.
They won't look like that.
Okay.
Well, do you want to physically move them into a different location in the courthouse to go through it if one of you sees?
Yeah, I'm fine with that too.
That's fine.
So just go to the little room right out here?
Yeah. You're talking about tomorrow.
Tomorrow.
Yeah, that would be a lot easier, Judge.
But that would be during closing arguments.
I understand. I don't know who from their side is willing to do that.
We don't need to look at it. We've been checking throughout, so whatever's easier for you.
I think it's the courts requiring us to look at it. I don't think it's a request.
Then
we're happy to look at it wherever.
Yeah, that wasn't my suggestion. The court's requiring us to look at it.
You haven't looked at it yet.
I'm giving, because what I don't want to have happen is something inappropriate going back to the jury and someone saying mistrial because we didn't look at. Now, if you want to have a paralegal look at it instead of a lawyer, I'm fine with that. But I really want fresh eyes
on this issue, too much is riding on this for a silly, careless mistake that could undo this entire trial. And I just want to avoid that. So
That's fine. Ms.
So-
Dunn will take a look at it tomorrow.
okay, and we will do that. We'll wheel it out into.
Yes. And Your Honor, is that only the plaintiff and the fence? It's not the joint, or also the joint?
Joint, any exhibit that is actually introduced in evidence, I want them to look at it because I want them to be able to, and I'm going to ask the question, do you agree that there's nothing inappropriate going back and we only have the admitted evidence? That's the question that I'm going to ask.
There have been a lot of redactions and things in this case, Judge, so I hear what you're saying.
So just have your person or team ready to go for that. And I just don't want to have to spend an hour after we finish closings to
I understand.
effort this.
So we'll do that at whenever, right before closings.
8:30 in the morning after we
Yes.
start closings. Or you can even start before that. I don't particularly care. Anything else, or can I let you all go and...
Nothing further.
Nothing here, Judge.
Okay, we will be in recess until 8:15 tomorrow morning. 8:15, we are in recess.
All right. So 8:15 tomorrow morning, which means we start at 8 again, an early morning, one more time. A little bit spicy. Defense lost a lot of the of their grant motions recently. They thought they had won. I want to see if I can rewind this just for a minute. Hold tight. Let's. I've got to get this on the big screen. Let's watch on this feed. Okay, where is it at? Where is it at? Let's go back. Go back. Go back. I want to see if I can show you the jazz hands moment that occurred. Mr. Anderson was up. Just before that. See if I can bring this up. Hold on one second. We're going back in time here. Play for
Question on almost every single witness that wasn't by deposition. And the witness...
Going to rewind a bit further.
As my client feels more comfortable.
Okay, so it's just before this.
With juror number one. So I'm going to switch positions based on my client's input.
181.
Let's go back. Yeah, here we go. Watch,
Okay,
watch
so
this.
what we're going to do with the agreement of the
back there, like,
parties,
yes,
and
jazz
this
hands.
is
Did you
the
see that?
agreement of the parties, is...
I'm going to kill the audio and we're going to watch that one more time. Back up, back up. So watch the lady in back of Mr. Hunter, and the first one does like yes, like a victory type thing. Where'd that go? Hold tight. Okay, right here. So we're coming to it. First, she does like a fist in the air in blue, and the other lady's like, "Yeah, jazz hands, yay!" They're all giddy back there, and then Mr. Anderson goes, "Wait, but let me go talk to my client. Let me go talk to my client," and then it all goes downhill from there. Oh my goodness, good stuff, good stuff. All right, let's see. We want. Why am I not getting 4 on there? I need 2 is 4. Oh, super source here. Okay, there we go. All right, we are up to 1,774 objections. We're going to quickly just put up on screen the... Jules is calling. Well, Jules is calling. I'm going to put up on screen.
Call from Jules.
Jules, how are you doing today?
I'm doing just fine. How are you?
We rode a roller coaster of emotions at the end of the day today while we were thinking for a moment that juror number 1 was out. And that was my call. I thought it was going to happen. And then in the last minute, Mr. Anderson says, well, let me talk to my client, talks to Jack. That gets reversed.
And I was right behind Jack, and Jack was shaking his head. Nope.
Yeah.
No.
Now, I'm not sure if
And
you.
I could not.
Yeah.
What?
I'm not sure if you.
No, go ahead.
I'm not sure if you saw this, but the two ladies in back of Mr. Hunter on the defense counsel, sitting at the computers there in front of the bar, when Mr. Anderson first said that they would go ahead and side with the defense and replace the jury, one of them did like a fist bump in the air, like two fists up in the air, and the other one did jazz hands, like yay, yes.
I didn't know.
And we just watched it on
I didn't
replay.
see
So.
it. Oh, no, well, when I get home, then I'm going to have to watch it on replay myself because, no, I did not see that because my eyeballs were like burning in the back of Jack's head. Like, I cannot believe this, not this jerk, not this one.
Yeah.
And I'm so glad because I can officially tell you that my juror number 7 is juror number 1.
All right, it matches up now that the judge has connected
Yeah.
all the dots and told us about the different numbering systems. So that's
Yes.
good to know.
And, yeah. My juror number 7 is definitely beyond a shadow of a doubt juror 1.
Yeah.
And the juror that was discharged due to a medical emergency is the young guy.
The one with the striped hair?
One that, the one, no, that's juror number 1.
Okay.
Juror number 1 is the one that did the striped hair. No, this is the one, excuse me, that in my opinion, was the youngest guy on the jury.
Okay. And he's out now. And
He has a medical emergency. So, yeah. And, yeah. But, I'm going to go ahead and share this with you. I think it's going to take me, I don't know, probably about 30 minutes to get home because traffic is quite crazy right now. So I'm thinking about going live on TikTok, but just in case I don't, because I'll be honest with you, I'm tired. I've been up. I didn't sleep well last night, and at 4:00 this morning, I gave up and said, just stay up. So I don't know about. Yeah, I've been up.
Jules,
I wasn't the only one. I know I wasn't the only one. So I'm going to go ahead and share this with your group, and this way, if I do go on TikTok, well, then go live, then I'll go into more detail about it.
Okay.
But Mr. Shapiro knows who I am. You want to know why?
Did he follow you on TikTok?
No, but apparently he's been alerted.
Say that again?
Apparently he's been alerted. Ooh. And what happened is we walked in after the jury left, and then there was another break, and I was talking. We were still in the courtroom, but it was break time, and Dr. Richards and I were having a conversation, and no, I'm not going to rear end you, you idiot. And Shapiro comes walking in behind me and said, right to me, right to my face, right, with a big smile on his face. So, what are you going to do wait, he started out. So, this is winding down to an end. So, what are you going to do when this is all over? And I said, and I smiled at him, and I said, I'm going to live my life. And he went just like this. He said, yeah, get a life. Yeah. And so I turned around, yeah. And he said it right in front of Dr. Richards, and the deputy was standing right there. But he said it like laugh. Well, I'll describe it later, but that's what he said to me. But my comeback was, yeah, so you still going on that vacation? And he turned around and he goes, yeah. I gave it right back to him.
Wow. You should
So,
have
am I
said
wrong?
something like, actually, we're booked on the same cruise, so you'll be seeing me.
I didn't think that. But judging by what now, mind you, he didn't say it nasty. He had that big fake smile on his face. And when I said, live my life, he went, yeah, get a life. And then, and laughed. And that's when I turned around and said, yeah, and you still going on that vacation. So, what do you think, Scott? You think he knows who I am?
I think you've made a friend. I think you've you've made a friend. So. Wow.
Yeah.
I cannot imagine the stress he's under right now. And everything is falling down around his ears. It's been a rough day.
Yeah, and then, well, I'm going to save this for for if I go live. There was somebody who approached me as I was leaving court that said something to me about my TikTok, and I was like, yeah, that's me. And they're like, do you have those documents? And I was like, yeah, I do. Can you show them to me? I was like, sure. Here.
Yeah.
And so I think Mr. Shapiro is going to be, media-wise, called out now.
Yep. You've got some good stuff. If for those that don't know, Jules is on TikTok. She has some great information. She's spilled the tea, or served the tea. How do you say that? You've let us know a lot of things. Jules, thank you so much. I'm going to miss your daily calls once this is over. So we're going to have to get another court case in your area so we can stay in touch.
Yeah, for sure. Well, I really am hoping that you're going to cover Petito versus Laundrie.
Okay, about that one. Has that switched to a new judge? Did that get reassigned?
Not. I looked on the docket a few days ago, and it's still under Judge Carroll. So I don't know. Is there a plan coming up in place for this, or I don't know. But no, as far as I know, Judge Carroll is still the guy. And what did you think about Ms. Lawrence?
She did great. That was awesome. It was a little tiny. I mean, it's not a hugely influential point that the whole case is going to turn on. So it wasn't like a major issue. But she stood up there and took it. And man, I think Ms. Correll's got a little bit snippy with her towards the end.
She did.
Which I thought was uncalled for. And like way to welcome the new class of attorneys, by being a little rude to them. So wasn't really happy about that, but I think Ms. Lawrence did a great job, and I'm super excited. Can't wait to see some trials that she's sitting on that front row for.
And you had a couple for the morning thing. You had a couple of your people were in the courtroom, but then once jury instructions started, they're like, yeah, I'm out. I was like, I wish I could go through, but yeah.
Jury instructions.
We all know how boring.
They're tough to sit through. Sometimes I feel like I just want to put a video loop of me nodding at the camera on, and just set down the headphones and be like, I'll be back in a minute. Sometimes they can be just a drag. I remember, with Daryl Brooks. You got 90-something charges, and it's just like hearing the same thing over and over. It just lulls you to sleep. But I think the judge did a great job reading them. I think they're great. It helped clarify a few things. We've got those 7 charges. We understand where they're at. Tomorrow we're going to have closing arguments. We still have a couple issues. The judge he's reserved his decision on sanctions for the defense, and he's reserved his decision on directed verdict. And
Did you read the sanctions?
I haven't read them. I've got the document, but I got it while we went live, so I haven't gone through all of it.
Okay. I was just checking to see if you had them or not, because if you didn't, I was going to send them to you. But that's cool.
It's in that 327-page motion, right?
300. Yeah. Mm-hmm. The sanctions in there, and I started reading through some of them. They're it's quite interesting, and I think if you read through them, that question you had asked me on the first phone call, I think your answer will be in there.
Okay.
You'll find the answer to that question in that stack of papers. But all in all, my opinion, I think it went really well today. I thought we were going to go in there this morning and, Judge Carroll was going to lose his mind.
Yeah.
But, as I told you this morning, Hunter was more, he came off as more humble, than he has in the past. But overall, everything went really, really well. And I need to do a shout out to someone in your chat. Marta. Marta needs to know that Maya wore the bracelet that Marta made for her.
Oh, that's awesome.
She wore it to court today, and and it's so pretty. It's pink gems, and it's tiny, and it's delicate, and it just fits Maya's personality perfectly. So yeah,
That's really cool.
So yeah.
Marta,
Yeah.
no, we've got it up on the screen now. She hasn't heard. That is awesome. Jules, I know you're driving. Please drive safely. Tomorrow's going to be a huge day, and then obviously we're into verdict watch. Probably by the end of the week, I'm thinking we've got a verdict in this one, and it's been a long time coming. Years to get to this point.
I say Thursday afternoon.
Yeah.
There's no way that they have a mountain of evidence to go through, and I just don't see it happening quickly at all.
Yeah.
I don't.
Yeah. Jules, once again.
Good night, everybody. Love you guys. When I get home, I'm going to rewatch. So it was at the point when Greg said, "Well, wait a minute." So that's where I have to check that out.
Yeah, it's gonna be right behind. It's actually, if you go back and watch the part after you called, we played it right as you called, so we replayed it. You can just go back to your call, and that'll have it. And I just have to tell you, there was I think you pocket dialed us on a break earlier. We got about 3 or 4 seconds of you saying something about Mr. Whitney knew what he was doing. We hung up because I didn't want to listen into any conversations. So I just want to give you a heads up.
No, are you kidding me?
It was, I think we got 3 or 4 seconds of something about Mr. Whitney knew what he was doing or something. And then I said, I don't think Jules, I said, hello, Jules, are you there? And then we hung up because I didn't want to have an accidental conversation captured. So.
Oh, thank you so much. My phone was bouncing around in my bed. Oh, my. Thank you, Scott. I appreciate that.
Not a problem.
not
We appreciate
meant
you.
to be.
So.
Okay. Everybody, love you guys. I might not. I have to wait and see how long I get home, for me to get home, if I'm going to go live or not. Thank you all.
Thank you, Jules.
Have a great night.
We'll talk to you tomorrow.
Talk to you tomorrow. Yep.
Right.
Yes, sir.
Bye.
Bye-bye.
All right. We have this has been all the fireworks that we wanted today. We got today. We've had several days in this trial where we thought it was going to be juicy. We thought it was going to be something big, and it turned into a little whiff. Today, we knew it was going to be big, and it was. And it was actually even more so than we thought, with the roller coaster back and forth as the pendulum swung back and forth with the decisions. It just amazing. We are finally to closing arguments, and they're going to happen tomorrow. So this is going to be really big. There are also some decisions the judge has on his table that he needs to decide first thing in the morning. That might be sanctions. It might be DV. I guess it could probably come later. You might have a judgment notwithstanding a verdict. I think of it a J-NOV, I forget what they call them. A judgment notwithstanding the verdict means the jury comes back in a verdict and then there's a ruling. So it's possible they could come as late as that on a directed verdict, or it wouldn't be directed by that time because it went to the jury. It would be a judgment notwithstanding. Anyway, so lots of things can still happen. There are still fireworks to go down in this case. And of course, the verdict itself is up in the air. We don't know. We think we have an indication from the questions. We think we know what the jury might be thinking, but we don't know. We don't know where this will fall. And all 6 have to agree to have a verdict on this. No Rob tonight. We do not have Rob. I will tell you, there are a lot of there are a lot of great legal minds in LawTube. Okay, I'm LawTube adjacent. That's what I consider myself, LawTube adjacent. I'm not a lawyer. There are some great legal minds out there. Some of them I don't always agree with. I took the opposite position on Rob on whether or not this juror was going to be dismissed. Turns out he was right. And some of them I do. Some of them cover things differently than I do, and I think that's great. I think there are different people out there. I'm going to send you over for Kurt from Uncivil Law. He has a live stream tonight where he's going to do a recap about this. I know Melanie Little is also doing a recap tonight about this. So there's a lot of places you can go to get different takes and different styles of covering. They're not me. I'm not them. I'm glad we have variety. So if you want more of this, if you want to rehash some of this and hear it from a legal perspective, from a lawyer who can really spell things out for us on what it means, then you've got some options tonight where to go. We're going to pass people over to Kurt at Uncivil Law and say thank you, Kurt, for following this. We were in contact over the weekend. He also helped out with Ian on the charity stream over the weekend. Kurt helped out there, so thank you, Kurt, for that as well. So we're going to pass you over there. I think his live stream starts in 1 hour and 20 minutes. So we're going to pass you over there. If you could be so kind as just to hit the like button for him and maybe click the notify button so you'll be notified when he goes live, that would be great. I think he might still be live doing a direct coverage, but he's got one starting tonight for the recap. So at the end of this show, we're going to go ahead and send you right over there. All right. That being said, I think I have to say a couple things. First of all, I don't know how I could do this. All I know, I will tell you, I know I could not do this without some amazing moderators. We've had today a massive group of people who have come together to watch this together, and being a moderator when you have 6,000-8,000 people in chat is a daunting task, and they are incredible at it. They are so good. They help make this the fun and friendly environment that we love. That's why we like to come back and watch things together. So I just want to say heartfelt thank you to my mods. Thank you for the amazing work you do. And above and beyond that, they're helping me out with stuff on the back end for documents. They're helping me out as I'm tracking other court cases and doing paperwork. It's a huge undertaking. Only a little bit shows up in chat. But thank you so much to the mods. Thank you to this wonderful community. Thanks for all the new memberships. Thanks for the super chats and everything. That really makes all this possible. So thank you for me and my family. I appreciate that. As always, I would say it wouldn't be the same without you. I appreciate all of this community and what you guys have made possible for us and what we've done together. Tonight, when you go home, please hug the people you love. Smile at someone. Make their day just a little bit better. And please stay safe till we go live again. Tomorrow morning, it will be 8 o'clock again as we're getting started early. But right now, I'm going to pass you over to Uncivil Law, to Kurt, as he's going to do a recap tonight and cover some of this from a lawyer's perspective. Excited about that. So hopefully we'll see some of you guys over there. I think that's it. Is there anything I forgot? Happy birthday if you had a birthday. We sang this morning. I think we're good. All right. Let me get my... that's a tree picture. I'll fix that. Here we go. There we go. Be good to each other, guys. We'll see you tomorrow. Have a good one. Bye.